যদি আপনি ম্যাটার বলছেন সেটা ছাড়া অন্য কেউ দেয় তাহলে সাইড করে দেবেন, স্লিপটা ওটা দেবেন না লিস্টে। Application.
My lord, my lord, I have urgent matter.
Like no further applications.
My lord, I have urgent matter, my lord.
Kindly you are mentioning
No further application, please.
a group one appeal. Rashid, I'm mentioning for to let it come as to be mentioned because in the connected appeal that was already disposed of in the presence of all the parties. Rashid, this somehow this appeal by the state has been left out. The appeal by WPID.
It will appear as to image.
My lord, I have urgency. My client is 96 years. Recently on Wednesday, his wife died. And in the meantime, taking the advantage, he responded.
Lord, may of the City Civil Courts Act, Schedule 10.
Not right now.
My lord, it's a new application. My
lord, the respondent, our private respondent are encroaching my land, trying to encroach my land.
You don't have an interim order?
No, my
No, then no.
Under compelling circumstance, my lord, I'm mentioning item number 162 from the day's list, my lord. My lord, this matter was heard extensively by the Honorable Single Judge. Interim order was granted in my favor. Subsequent date, it was extended. But subsequently, due to change of determination, the Honorable Single Judge refused to extend the interim order, questioned the maintainability of the writ petition. Now, my lord, since I'm without any interim order, the other non-parties are trying to encroach over my land, saying that this is state's land. This is overzealous attempt on the part of the state to, my lord, to grab my land and hand it over to the MSMET department.
Let it appear as another heading extension. Right, extension and handover.
Extension. Interpretation of this matter.
No obligation.
The state is trying to grab my property, my lord.
No obligation.
Your Lordship, if I may to mention an appeal from an order passed by the learned civil court.
You're mentioning a hearing matter.
Yes, Your Lordship, it's a new appeal, Your Lordship. We just
Then write order 41. Then what is the urgency?
urgency is, Your Lordship. It's an undivided property, Your Lordship. My
Not an
ingress,
urgency. Please wait for
my
some
ingress and egress has been completely.
Wait for some time.
Your
Yes.
Lordship, if I may be permitted.
Yes, Mr. Mundal, quick. What is the urgency?
One mistake in the observation in the order, my lord. They are taking advantage and disturbing.
That's not an urgency. Please mention. No.
Application was rejected and it was to be getting the order of public open the law on 10th of
Handover.
Your Lordship, if I may be permitted.
Yes, ma'am. What? Under what? What application? Under what? Applications we have taken sufficient applications today. Wait for next week.
Your Lordship, if I may be permitted, this is.
What is the heading? No, applications we have stopped. You have taken some applications? No further application, please. Yes.
My lord, order 41, my lord, urgency is, my lord, execution of eviction suit is, my lord.
When is it fixed?
My lord, I beg your pardon.
When is the execution case fixed?
My lord,
No, not right.
the month of August only, my lord.
No, not right.
my lord, it was
Please
to
don't
appear.
repeat.
My lord, it was to appear on 13th. It's not appearing. That may be included.
Yes, in a suit for declaration, my lord, for tenancy, my lord. The order had
1 second. It actually 13th appear kar kotha chalo.
My lord.
We'll check up if there was a direction, then only it will appear.
31st, my lord, it was a returnable date.
What?
31st was the returnable date, my lord.
31st of July.
Of July, my lord. I'm deeply
Level.
obliged.
If it was due to appear, then it will appear.
I'm deeply
Otherwise
obliged.
not. Yes.
But in a suit for declaration of tenancy, my lord, the 39(1) and 2 gets admitted. My 39(4) gets dismissed, despite there being, my lord, an assertion in an application file that the tenant is not in possession. Difficulty, my lord, is that the development has stopped, my lord.
No, Mr. Nag, not right.
May I, my lord?
Saying for inclusion of a hearing, my lordship.
Please, no. Yes.
On inclusion, your
Don't.
May I be allowed to mention an application pursuant to the direction.
What is the urgency? No, not right now. Not right now.
Order for the delivery, my lord, concurrent filing, my lord, dealing pregnancy, the first appeal, my lord, third party purchase the property, starting construction of the property.
No, Mr. Ghosh.
Lordship, very urgent order.
Not right now.
Lordship, may I be permitted to mention, Lordship, for inclusion, Lordship, first appeal.
No.
Damage, suit for damage was filed.
For hearing.
My lord, one upgradation, my lord, difficulty is made.
Upgradation we are not for.
My difficulty is this, the lease has been refused to be renewed less than more than a year ago. The factory is closed. Near about 100 families are jobless. My lord. Now the bank is behind me. Everyone is behind me. My lord. I am not in a position to answer these employees.
For some time hearing we can't add.
My lord, this is
I think
running.
right now we can't.
Your lordship, kindly
You
accommodate.
won't be able to reach it. Yes.
My lord, paper book has been filed as per.
Hearing we are not taking, ma'am.
My lord, I am mentioning one Lojma matter.
Lozima, yes.
Lordship, good
Yes.
morning. Lordship, good morning to you. I'm mentioning an application on order 41 for inclusion in the list.
Good morning, but no.
Oh,
Yes.
One urgency is that mandatory order has been passed at the ex parte ad interim.
What sort of mandatory order?
In a suit for defamation, the posts have been asked to be deleted and it will be
Delete
detrimental.
the post for the time being. No.
Already mentioned, my lord, 2 weeks
No,
back,
ma'am,
but
no.
Lordship, I am permitted to be mentioned one matter. It's under to be mentioned. When the order appeal was filed, the interim order decree was not been passed. Subsequently, the decree has been passed, but the EP number has not been allotted by the decree.
Hand over.
My lord, my matter is a second appeal, my lord, where my lords have directed to exchange affidavits and to the matter to go out of list. My lord, we have finished our part of the pleadings, but we have not received anything from their part since.
The appeal was admitted, must have been.
Yes, my lord. That,
After admission, we don't have determination, sir. You have to go to the learned single judge.
my lord,
Go to
that-
the learned single judge, you know.
May your lordship kindly to mention, your lordship, a matrimonial appeal. Your lordship, paper books have been completed. Your lordship granted us, your lordship, the
There are so
liberty
many
to.
appeals we can't reach.
Let it be included, your lordship, then we'll.
No, no, no. Yes.
it relates to group 2 appeal. Urgent matter of the division bench presided over Justice Man. My lord, only leave my lord to file without certificate.
Yes, leave is granted.
First appeal.
You heard us. Yes. Call on the list. Accordingly, WPLRT 31 of 2026 is dismissed on contest, thereby affirming the impugned order. No order is to cause urgent certificate copies.
My lord, I am for the, my lord, applicant husband. My lord, the last occasion, my lord, your lordship was pleased to pass an order to take the, during this summer vacation, my lord, initially, my lord, the brief fact of the case is, my lord, that the child, my lord, the wife left the matrimonial home with
An
the,
arrangement was made. What is now your what is your problem now?
my lord, the child has been retained by mother, and my lord, that child has not been returned. No prior intimation was
Keeping it day after tomorrow. If not, your client will go to jail.
After that, my lord, the child had contacted with the mother. And the
Please
child
return the child during the course of today.
because my lord kindly considers my lord.
Very well. By recess, we'll keep it after at 2 p.m. and your client will go to jail if you don't.
Because the child, my lord, is desirous.
It is complained that in stark contravention of our direction dated July 20, 2026, comma, taking undue advantage of the same, comma, the respondent mother has retained the child in the name of visitation. First of next para, the respondent is directed to return the child to the custody of the appellant
The
father
child, my lord.
during the course of the day. Full stop. The matter be listed tomorrow under the heading to be mentioned.
The
Full
child,
stop.
my
It is
lord.
made clear that in the event the above direction is not complied with, serious consequences may follow for the respondent.
My lord, father is Guwahati, my lord, through grandmother, my lord.
First written the child.
My lord, through
Because the
grand,
child is desired as my lord to.
Very well. Very.
my lord,
If you don't, then you'll go to jail.
my lord,
I will.
How dare you? How
Because-
dare you?
No, I will.
Taking advantage of our order of visitation, you have taken the child not returning.
Before that,
The child has to be back by tomorrow, sir. Otherwise, your client will go to jail. Please don't argue. There is no question of argument in this. And we'll stop visitation altogether. Please remind us on the next day.
Yes.
It will appear tomorrow.
my lord, as father is Guwahati, my lord, through grandmother.
Don't overdo it.
Yes.
Next.
মেনশন হয়ে গেছে
Please give your appearance, sir.
My lord, before,
Yes.
my lord, under compelling circumstances, my lord, before my lord takes up item number 3, may I mention a matter from the list and determine?
No, not now. This is not the mentioning. Mentioning is over. Yes.
date of the place the as per
Venue.
the venue the daughter is permanently living in
Have you agreed on a venue?
there is no but the nearest venue 3 venues
My lord,
But,
nearest venue, one is Mowgli Play Zone, Badulpur, and another is Which Kids?
but
What kid?
Which Kids?
Which kids?
Which Kids?
but
Play Zone, my lord.
Acropolis Mall or the Highland Park Mall or
Have you got a coin in your pocket? We'll just have a toss and decide. If you can't agree to a venue, what is this?
My lord, they are too far from.
Because they are suggesting two venues, we have to suggest two other venues.
no but that
No, agree to one of them.
they are agree this is impossible but about several 498 case
Give us the phone names
Yes,
in writing. What was the first one?
Mowgli Play Zone, Badulpur, Poddopukur, pin code 145.
Write on a piece of paper that name. We'll direct there. In our order dated July 28, 2026, we had proposed an arrangement for the visitation of the minor daughter of the parties. Which of next para? Only for the purpose of permitting the parties to arrive at a consensus regarding the venue of such visitation, we had kept the matter today. Which of, however, at the time of call, learned counsel submit that there has been no agreement between the parties on the venue. Which of next para? Accordingly, as suggested by the respondent, respondent mother, we direct the child, we direct the parties to comply with the directions as contained in paragraph number 27 of the order dated July 28, 2026, with the modification that the place of visitation shall be Mowgli Play Zone, Mowgli, MOWGLI, Mowgli or cartoon cat, Mowgli Play Zone at Baduypur, Padmapukur, Kolkata 700143.
145.
145. Full stop. The aforesaid arrangement shall continue until further orders. Full stop. This is can 1. Can 2 was the second.
Judgmental একটা কি ছিল? Can 2 হবে? Can 2
মনে হয় section
section 5 ছিল। 2 তে dispose of হয়ে গেছে।
Appropriate order is that application for visitation.
can 1 but can 2 is a section.
Can 1 of 2026 is disposed of in the light of the above observations, no orders to cost. In view of the appearance of the respondent through counsel, service of notice of the appeal on the respondent is dispensed with. The trial court record shall be brought by special messenger. Should we direct the trial court records or you prepare inform? This is section 26.
Liberty may be given to the petitioner to file an application as and when necessary regarding.
No, that will give, but the main suit is still pending.
Main suit is
very well. The applicant shall prepare and file the requisite number of informal paper books without comparing with the records by incorporating all necessary documents within 6 weeks from date, full stop, for the present comma, the necessity of calling the trial court records is dispensed with. Full stop, next para. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Full stop. In the event there is any difficulty regarding visitation, comma, the parties will be at liberty to file a further application in that regard. Next. এটা রেখে দিন, রেখে কাগজটা ওখানে স্টেপল করে রেখে দেবে না, কাগজটা স্টেপল করে রেখে দেবে, ফাইলে থাকবে দীপঙ্কর, কাগজটা স্টেপল করে। ইয়েস, নেক্সট। Yes, you are for the petitioner.
For the state. I will go to that.
No, it's fine.
No, it's all right.
No difficult. So state should be on our right now. Previously it was the left.
The respondent here.
My lord, as of now, I am in custody for 9 years.
9 years.
498A, 3 and 4B, the prayer for bail was earlier rejected. And there are two accused persons, the petitioner and petitioner's mother. Mother had been granted bail by the Honorable Division Bench, but the appellant's prayer for bail was rejected. He is in custody for about 9 years.
Mr. Bosu, has the previous rejection order been annexed?
Yes, page 16 and page 19.
Rejected twice?
Yes.
Right.
হ্যাঁ,
একবার 19 একবার 22।
yes, what do you say? 9 years in custody. It was last rejected in 2022. We are in, 2026 now. 4 years have lapsed. The paper books are ready, and otherwise the appeal is ready.
Paper books are ready.
But we are not the regular bench. You cannot direct the appeal to be listed. Only in view of the number of years he's behind the bars. And the trial is over now, he cannot influence the witnesses or the evidence. There is no scope of that.
My lord, subject to my learned senior friend's kind correction, if lordship does not wish to enter into merits, my lord, purely on the period of detention.
Yes,
lord,
the gravity,
I can only...
is, obviously the gravity is high.
Yes.
Obviously the nature of the offense is high, but we feel that 9 years is sufficient reason for the petitioner to get the benefit of suspension of sentence. Only on the 9-year ground. And we'll record that on 2 previous occasions it was done, but still the appeal is pending. It's our fault. Neither your fault nor their fault.
Kindly for the record, my lord, kindly records my objection also.
Oh, yes, we have to. Thank you. Okay. The petitioner is behind the bar for about 9 years now. Full stop, next para. Learned senior counsel appearing for the petitioner submits that the mother of the petitioner, comma, who was also one of the accused persons, comma, the mother was also convicted, was also one of the convicted persons, comma, has been released on bail, whereas the application for bail of the petitioner was rejected on 2 previous occasions. Full stop, next para. Learned counsel appearing for the state seriously opposes the prayer for bail / suspension of sentence on the ground of the gravity of the offense. Full stop. While fully appreciating the gravity of the offense, comma, the court is of the opinion that since the last rejection of a similar prayer of the petitioner on February 21, 2022, comma, more than 4 years have elapsed, comma, without the appeal being heard. Full stop, next para. Moreover, comma, since the trial is already over, comma, there is no scope of the appellant / petitioner influencing the witnesses or tampering with the evidence in any manner. Full stop. In view of the long period of custody, comma, we are of the opinion that the demands of personal liberty requires that the appellant stroke petitioner be granted the relief sought for. Full stop. Accordingly, CRAN 3 of 2026 is allowed, comma, thereby granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 10,000 with two sureties of like amount each, one of whom must be local, to the satisfaction of
CGM Krishnanagar Nodia.
learned CJM Krishnanagar Nodia. Full stop. Next para. The appellant stroke petitioner shall make himself available as and when required by this court in connection with the appeal. Full stop. The appellant shall not leave the territorial jurisdiction of the police station of his residence during the pendency of the appeal.
Great, Pradhan.
Thank you. The threat of the books was sufficient. The number of books.
No, this is Kashmir Singh's judgment that if the appeal is pending for more than 3 years.
Yes, yes, those judgments. We appreciate that. Yes.
Madam, item 6, I am appearing.
Madam, is appearing online.
Yes, Mr. Singh is there.
Madam, in this case.
Yes, Mr. Singh.
Madam, in this case, the division bench was pleased to grant bail to the appellant on 21st of November 2025. That is at page 9. Madam, there was a condition that he shall not leave the jurisdiction of the municipal limits of Kolkata. Now,
Yes.
Madam, his parents reside in Barasat, my lord, and both are octogenarian and suffering from several ailments. But only my prayer is, humble prayer is to allow him to reside in Barasat, my lord, nothing else. There is another condition that he will meet once in a fortnight the IC of the Badabajar PS, which I will continue to do, but allow me to reside with my parents who there is nobody to look after. That is the only prayer. They reside in Barasat, both my parents, they are more than 80 years old.
In Barasat, what is the police station? Barasat police station.
Barasat police station, within the jurisdiction of Barasat.
Barasat has an IC or OC, Mr.
IC. It has IC.
Yes, what do you say?
My lord, it is not Barasat, it is Barakpur, my lord.
No, sir. It has been wrongly.
There are 5, my lord. Is there?
My lord, it is wrongly written, my lord. I am sorry that I should have pointed out to that.
Because the criminal court is in Barakpur, there may be this.
No, my lord. This is a typographical mistake. We should have.
Para 5.
My lord, page 5, my
My
lord.
lord, it is a fact that we have written wrongly. It should be Barasat, my lord. The address is Barasat. That has wrongly written.
Mr. Singh, what is this currently campaigning at 13A or camping?
No, that there was a condition that he will not leave the jurisdiction of Badabajar PS, so he took a rented accommodation there.
Have you stated anywhere that you reside at Barasat? Because that
No,
wrong.
my parents reside. My lord, kindly come to page 22, the affidavit.
Page 22.
Yes, my lord, that is the affidavit where I have given the address of my parents.
Yes,
My lord, that is while entering into the agreement.
very well. Yes, your permission.
My lord, my lord, only thing is that no medical documents have been annexed, my lord.
My lord, my junior is there, my lord. He will be maybe.
No, but if it's not annexed, the state does not have an opportunity to.
My lord, they are 80 years old, my lord. What is, I'm myself 57.
You have stated that. Let us see that only.
My lord, we have stated that. My lord,
Yes,
that is in paragraph.
more than 80 years. More than 80 years, no ailment is required.
My lord.
Well, Mr. Singh. Thank you. We'll record your opposition.
My lord.
The present application has been filed for relaxation of two conditions of bail as granted on November 21, 2025. First, comma, in the said order, comma, bail was granted on condition that the petitioner shall not leave the territorial municipal limits of Kolkata without the leave of the inspector in charge, stroke officer in charge, comma, Barabazar police station. And secondly, that the applicant
No, shall meet the
Yes, shall meet the inspector in charge, stroke officer in charge of the Bada Bazar police station once in a fortnight till disposal of the appeal. Full stop. Learned senior counsel appealing for the petitioner submits that since the petitioner's parents are both octogenarians and reside within the territorial limits of Barasat, comma, the condition of bail may be modified to the extent that the petitioner be permitted to reside within the uh, territorial jurisdiction of the Barasat police station and report to the inspector in charge of the said police station. Full stop. Next para. Learned counsel for the state opposes the prayer and submits that in paragraph number 5 of the application, comma, the place where the petitioner wants to reside has been mentioned as Barakpur. Full stop. Next para. At this, comma, learned senior counsel appealing for the petitioner submits that the same is the result of a bona fide error, whereas the prayer of the petitioner is to reside at Barasat. Full stop. In support of such submission, comma, learned senior counsel draws the attention of the court to a copy of a leave and license agreement annexed at page 22 of the application, from which it appears that the parents of the petitioner reside at Barasat. Full stop. Next para. Taking into consideration the aforesaid circumstances and the fact that the octogenarian parents of the petitioner require his attention, comma, CRAN 5 of 2026 is allowed, comma, by modifying the order dated November 21, 2025 to the limited extent that instead of the Barabazar police station, comma, the appellant stroke petitioner shall now report every fortnight to the inspector in charge of the Barasat police station and shall not leave the territorial jurisdiction of the Barasat police station during the pendency of the appeal. Full stop. Next para. The appeal is otherwise ready for hearing.
Well, it was appearing in the list. It is ready for hearing. Well.
Very. We are not passing any direction because we are not the End it. Thank you.
I'm so grateful.
Thank you, Mr.
Number 7.
But in this matter, I am appearing on behalf of the petitioners, my lord. I am praying for not this week.
No.
The advocate on record is absent today for his illness, my lord.
What?
For his illness.
No. These matters we are refusing matters at the in the morning. We are refusing matter. You move the matter.
Today is fixed for filing a supplementary affidavit.
So no. We are not granting time. He had to make alternative arrangements then. No. Restoration application.
Yes, my lord.
Restoration, you are not appearing. You are there. You move the matter.
I have no petition, my lord.
An adjournment is sought on the ground of illness of the learned advocate for the petitioner. Push up next para. Let the matter go out of the list. Next.
And this is my application.
Yes, Mr.
Suit for
application উপরে থাকবে অ্যাপ্লিকেশনটা উপরে দেবে অ্যাপ্লিকেশন তো শুনছি আমরা বলা অ্যাপ্লিকেশন ওকে খুঁজে নেবো we are supposed to search it out. Sorry, Mr. Expeditious disposal.
মানে suit for eviction on the under the Transfer of Property Act.
Plaintiff.
I'm the plaintiff. Transfer of Property Act. The suit has been decreed. My client is of 83 years
Need
old.
not say so much. Need not say so much.
Doctor advised her not to move. Since it is only on the ground of under the Transfer of Property Act, value.
Why was it dismissed?
Suit was allowed. Suit was decreed.
Oh, their appeal?
Yes, their appeal. The tenants appeal.
They are enjoying stay?
Yes.
So what is the occupation charge?
It was 18,000. Initially, the rental value was 18,000. These honorable court enhanced it to 35,000. They are paying.
So then, what is the urgency?
My client is of 83 years old. Only on the ground of under the Transfer of Property Act.
In view of the appellant being 83 years old, comma, can 4 of 2026 is allowed, comma, thereby directing the appeal to be listed for hearing in the monthly list of September 2026. Thanks.
My lord, I appear for the defendant respondent, my lord. My lord, the copy of the stay application along with the memorandum has been served upon us with your lordship's order, my lord.
My lords have been pleased to admit the appeal, give directions for expediting the appeal, and grant an order of status quo, and with leave to them to use the affidavits. That was in item 10, which is my appeal.
Yes.
9 is my learned friend's appeal. From the same.
What is the impugned judgment, Mr. Thakur?
My lord, this was relating to the lease of that Nalban boating complex area. That lease had a clause that if the fisheries department, if the state revokes the license given to the fisheries department, then my lease would stand ipso facto terminated. During the pendency of, I initially filed a suit for declaration that clause was void. During the pendency of the suit, the site was repossessed. The demised property was repossessed. I amended. I sought delivery up and cancellation of those documents of repossession and mandatory injunction directing me to be reinstated in the property, and damages for the wrongful dispossession which was there. Damages was allowed to the extent of 10 crores, but I was not put back in possession. So my learned friend's appeal is from the order, from the decree directing damages of 10 crores. My appeal is from that part of the decree which does not give me the relief of repossession.
The application you've asked for status quo,
Status quo, yes, that is what your lordship has been pleased to know. I had sought a greater relief of receiver be appointed, etc. But your lordship, at that stage, kept it to.
The appeal is otherwise ready for hearing, no?
No, madam, the papers haven't come. Madam. We put in the requisitions. Madam, where's the requisition?
All put in within the next
All put in. On the very next day, we put in the requisitions.
Yes, what do you say?
Well, SFD, well, I do not know whether SFDCL is a party in item number 10 or not. My client have received the copy of item number 9, my lord, which is FAT 148 of 2021.
9 is their appeal.
Yes, well, everything is.
My appeal
No,
has
9 is your appeal.
9 is my learned friend's appeal.
You have received their copy.
Yeah, I have received their copy. I do not even know whether we have also filed the appeal or not. Well, there has been a change of management from West Bengal Fisheries Development Corporation to SFDCL, and after the change of government, the managing director has also been changed.
Then you have to file a proper application
Lordship.
pleading yourself. That is a
No. My lord, the managing director is a party and SFDCL is there. My lord, I need a fortnight's time to come back with instruction. What is there, my lord? I do not know what is.
So whatever is there, we are continuing the status quo.
Yes, my lord. I'm not opposing to that.
Disposing of this
Yes, my
application,
lord.
your
Yes.
paper
Let
books you have
the
already
paper
direct-
books. Yes, let the paper books be filed, my lord. I'll come back with instruction.
So you're not appearing in 9.
9
is the state's appeal.
Yes, Your Lordship, but there is a problem that 2 sets of advocate has been engaged.
Ms. Roshidi, you are for the state.
I am only for the State Fisheries Development Corporation Limited.
Who is-
My lord, State of West Bengal is a separate. They have their own advocates, your
Your
lordship.
fisheries corporation is not a state entity.
It's not
a state
totally aided, my lord. It's an undertaking. They have their own separate advocates, your lordship.
So disposing of it.
That order was there in paragraph 13. That order may be made absolute, my lord. Till disposal of can 1 it can be till disposal. Paragraph 13 of my lords, this honorable bench's order dated 24th June. आप है party number 1 मेरा appeal. নিয়ে আছে জজসাহেবের কাছে আছে ফাইলে
The appeal arises from a suit filed by the appellant in FA 182 of 2024 for declaration, initially for declaration that a clause whereby whereby upon the expiry of the lease of the superior landlord, the appellant's lease would expire, and for consequential reliefs. Subsequently, the suit was the plaint was amended in view of the appellant having been dispossessed, seeking consequential reliefs. Next para, by the impugned judgment, the learned trial judge granted damages to the tune of rupees 10 crores in favor of the appellant in FA 182 of 2024. However, mandatory injunction as sought appellant in FA 182 of 2024 has assailed the refusal of mandatory injunction. Next para, in view of the arguable questions raised in the appeal, we direct all the parties in both the appeals to maintain status quo with regard to the subject property till disposal of the appeals. The appeals shall be heard analogously. No address to cause urgency.
But I said 10 crores, it's not 10 crores, it's 8.8 crores. 8.8 crores odd, your lordship.
10 crore, যেখানে বলছি, about 8.8 crore.
Yes, please. Great.
দু জায়গা বোধহয় আছে, 2-3 জায়গা. About 8.8 crore. 10 টা শুধু এটা হয়ে
And for the appellant, may I pray for 5 minutes Passover? Lord, the affidavit of service is being affirmed. Lord.
What is the service? It has been effected?
Effected. I've checked up.
We'll give you leave, we move the map.
Lord, Section 5 application, my Lord, direct.
You know that it has been effected?
I've checked up.
You rely on her? Yes.
Lord, sir. Oh, let's come.
Oh, it has come also. Then you rely on the affidavit itself. How many respondents?
Many.
This is a partition suit?
Partition suit. Against preliminary degree of partition, my Lord.
You're lucky that no, you're not lucky. So many. So all have been served.
Served.
So what is the
12
delay?
days delay.
Huh?
12 days.
What is the reason?
My Lord, your lordship would kind enough to come to my Lord from page 3 to
Layman and rustic villager.
That is one of the ground. My Lord, the law clerk, my Lord, who was my Lord taking care of the matter in the trial court, he informed about the passing of the decree, my Lord, at a much later stage.
Affidavit of service filed today be kept on record. Despite service, none appears for the respondents. Next para, the delay in preferring the appeal is only of about 12 days. The appellant has explained the delay by pleading that the appellant is a rustic villager having and a layman in law, and as such was not aware of the limitation period in preferring an appeal. Moreover, there was some delay in the clerk of the learned advocate for the appellant in the trial court informing about the disposal of the suit to the appellant. Upon a perusal of such averments, the court is satisfied that sufficient explanation for the delay has been furnished. Accordingly, can 2 of 2025 is allowed, thereby condoning the delay in preferring FAT 403 of 2024. No other application?
No.
The paperwork directions
already given.
Given at the section?
My Lord, that was a mistake. My Lord, the report has been given by the stamp reporter later.
So the directions are
okay.
বললাম যে ক্যান ডিসপোজ অফ করে বলুন তাহলে ক্যান ওয়ান অফ দেখে নিলাম তাকে বলে দিই ক্যান ওয়ান যদি না বলে থেকে ক্যান ওয়ান ইজ অ্যাকর্ডিং ডিসপোজ. Yes, you for the other side?
Yes. I'm for the appellant, but the application will not filed by my learned friend.
Yes. What is your appeal?
There is a suit filed by the appellant for cancellation of gift deed that was executed by the mother to the the daughter. There are the injunction.
Is the mother? The mother has filed the suit.
No, my lord, she is the my lord.
Other
Other
child.
my lord, son and my
You
lord.
are appealing for the mother or the
Mother, my lord. Mother died, my lord, after executing the gift deed, my lord.
Good. Yes.
Thereafter, my lord, you file a suit for, my lord, cancellation of deed, my lord, injunction, my lord, preferred, injunction rejected. Against this order, my lord, file this. Your lordship granted injunction.
Yes.
After injunction granted, my lord, I file one application. Only, my lord, with the prayer can do that my ingress not to be disturbed. If it is, if I lose the case, in that case, my lord, I admitted fact that I am the co-sharer in respect of the property. But in the one paragraph, my lord, I stated in
what
the
injunction did you pass, Mr. Chattopadhyay, originally?
Your lordship passed.
What injunction?
Not to transfer alienate.
That's why, my lord, there was an agreement, my lord, entered into with the defendant number 3, who is the promoter.
So we directed restrain them from creating third party interest.
Yes, my lord.
Yes, my lord.
No other injunction.
But I am not to disturb our position. I am the, my lord, daughter-in-law, and I am residing with my son.
Mr. Mukherjee, is there any difficulty if you direct restrain both parties from disturbing each other's?
Yes, my lord, do that.
We'll do
Yes,
that.
my lord. So, my lord, I am not allowed to, my lord, enter into the premises.
We'll restrain both of you from preventing the ingress and egress of each other.
Yes, but I have no problem on that. But I am not allowed to enter into this property.
That's
why,
their
Lord,
allegation,
made
but I have
but
denied.
Obviously,
That's
that's
why,
why you
Lord,
are passing this order.
That thereafter, my lord, I made an application, Lord, that I in the first floor my mother was there. I
was not there in the first.
Lord, he is the ground floor.
My lord, I am dispute.
I was not there in the first. You said my lord was there.
The respondent, my lord. In the first floor. Thereafter, my application made will allow me to ingress egress to look after my
Why are you
portion.
repeating the entire thing? We have already said that we'll pass order in your favor.
But I am not allowing. The problem is that today.
What are you saying? We are saying we'll allow your prayer. Don't you understand basics?
Thereafter, supplementary affidavit, my lord, your lordship.
For what?
Supplementary affidavit, my lord, to stated that I am in position in the first floor.
Did we permit you? Keep it with you wherever you are in person. Ingress and egress to the premises.
Yes,
scheduled property. That is your prayer.
Yes.
The present appeal arises out of the dismissal of a suit filed by the appellant. Dismissal of an injunction. Dismissal of an injunction application.
Yes.
Right? Dismissal of an
Temporary
injunction application filed at the behest of the appellants in a suit filed by the appellants, primarily seeking cancellation of a gift deed executed by the mother of the parties in favor of the respondents. Whose of next para, the present application has been filed by the respondents seeking an injunction restraining the plaintiff stroke appellant from creating any obstruction towards the free ingress and egress of the defendant stroke respondent number 1 to the suit property. Whose of next para, since the parties are apparently in joint possession of the property, can 2 of 2025 is disposed of by restraining both parties from preventing the ingress and egress of each other to the suit property during pendency of the appeal. No arrest to cause urgency.
Regarding the transfer alienation, since your lordship is disposing of the appeal itself now.
Appeal? No, application.
Your lordship.
Appeal.
I thought since grateful.
By passing this order, your lordship
we can dispose of the appeal.
That's why, my lord, nothing remains.
As early as possible, my lord.
Injunctions will remain.
Yes, my lord.
Yes.
Disposal of the suit.
Disposal of the suit, my lord. My ingress, egress not to be disturbed.
Fantastic. We are so happy. At this juncture, যা ছিল সেটা থাকবে যেটা বললাম urgent certificate copy দিও না তুমি at this juncture learned counsel for the parties submit jointly on instruction that in the event the injunction orders passed in connection with the appeal be maintained till disposal of the suit the appeal itself may be disposed of. Full accordingly FMAT 134 of 2025 is দাও একবার ফাইলটা দিন মেমোটা লাগবে is disposed of by setting aside the impugned order, bearing order number 15 dated March 18, 2025 passed by the learned judge, 10th bench, City Civil Court at Calcutta, in title suit number 2026 of 2022, comma, restraining both parties from selling, transferring, alienating, and or creating any third-party interest in respect of the suit property, and stroke or preventing the ingress and egress of each other in respect of the suit property till disposal of the aforesaid suit. Full stop. Next para, it is made clear that the merits of the respective contentions of the parties in the suit has not been entered into, and it will be open to the learned trial judge to dispose of the suit independently on its own merits without being influenced unnecessarily by any of the orders, any of the observations made herein or in the impugned order. No orders to cause. Grateful. Thank you.
Ultimately, my lord, 1 or 2 years after this order release of that.
Exactly. You're absolutely right. Yeah.
Well, 13, my lord, there is some deficiency on my part.
What if
I have sent for, my lord, affirming the affidavit of service.
It's not prepared.
It hasn't prepared. I have sent for affirming the same.
No, service has been effected.
My lord, yes.
Are you sure?
Not sure, but my lord,
sure.
Because it has not been said. Because it
Then we'll take it up later. We're passing it over. Let it come. Whenever it comes, mention.
Yes.
Pass over.
Yes. Because now at 11 it reopens. It will take half an hour, my lord.
Whenever it comes, you just
Yes,
mention.
Yes. I am grateful. হ্যাঁ আপনাকে বলি
14. Expeditious hearing.
No, my lord, this is for expeditious hearing, but seeing the impugned order, my lord's desire was you serve the application, it will be hard at the application stage. That was my lord's desire. My lord, regarding service 1, 2, 4, and 5 has been, my lord, it says it has been dispatched. Respondent number 6 says insufficient service. Only, my lord, respondent number 5 has been served.
We have to serve again. Is there anybody appearing in the trial court?
My lord, the suit has been dismissed on the preliminary ground of maintainability. I do
Without
not...
their appearance?
No, they have appeared.
Serve on the learned advocate in the trial. From the affidavit of service, it transpires that service has not been completed on the respondents. Full stop. Accordingly, the appellants are directed to serve copies of the memorandum of appeal as well as scan 1 of 2025 on the learned advocate appearing for the respondents in the trial court, advocate within bracket S, appearing for the respondents in the trial court, and file an affidavit of service to that effect on the returnable date. Serve copies of the memorandum and can 1 along with a server copy of this order. File an affidavit of service on the returnable date. Full stop. Next para. It is made clear that such service shall be deemed to be service of the application as well as notice of the appeal. Full stop. The appeal and the appeal shall be taken up along with the application on the returnable. Great. Application heading as well. Acha, the matter shall next be along with the application on August 24, 2026. 24th.
Great.
My lord, I am appearing on behalf of the respondent, my lord.
I appear for the appellants, my lord.
My problem is,
what is
today I got the list. I could not prepare. 1 week time I am praying, my lord.
I have no problem. I am enjoying an interim order passed by your lordship.
1 week time.
What is the...
My lord, this is the matter where regarding, my lord, I had filed a suit for declaration and permanent injunction regarding, my lord, the trust, Shahu Samaj Trust. There were 2 trusts, one of 1981, Shahu Samaj Trust, West Bengal, and one of 2018, Shahu Samaj Trust. On 3 principal grounds, my lord, lordship was inclined to stay the operation of the impugned order. By the impugned order, my lord, an application filed by the defendant number 2 in my suit, my lord, was allowed. And my lord, there was no counterclaim in the written statement. That was one ground that the application was outside the purview. This under challenge at the instance of the defendant number 2 was to call for a meeting where certain agendas were to be discussed. Now, there was no illegality per se shown in the application why the, my lord, meeting cannot be held. Yet the learned trial court, my lord, had passed an interim order in favor of the defendant number 2.
Please come prepared with the appeal. This will be the argument in the appeal. You are keeping it next week.
paper book, my lord, appeal will be hard.
I can, my lord, prepare informal paper books if
If you
lordship.
don't want it to be hard, no difficulty, I will continue
No.
this stay.
1 week time I am only praying.
On the prayer of the respondent, the matter is adjourned till August 10, 2026. Yes. The relief you have granted, that is the relief you want in the suit.
In all practical purpose, that is the relief.
If your friend does not want the appeal to be decided along the application, we are very happy, you are very happy.
Yes.
Only your client will be unhappy.
Next day.
Next.
Grateful, man.
None appears for the parties at the time of call. Let the matter go out of the list. Yes, Mr. Alex. Mr. Banerjee appearing for the first time? Oh, second time.
I am appearing for the first time.
Very well. What is the matter, Mr. Banerjee?
Lord, for mandatory injunction that they have violated the order of injunction of your lordship and raised a boundary wall up to certain height.
What was the injunction passed by us?
Therefore, certainly, my lord, when he appeared, he is required to file an affidavit on this. I cannot, my lord, because he is entitled under the law, provided he is agreeable.
No, if
to
he
file
doesn't want to,
affidavit.
then we'll proceed on the allegations made here.
That's right. That is why.
I beg to appear on behalf
So
of the-
non-traverse, you have written position.
No, kindly does not. Lordship, I beg to appear on behalf of respondent number 1 and 5 in this matter, Lordship. There was a previous order. If my lord kindly takes up annexure B of my learned senior friend's application, that is at page 20. If my lord kindly turns overleaf to page 21. Lordship, paragraph 5.
As per interest, changing nature, character, and making construction. So, but status quo regarding position.
Yes, Lordship, my instructions are that my clients are not raising any constructions after the order was passed.
No, regarding their being dispossessed, that is.
Lordship, their application initially, the appeal, Lordship, is that a suit for partition, they failed to produce the title deed, hence it was dismissed. Lordship has noted at page 21 of Can 4, Lordship, if my lord is taking up Can 4.
Yes, we are there.
That since the appeal at paragraph 5, since the appeal has a limited conspicuous and revolves around, Lordship, the matter may be remanded with a direction on us to maintain status quo as regards the nature and character.
What happens to the violation of our order?
Lordship, my instructions are we have not violated. My learned senior friend, he has relied on certain photographs. If my lord takes up.
Mr. Banerjee, should we dispose of the appeal, remand it, and give you liberty to approach the trial court for this mandatory injunction? You think over it. Although it's our order which has been violated, but you can cite that order and parties can satisfy the
Lord,
court.
exactly, my lord. When the appeal was admitted, I submitted before your lordship that originals were not submitted because there are two
No,
parts.
no,
of
your
that.
friend is
He
conceding
agreed,
to that.
Lord. I am also agreeing to that, my lord.
So
But,
then we're
my lord,
disposing of the appeal, sending it back with liberty to you to file a similar application for mandatory injunction, alleging that they have disposed you. And if such an application is filed,
not
trial
only
court will decide
disposition,
by giving them opportunity to.
but not only disposition, but changing the nature and character of the property.
But
Property
this
in
is not a
suit.
contempt application. That is if it was contempt, we had to take it up.
Yeah.
But this is mandatory injunction.
Mandatory injunction, my lord, that is because raising of the wall, making construction on the property. Of course, my lord, that I can take if your lordship grant liberty to me.
We're doing that. We're doing that, relegating it because it will be wastage of time to keep the matter pending on.
Absolutely right,
The
my lord.
suit-
I
let the
agree
suit
to
proceed
that.
and you.
I agree to that.
Very well.
And the application order 41 rule 27, that is the document.
Those are the title deeds.
That
contains the title
in the
deeds.
appeal.
Very well.
That may be allowed. We may be permitted to adduce evidence on that.
We're doing that.
এই তো পরিষ্কার হয়ে গেল।
Can 1 of 2025, should we record your submission to that effect, to that extent that.
That we are not making any constructions?
No, not that. That will you are denying. Regarding this, the appeal may be disposed of with by permitting them. Fantastic. Yes. Fair
And
enough.
Lord, construction also, nobody will.
No, those will keep open.
Lordship.
The trouble will give the trouble to the trial court, but regarding the easier portion, we'll do it.
Lordship.
As is usually done by the superior court.
Lordship.
So, Can 1 of 2025 is an application for production of additional evidence by way of deeds which are alleged to be title deeds by the appellant. Puts up next para. The appeal arises out of the dismissal of a partition suit filed by the plaintiff stroke appellant on the sole ground that the appellant failed to establish his title by producing appropriate title deeds and other documents. Puts up next para. In view of such documents being sought to be produced before this court, and since the learned trial judge apparently did not give any further opportunity to the appellant to produce such documents, can 1 of 2025 is allowed, thereby granting opportunity to the appellant to furnish the originals of the documents annexed to the said application in the trial court. Full stop next para. Learned counsel for the respondent, on instruction respondents, on instruction and in his usual fairness, submits that his clients have no objection to such documents being furnished, subject to those being appropriately tendered in evidence and opportunity being given to the respondents to take appropriate objections in the trial court. Full stop next para. Insofar as Can 4 of 2026 is concerned, the appellant has alleged therein that in violation of an order of injunction dated January 5, 2026 and February 4, 2026, passed by this court, the respondent number 1 and 5 have pulled down the
No, we have raised.
the respondent number 1 and 5 have raised construction as well as dispossessed the appellant from the suit property. Full stop next para. In view of the intention of the court to dispose of the appeal itself, no useful purpose would be subserved in keeping the interlocutory application pending. Full stop. The ends of justice would, however, be subserved if the appellant is granted liberty to file a similar application with self-same reliefs in the trial court. Full stop. Next para. Accordingly, FA
Self-same relief or mandatory injunction, kindly. Otherwise, they will say the injunction application was filed. Mandatory injunction application.
Self-same prayer যেখানে বললাম for mandatory injunction.
Lordship.
Accordingly, FA 433 of 2023 is 2025 is allowed on contest, thereby setting aside the impugned judgment and decree dated July 7, 2025, passed by the learned civil judge, senior division at Islampur district, Uttar Dinajpur, in partition suit number 61 of 2014, and remanding the suit to the trial court for a fresh adjudication on merits upon giving opportunity to the appellant to produce the documents of title of the appellant, as annex copies of which have been annexed to Can 1 of 2025 filed before us, in evidence. Full stop next para. It is made clear that this court has not entered into the merits of the respective contentions of the parties, and it will be open to the learned trial judge to decide the suit independently in accordance to law and on its own merits. Full stop next para. If the documents in question are tendered by the appellant, needless to say, appropriate opportunity will be given to the defendant stroke respondents to take relevant objections and adduce their independent evidence as well. Full stop next para. Insofar as Can 4 of 2026 is concerned, the same is disposed of with liberty to the appellant to file a similar application with the self-same relief of mandatory injunction on the allegation of violation of the injunction orders passed by this court. First up, if such an application is filed, the learned trial judge shall decide the same on its own merits in accordance with law upon giving adequate opportunity to the respondents to controvert the same and upon hearing the parties. Full stop.
Within certain time, Melody.
No.
Oh yes, my lord. Very well, my lord.
We'll leave it on that.
Your lordship.
Full stop next para.
Lord, all
Any other application is pending? Can
no. Lord, can 1 of 2024, that is order 41/27 be
that has
allowed?
been disposed of?
Yeah, allowed.
The injunction application was disposed of.
They are disposed of. Till the disposal of the appeal.
Very well. Or trial court records have arrived.
That is, I'm submitting, my lord. In the
The
event
trial court records be sent down immediately by special messenger at the cost of the appellant to be deposited within a fortnight from date.
I'm very grateful.
my lord, I am grateful to my learned friend also.
No, he's absolutely fair.
Blood, exactly.
It
That
helps
was my
the
submission.
court and all parties.
All
because
parties.
Other
Yes,
ultimately,
court.
it
Lord,
is
I am grateful
both
to
of
your
your client-
lordship.
No,
Lord,
we
that
are,
is
you
why.
need not be grateful. Be thankful
No,
to
no,
him.
I told him also, my lord. I told him also.
Him and her.
Grateful
She
to
was
him
instructing
also.
Yes, it
Lord, injunction. So far, the injunction is concerned, my lord, not to a status quo that he said. That is status quo, not to
We'll
make
neither
any
say we are vacating,
change in
nor
nature
we'll
and
say we'll
character
keep it
of the
vague.
property.
No, we'll not pass anything. It's already violated, you say. Next.
Lord, yeah, appeal. Yes, my lord. Because please, Lord,
We are neither saying we
Lord,
vacate
in
it.
the suit, my lord, may I? In the suit, my lord, injunction order is already subsisting.
We'll not
Therefore,
comment on
once
that.
the order is set aside, my lord, it has been restored.
Yes.
My lord, I beg to appear in view of the appellant wife, my lord. My lord,
This is happening for the first time.
first time, my lord. I beg to.
You're challenging what?
But degree of divorce, my lord. I am for the wife. And one for stay and another for maintenance, my lord. My husband is a constable. He was appointed as a constable in the Kolkata
Serve
police.
copies and come back.
My lord.
Yes.
And
we'll injunct him from remaining in the meantime.
My lord.
The present appeal has been preferred by the defendant wife in a suit for divorce, comma, assailing a decree of divorce. Full stop. Next para. However, comma, we are not inclined to grant stay of the judgment and decree, comma, since the ramifications of it will be wide, comma, as such a decree is in the nature of a judgment in rem. Full stop. However, comma, the respondent shall remain restrained by an order of injunction from contracting any remarriage, comma, if not already contracted, comma, till disposal of Can 1 of 2026. Full stop. The appellant shall serve copies of Can 1 of 2026 and Can 2 of 2026 on the appellant along with the affidavit of assets of the appellant, comma, which shall be filed on the returnable date, along with an advance copy of the affidavit of assets, shall be filed on the returnable date. Full stop. Affidavits in opposition to the applications, comma, if any, shall be filed by the respondent within 3 weeks from date. Full stop. Such affidavit in opposition shall compositely deal with the 3 weeks, 4 weeks. Compositely deal with the amendments made in Can 2 of 2026 as well as the affidavit of assets of the appellant. Full stop. Along with the opposition, comma, the respondent husband shall also file his own affidavit of assets. Full stop. Next para. Composite reply, if any, shall be filed within a fortnight thereafter. Full stop. The matter shall next be the applications shall next be listed for hearing on September 21, 2026, when an affidavit of service to that effect shall be filed with it.
But I beg to pay for correction of the cost title. My lord, the name of the husband.
প্রথমেই করে দাও তাহলে on the prayer of learned counsel for the appellant, leave is granted to the learned advocate on record for the appellant to rectify the cause title of the memorandum of appeal as well as the application.
Only memorandum of appeal.
Only memorandum.
Only memorandum
of the memorandum of appeal.
About not a lot.
Next.
That's I for the applicant, Lordship. Unfortunately, I misplaced the affidavit service, Lordship. Lordship, 3 respondents are refused to accept the notice, Lordship. One is
Can you find the affidavit? You file serve afresh then.
Yes, Lordship.
Serve again.
Today I got a
Learned counsel for the appellant submits that the affidavit of service has been misplaced from her chamber. Full stop. Accordingly, the appellants are directed to serve copies of the applications afresh on the respondents and file an affidavit of service on the returnable date. Full stop. Let the matter be listed next on in the monthly list of September 2020.
Lordship, kindly fix any date, Lordship.
September 20. Next. Give your appearance, ma'am.
Yes, sir. Item number 20.
Yes.
I am for the respondent.
I am for the petitioner.
Dead person, respondent of 6. That is your ground.
We have raised 3 points in the review petition.
What are those?
Firstly,
The appeal was disposed of by the
yes,
Acha.
dismissed.
Your appeal was dismissed
Yes,
on contest.
on contest.
What are the 3 grounds?
Mainly on the ground of limitation.
Appeal was time barred.
Appeal was not time barred. The suit was time barred because their case.
That was not raised by you in the appeal.
We have not pointed out. It is.
How is it a case for review then?
Review the limitation point, which was considered. We have not placed the case properly.
Is that a ground for review? If you could not place the case properly, it's your problem. That's not a ground for review, sir. Mr. Shah, that's not a ground for review. Sorry.
As if we the case was filed in the year 2019, and their case is that.
Sir, limitation is a mixed question. It has to be gone into. You have to raise it in the appeal.
But the appeal was disposed of that as if that we have admitted the facts of the one registered deed in the year 2004, but we denied in the cross-examination.
No, we recorded that their argument, your argument.
Our argument
that you argued that the deed was void ab initio, therefore question of limitation does not arise. That was your argument.
No, the trial court will not dismiss the suit on the point of limitation, holding 2 of the exhibited document. That is their case. They have filed under section 144, where they have admitted with regard to the knowledge of the deed.
No, and we have denied. We have denied.
Your lordship
in cross-examination. In cross-examination, we have denied.
This is not a ground for review, sir.
This is we have denied.
That my other friend is asking, it is a decree passed in favor of a dead person, not against. Because the respondent number 6, who is the defendant, it is their appeal. They ought to have come up with the substitution application.
We are not aware.
That's right. It's a decree in favor of a dead person, not in against a dead person. Your lordship kindly.
At the time of passing of the
nullity concept comes up in 90 Supreme Court, where a person who have been deprived, had it been a case that he ought to have been substituted, he could have defended.
Have you got a copy of the judgment?
Today I have not brought. I shall come back only on that, because other are not ground of review at all. So far as regards the dead person, I shall try to assist your lordship to citing that judgment. The concept of nullity comes up if the substitution has not been.
Respondent 6 was a defendant in the suit.
Yes.
Because their suit, they did not implead.
It's their suit. They did not implead. It's their appeal.
Then the suit has abated. Then your suit had abated.
During the pendency of the appeal, just disposal of the appeal, she was died.
Your appeal has been dismissed. What is the difficulty if she died?
And the other respondents have been represented by.
We want to place the limitation point. That was not
limitation point was dealt with by the court. You have argued the limitation point.
Yes.
The argument was that because deeds were void ab initio, therefore no limitation. It is not time barred. And we dealt with that.
But the case is, we filed the suit in the year 2009. They made out a case that in the year 2004 we filed a 144 application, which was registered as mixed case. Their case, we knew that of the cause of action, when we got the input registered deed of settlement, our cause of action is Our cause of action is on 7 June 2019, 2009, and we have specifically stated that in paragraph number 16, 15 of the plain, that lastly on 7/6/2009, when the plaintiff went to the suit property to request
Mr.
that
Mukherjee, come prepared with that judgment. We'll take up-
Even my junior just now pointed out, even it is not a case of substitution because her legal heirs are already on record, being the respondent number 4 and 7. So,
It's
even
missing.
that is not also necessary.
It is missing. Your phone is vibrating.
we shall place
Phone
that.
is vibrating probably. Coming in the microphone.
Oh, my phone is not.
Very. What else, Mr. Shah? One is dead person. The other is
Limitation point, and other my point is the Benami transaction, because in the purchase of the
cannot
property,
take a new ground here. Sorry. In review, you cannot take a new ground.
we have taken ground in the appeal.
No, we did not argue that. Did not argue that. Sorry. Yes, Mr. Mukherjee, you answer us on this.
Yes.
That Mr. Shah argues that in his plaint, the cause of action was disclosed to be in 2009.
Yes.
Now,
But the case is that the trial court, on the point of limitation, two of the exhibited document that has been on our behest, the trial court found that in the year 2002 itself, there was a case initiated by them, that is the MP case number 2004, sorry, 1430 of 2004. This exhibited document suggests that he
you
knew
exhibited those documents.
this MP case.
144 you exhibit.
Yes.
They are 144.
They are 144. They admitted the initial impugned deed as well as the deed of rectification.
I have denied in the
and
cross
if
examination. I have
2004
denied.
Denied,
I have
but this is
denied.
documentary evidence. He
have
may have
denied.
denied in the cross examination, but
What
it
have you
is his
denied?
knowledge.
You have denied that you filed that 144.
No, I have denied. My case is I have
We are
not
denying you.
I have not filed any MP case number. In the cross examination, I have denied.
Very.
I am.
We are dealing with your review application right now.
And if 2004 is the knowledge, 2009 suit initiated.
Their
so
case is
found that
knowledge
it is
is
expressly barred by
2004.
limitation.
One is limitation, one is dead person, the third ground is Benami.
Benami. And our fourth point is that
the fourth point also, yes. Mr. Shah, you know the merit of your review application, you're wasting the court's time.
No.
What is your fourth point?
Fourth point is the deed of settlement has not been properly executed because at the page of signing execution there is no sign of the executor.
That Mr. Kormokar argued that your lordship has dealt with also.
Which paragraph?
Your lordship's order, your lordship has dealt with regarding the execution. Your lordship says, this cannot be challenged by the Mr. Kormokar's client. That your lordship has held in the order.
Shah, Mr. Shah.
Mr. Shah was not there. Then Mr. Kormokar.
Oh, then Mr. Kormokar was there.
I was there.
He was.
No, he was there.
He removed Mr. Kormokar because he lost.
Paragraph number 13 of your lordship's judgment.
Yes,
that particular point was not dealt with.
Very. The present application has been filed for review of a judgment dated November 4, 2025. Kushab, Learned Counsel for the review application.
My lord, we want to file a supplementary affidavit regarding our
review. There is no scope of any further awareness.
Regarding the cross examination.
No.
There is no. There is no.
That is not permissible in review. The first ground of challenge, Learned Counsel for the review applicant submits that this court, while passing the judgment under review, erroneously observed that the suit was barred by limitation, whereas in the plaint, the cause of action was claimed to arise in the year 2009, whereas the suit was filed in the same year. Full stop. Secondly, comma, the respondent number 6 died during
Yes,
pendency of the appeal, comma,
প্লেনটা কোথায়?
despite which
প্লেন
the appeal was decided in the name of the said dead person. Full stop. Next para. Thirdly, comma, it is argued that the impugned transaction was vitiated, comma, since it was a Benami transaction which was not taken note of by this court. Full stop. Lastly, comma, it is contended that the deed of settlement was not properly executed, comma, in view of there being no signature of the executrix.
And he says, no witness.
No. At the where the witness has signed, there the executor has not signed.
No signature of the executant at the place where the witness's signature found place. Full stop. Next para. Learned counsel for the respondents opposes the prayer, opposes the review application and contends that the question of limitation was dealt with elaborately. Full stop. The learned trial judge, comma, it is pointed out, comma, had considered an application under section 144 of the Criminal Procedure Code filed by the appellant.
Appellant, my father.
Appellant's father.
Father.
Mr. Mukherjee?
No, my lord. Along with both are the petitioners. This is
Signed
the
by
copy
the-
of the one.
Fined by the
Have
appellant.
used the opposition against their application. This is part.
Fined by the.
Kindly see the applicant number 2 is the, my lord, plaintiff over here.
Appellant.
Shubhra Goswami.
No, appellant is Shubhra or Shubhra?
Shubhra.
Shubhra is a,
yes.
By the appellant, comma, where.
And his father.
The.
Lord, I have marked, Lord, kindly excuse me.
Registered deeds in question, the registered deed of settlement as well as a revocation deed were rectification deed were admitted. Full stop. Next para. Thus, comma,
We have challenged a dispute.
Since the said application was filed in the year 2004, comma, the suit was rightly held to be time barred by the trial court. For the next para, insofar as the demise of respondent 6 is concerned, comma, it is submitted that the heirs of the said respondent,
being the respondent number 4, Prithishang,
being the respondent of 4, comma, was already on record. So moreover, comma, since the judgment under review was passed in favor of the respondents by dismissing the appeal, comma, in any event, comma, the demise of the respondent number 6 does not make a difference. So next para, regarding Benami, comma, it is pointed out that the same was never argued before this court. Full stop. Insofar as the execution of the deed of settlement is concerned, comma, learned counsel points out that in paragraph number 13 of the judgment under review, this court had observed that since the deed was admittedly a registered one, there was no question of any doubt about the execution of the same, since presumption of correctness was attached to it, which was never rebutted by the plaintiff stroke appellant. So next para, learned counsel for the review applicant reiterates in reply that in cross-examination, comma, the appellant had categorically denied having filed any application under section 144 of the Criminal Procedure Code. That is all, Mr. Shah. That is it. Full stop. Next para. Insofar, heard learned counsel for the parties. Full stop. Next para. Insofar as the first point is concerned, comma, since the learned trial judge elaborately dealt with the question of limitation by relying on an exhibited document which was an application under section 144 of the Code of Criminal Procedure filed by the respondent, filed inter alia by the appellant, comma, such documentary evidence prevails over oral evidence which might have been adduced by the appellant in the trial court. Full stop. Next para. Thus, comma, the finding of the learned trial judge did not require any interference to the effect that since that the application under section 144, comma, Criminal Procedure Code having been filed in 2004 and the suit in the year 2009, comma, the same was filed beyond 3 years from the knowledge of the deeds, attributable to the appellant and was palpably time barred. Full stop. Next para, even otherwise, comma, this court had dealt with the issue of limitation as argued by the appellant. Full stop. At the time of arguments, comma, the appellant urged that in view of the deed being void ab initio, comma, the question of limitation does not arise, comma, which was turned down by this court. Full stop. Next para. Thus, comma, fresh arguments on merits cannot be entertained at this stage, even otherwise. Full stop. Next para. Apart from that, comma, the question of limitation was rightly held by the trial court, which was affirmed by this court, and cannot be reopened on law under Order 47 of the Code of Civil Procedure. Full stop. Insofar as the demise of respondent number 6 is concerned, comma, the appellant did not point out the same at the relevant juncture, despite such fact being available at the said point of time. Full stop. More importantly, comma, as rightly contended by the respondents, comma, the demise of one of the respondents, comma, in whose favor ultimately the judgment under review went, cannot make a difference in the outcome of the appeal. Full stop. Next para. Since the appeal of the appellant stroke review applicant was dismissed, comma, the demise of one of the respondents does not affect the rights of the said deceased respondents in any manner whatsoever, comma, which accrued by dint of the impugned decree. Full stop. Next para. Even otherwise, comma, since the heir and legal representative of the respondent number 6 was already on record as respondent number 4, comma, in any event, comma, there was no abatement of the appeal. Full stop. Next para. We also find such argument to be rather peculiar since, comma, if the appellant had not taken out any steps, if substitution was required, comma, it is the appellant's appeal which ought to have been abated. Full stop. Hence, comma, such argument is also counterproductive in nature. So next para, regarding Benami, comma, no argument was ever made by the appellant during the hearing of the matter, the hearing of the appeal. Full stop. Thus, comma, a new point cannot be permitted to be reopened on merits at the review stage. Full stop. Next para. Insofar as the deed of settlement is concerned, comma, this court has already dealt with the issues sought to be urged by observing that the deed was admittedly a registered one, and there was a presumption of correctness attached, which was never rebutted by the plaintiff appellant. Full stop. Hence, comma, fresh arguments, comma, either on law or on fact cannot be entertained at this stage. Full stop. Even otherwise, comma, the absence of signature of the executant of a deed in the place where the witnesses' signatures are supposed to appear does not vitiate the validity of a document. Full stop. Next para. Be that as it may, comma, we do not find any error apparent on the face of record or the judgment under review to call for interference under Order 47 of the Code of Civil Procedure. Hence, RVW 48 of 2026 is dismissed on contest without any orders to cause. So, is there an interlocutory application? Urgent settlement.
My lord,
Yes.
Bharati, respondent number 6 died on 4/11.
Yes, Mr. Shah, we have decided. Next matter.
That was the 90 days was covered.
Who is appearing for the appellant in this case?
21, Your Lordship. I'm appearing for the appellant.
Deficit court fee is there.
Your Lordship.
And name of appellant number 1 does not tally with plaintiff number.
Deficit court fee, I'll be praying if Your Lordship.
Have paid?
No, Your Lordship. Since the original time given to me was expired, I could not deposit before this MI. I'll be praying if Your Lordship.
And what about the name of appellant number 1 not
yes,
tallying?
Your Lordship. That I have taken instruction. Your Lordship. Your copy of the order.
Insofar as the first defect is concerned, comma, on the prayer of the appellant, comma, leave is granted to the appellant to put appellants, comma, leave is granted to the appellants to deposit the deficit court fees by August 7, 2026. Full stop. In the event such deposit is made, comma, the delay in making the same shall be deemed to stand condoned, and the same be accepted by the office. Full stop. Next para. Regarding the defect in the name of the appellant number 1 not tallying with the plaintiff number 1 in the impugned decree, comma, learned counsel for the appellant hands over a server copy of order number 14 dated April 25, 2024 passed in the suit from which the present appeal arises, wherefrom it transpires that the present appellants were substituted under order 22 rule 10 of the Code of Civil Procedure in place of the original plaintiff. Full stop. Next para. However, comma, since the same was not reflected in the trial court's decree, comma, the trial court's decree is required to be sent down for effecting the necessary corrections thereto. Full stop. Next para. Hence, comma, we direct the trial court records to be sent down for effecting the correction as indicated above after the deficit court fees are put in by the appellant. A matter listed by Rachel. Is there any application?
Yes, on section 5, that is also a defect for out of time. The section 5. May I serve, Your Lordship, in the meantime?
Achha, very well. After the deficit court fees are paid, na kore, after the deficit court fees are paid, and can 1 of 2026 is disposed of. Stop. The appellant shall serve. Appellants shall serve how many respondents?
Lordship.
Copy বা copies দেখে করে দিও of the respondent on the respondents. Copies of can 1 of 2026 on the respondents. Yes.
3 respondents.
Copies of can 1 of 2026 on the respondents, indicating that the application shall next be listed in the monthly list of September 2026 when an affidavit of service shall be filed by the appellants. Next.
22, my lord, I appear for the appellant, my lord. On 13th of May 2026, my lord had taken up this appeal. Appeal was admitted and the injunction application of the respondent was dismissed.
Yes,
And my lord, 8 weeks time was given to for filing paperwork.
lord.
My lord, in the 6th week,
You first.
in the 6th week, my learned senior friend has filed a review application. He served upon me. Review 159 of 226. That is still pending.
So it's his application then. Yes.
And can 5 that has been filed, that has not been served upon me.
Can 5 copy dine?
Can 5 not served. Review application served. Review 159 of 2026.
Review of what order?
Review of the 13th May order
13th
that
May.
I just said. 13th May 2026. My lord has
see.
passed.
Review on what now?
My lord, review ground kindly paragraph 7 of the 13th May judgment, my lord. Order.
That application is not in
Paragraph
the
17 and 18.
Review application you have not got a copy?
No, I have got. That is not in the list.
A review application is
Review
apparently
application passed by Honorable Justice, my
apparently-
lord, along with Justice Vishrup Chaudhary.
then that bench has to sit.
Yes. That is what I
Before that, we'll dispose of the scan
This is again an injunction application again filed. That has already been dismissed by this.
by him.
Dismissed, my
Yes.
lord. But my lord, the stay application also be in dismissed. I'm saying, my lord, kindly see paragraph 17, my lord.
If my lord sees the 13th May order, it will clarify.
So, but this scan is dependent on that review, the outcome of that review.
Yes, my lord. My lord, only one point, the amicable partition, amicable partition.
Why are you asking for review of that order?
Review, my lord, that the not party, my lord.
What not
Actual
party?
party was not made in the suit. That is who will produce the, my lord, the amicable partition. That is also I have annexed with this.
Anyway, since can 5 of 2026 is dependent on a review application which has apparently been filed by the respondent, comma, let the matter go out of the list. Full stop. Go out of the list, comma. What is the review number?
159 of 2026.
Full stop. Next para. RVW
9 of 2026.
9 of 2026, comma, which is not appearing today, comma, be listed before the appropriate bench. Hey, please give on a slip of paper, please write the number of the review. Write the number of the review application.
Yes, my lord.
Because that will be heard then.
Yes, my lord.
Very well, my lord. Deeply obliged.
রিভিউটা জাস্টিস বিশ্বরূপ চৌধুরীর সঙ্গে বেঞ্চ করে করে নেব।
In the meantime, that disturbing the possession of the, since 1956, They are in possession, my lord.
Let them disturb for a few
I'm in
days.
possession. He's saying
No, my
I'm
lord, do not-
disturbing my
Just-
possession.
just-
Because this
so they like-
only we are taking advantage of the order, my lord.
We have
Never
already
challenge.
passed an order.
Yes, my
Unless we review that order, there is no scope of again you asking for injunction on the same cause of action. You cannot repeatedly go on filing applications.
My-
Therefore, this is dependent on the
I'm praying on till the disposal of the review application, my lord.
No.
I'm praying
No
for.
question of that. Till the disposal of review application, this application is not maintainable. If you take it now, then we'll have to reject it because of our 13th July order. You have to understand this, Mr.
13 May, my lord.
People are
I am for the appellant. This is against the preliminary degree that has been filed. Two application is there, my lord. Only one thing, my lord. Application number 2 is for additional evidence. There is some defect, and another thing, my lord. No document has been annexed, which has been produced as additional evidence, my lord.
You have annexed to the order for 2027 application.
No,
to the you have annexed
filed without annexing the document.
This order for 2027 also filed without annexing documents.
Yes.
Then
otherwise, in the my lord stay petition, it has been annexed. That document has been annexed.
Those are the same documents which you want to rely on.
Yes, yes.
I am for the respondent number 1 to 5.
1 to 5.
6 to 9 are the respondents here, but they are the pro forma defendant in the trial.
There is caveat.
Why pro forma? They are also co-sharers according
yes,
to.
Yes.
This is caveat, my lord, against.
This is my transfer brief.
No difficulty, but what about service on the respondent number 6 to the rest?
My lord, this is first time. Caveat is there. I serve.
Affidavit of service filed today be kept on record. It transpires from. It transfers. In view of the appearance of the respondent numbers 1 to 5 stroke caveators through their learned advocate, service of notice on the said respondents in respect of the appeal is dispensed with. For next para, the appellant shall serve copies of Can 1 of 2026 and Can 2 of 2026 on the respondent numbers 6 to 11 and file an affidavit of service to that effect on the returnable date. Next para, the application shall next be listed in the monthly list of September 2026. Next para, in the during pendency of the application, the trial court shall continue with the final degree proceedings, but shall not draw up any final degree without the leave of the court. So next para, the appellant shall put in postal costs and requisites for service of notice of the appeal on the respondent numbers 6 to 11 within a fortnight from date. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a fortnight. The trial court shall retain skeletal records, if necessary, to continue with the final degree proceedings. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellants.
My lord, may I file affidavit in opposition against Can 1 and Can 2?
Why? Can 1?
Can 1 is the stay application and Can 2 is the application under Order 41, Rule 27.
Yes, but even if we will have to direct that to appear along with the application.
Okay.
Very well. We'll direct affidavits. Affidavits in opposition to Can 1 of 2026 and Can 2 of 2026, if any, shall be filed within a fortnight from date. Reply thereto, if any, shall be filed within a week thereafter.
Annexure 2, P2 is the document, my lord.
When we decide that, we'll consider. Thank you. কোনটা পাসওয়ার্ড ছিল 13 কোথায় সে হারিয়ে গেল ঠিক আছে yes who is appealing
for the appellant.
What is the matter?
On the earlier occasion, Lordship was pleased to grant a stay of the proceedings, and accordingly, I filed affidavit of service.
All have been served?
Yes, in regard to
only 3.
1 and 2, there were 2 addresses. On one of the addresses, it has been served.
Sufficient. 3?
3,
Yes.
sir. It has been served. May I file my affidavit?
This arises out of what?
Arising out of a partition suit, preliminary decree.
So you pass the usual direction?
No, Lordship, there was
Stay.
a specific stay.
Why did we make an exception?
Because of the fact that there was no specific prayer for cancellation, and it could not have been made because of the limitation.
Partition was dependent on that?
Yes.
Affidavit of service filed today be kept on record. Stop. Despite service, none appears for the respondents at the time of call. At the inception, we had granted stay of operation of the impugned preliminary decree of partition primarily on the ground that despite the prayer for partition being dependent on the legality or otherwise of a gift deed, comma, the execution of which was admitted, comma, no specific relief of cancellation of the same was sought by the plaintiffs, full stop, even otherwise, comma, the said relief would be time barred at the point of time when the suit was filed. Full stop, next para. We do not find any changed circumstance to deviate from such view taken by us at the ad interim stage. Full stop. Accordingly, comma, since a strong prima facie case for hearing the appeal on merits has been made out, comma, what is can 2?
Can 2 is Order 41, Rule 27.
যেটা বললাম, comma, can 1 of 2026 is allowed, comma, thereby granting stay of operation of the impugned judgment and degree till disposal of the appeal. Can 2 Order 41 Rule 27. You have served copy of this also?
No, we have not served.
We did
There
not
was no
direct.
direction.
The appellants shall serve copies of Can 2 of 2026 on the respondents, indicating that the same will be heard along with the hearing of the appeal. Full stop. Affidavits, if any, shall be exchanged in the meantime. Full stop. The appellants shall put in postal costs and requisites. Did we pass directions for postal cost requisite these things?
Lordship, that direction has been complied with.
Very well. তাহলে আর কিছু দরকার? Thank you.
Great.
Can 2 of 2026 এখানে বললাম না, কথাটা ইউজ করলাম যে can 2 of 2 ওখানটা কমা দিয়ে একটা করে দাও, which is an application for production of additional evidence. তারপর shall be heard along with যা যা আছে. Thank you.
Agree.
Returnable date হয় না along with the appeal. গেছেন? Yes.
Please, your lordship.
Premium partition degree?
Yes, sir.
We ignore your appearance. We ignore your appearance.
No, there's one problem. Have a look at your lordship.
Oh, you're appearing for?
There are plenty more, my lord. Have a look at your lordship's last order. My lord, it was told by Mr. Mukherjee, my lord, that respondent number 5, my lord, has passed away.
Yes.
My lord, we did not know, my lord, with respect to his passing away, though this is a partition suit. So he has.
You found him roaming about somewhere.
No, my lord. Now they have filed an application in the court below, my lord, seeking for substitution. That was not served upon us. It was served on some other address, my lord, which did not reach us. We tried to, my lord, get hold of a copy of that application so that we can file it here. We have applied for certified copy. My lord, we applied for it, my lord, 2 or 3 days back. It will take some time to come. This is our application for that.
My lord, I am
Just
appearing on
each
behalf
time, my
of.
lord, so that the application for substitution of this, my lord, can come up before you.
Yes, Mr. Shah, what do you say?
I'm going to respond number 1. This is filed by respondent number 5.
You cannot pass further orders in the name of a deceased person.
No.
My lord, I am appearing for the respondent number 2 to 4 and 6 to 9. Mr. Mukherjee is leading me on the last occasion.
Yes.
My lord, only one submission which I would beg to differ from my learned senior friend appearing for the appellant is
That was
that
served.
we had tried to serve on the addresses of the appellants. Now, my lord, both of those addresses had come out with the remark that they were not present at that time. And accordingly, the learned trial court had passed an order saying that under General Clauses Act, as because they were not present, those addresses were.
May I make this very simple, my lord? Let them file it, serve it upon us. There is no problem at all. I'll instruct my learned friend, my lord, to
You
accept
have a copy of that application?
My lord, we have tried to serve, my lord, through postal service.
Now
we
you have a
tried
copy of that application. Serve on the learned advocate appearing for the appearance here.
Very well, my lord.
At the outset, learned senior counsel appearing for the appearant points out that on an earlier occasion, learned senior advocate appearing for the respondent numbers 2 to 4 and 6 to 9 had pointed out that the respondent number 5 has died. Accordingly, substitution is required in respect of the heirs and legal representatives of the said respondent. However, it is submitted by the appellant that as no copy of the substitution application in respect of the said deceased, which was filed in the trial court by the respondents, was served on the appellant, a certified copy thereof has been applied for, a photocopy of which application is handed over in court and kept on record. Next para, At this comma, learned counsel appearing for the respondent numbers 2 to 4 and 6 to 9 submits that the attempted service on the appellant with regard to the substitution application filed in the court below came back with certain postal endorsements indicating that good service was effected. Full stop. Next para, be that as it may, comma, the said issue will be considered at the time of adjudication of the application for substitution stroke addition, comma, when it is filed by the appellant, and all questions in that regard are kept open for being decided at the time of adjudication of such application as and when filed. Full stop. In the meantime, comma, the learned advocate on record for the respondent numbers 2 to 4 and 6 to 9 shall serve a copy of the substitution application filed in the trial court to the on the learned advocate on record for the appellant. By tomorrow, can you do it, Mr. Das?
Yes.
By tomorrow. To enable such appropriate application to be filed. Full stop. Upon filing of the same comma, and copies thereof shall be circulated among the learned advocates for the respondents. As learned counsel for the respondent number 1 submits that no copy of the memorandum of appeal has been served on him as per our previous direction, comma, the learned advocate on record for the appellant is directed to serve such copy, comma, which is served here and now.
Don't do all this.
Next.
The interim order is still the 19th.
Date
Was
person.
still the 19th.
Date person. Date person.
Partition suit, so there would be no.
Partition suit is more strict.
Yes, so it,
To file that application.
Lord, if even on the last occasion, my Lord, your Lordship had extended it.
Recall that.
No, because
No. You file it and
respectfully, my Lord, if
we have not put any returnable date. The matter shall next be. How soon can you file it? If they give you tomorrow?
Tomorrow, day after.
The matter shall next be listed on August 10, 2026, for sub liberty to the appellant to mention the proposed application for substitution stroke addition, comma, as and when filed, for being tagged along with the other applications on the returnable date. Whenever you file it, just mention it. That we have stated already, recorded in order. Item 26.
26.
Yes, Mr. Shamul, what is that?
On the last occasion, we have your Lordship, in pursuant to your Lordship's direction, we have served, my Lord, and I find that service is, my Lord, effective, my Lord. My Lord, challenging an injunction, temporary injunction order by the pro forma defendant.
What about service? Good service?
Service, my Lord, good service.
Stay means allowing the appeal.
My Lord, because the thing is that the parties to the suit, we have been implemented as a pro forma defendant. Enter allegation against us that we are conducting Durga Puja for last 30 years without any authority. We say that we are conducting the Durga Puja on a portion of a land which is vested to the state, belongs to the PWD, and there was a partition suit amongst the parties, earlier partition suit pending. In spite of pendency of this earlier partition suit, a fresh partition suit.
Mr. Shamul will record this time in our order that we'll keep it 2 weeks hence.
My Lord.
We'll record in our order that a further notice shall be served, only notice, no copy. That will be treated to be notice of this appeal.
My Lord.
And we'll take up the appeal along with
My
it.
Lord.
Otherwise, this will go on.
My Lord.
Affidavit of service filed today be kept on record, full stop. From it, comma, it transpires that good service has been effected on the respondent. Full stop. However, comma, since none appears for the respondent at the time of call, comma, the appeal along with the application cannot be taken up for hearing. Full stop. On the last occasion, comma, the intention of the court was to hear out the appeal along with the application, comma, since the ambit of the appeal is short. Full stop. However, comma, since the respondent is unrepresented, comma, we direct the appellant to serve a notice, comma, along with a server copy of today's order passed by us, comma, indicating that the appeal along with the application shall be taken up on the returnable date. Full stop. Such notice shall be constituted to be a notice of the appeal itself. Full stop. Next para. An affidavit of service to that effect shall be filed on the returnable date. The matter shall next be listed on August 17, 2026 under the same head. Sorry.
Number 27.
My lord, I beg to appear for the respondent in this matter.
I am for the appellant. On the last occasion, your lordship was pleased to and pass a direction for stay of the further proceeding from the court to the order of the matter.
My lord, may I make a small submission? My lord, just yesterday we have been appointed in this matter, and today itself we have submitted the Wakalatnama. My lord, I pray for a short accommodation.
Affidavit of service filed on the
ejectment suit.
Ejectment suit, my lord.
Originally filed as an ejectment suit, converted to 2G, suit dismissed on the ground that the trial court came to a finding, no pleading in the plaint of ownership, no evidence of ownership. Appeal Court, Order 41, Rule 27, bringing documents of title on record without amending the plaint and incorporating any pleading of ownership. The issue is, if there is no pleading of ownership, could it have been remanded for recording evidence of ownership? If your lordship will kindly see.
My lord, you direct them to file affidavit
No,
my lord, my lord.
You are directing that?
Yes.
You file affidavit in opposition.
My lord, ownership documents were submitted at the time of hearing of the petition filed by the tenant under section 7 of the 7.2 of the said act. My lord, these ownership documents were filed.
So you file your opposition, annex everything there?
Yes, your lordship.
And we'll keep the question of occupation
And my
charges.
lord, memo of appeal was not served upon us.
Need not be, but we'll direct now if you want.
Kindly, my lord.
My lord, it was served on the previous.
You are for all the
on both
plaintiff respondents?
Yes, my lord.
So we'll keep the question of occupation charges also open. And in your affidavit in opposition to the stay application, you indicate materials to
Yes, your
assert
lordship.
the occupation charges and also annex these documents, whatever.
There is no decree against me, my lord.
Oh, ultimately what was done?
My lord,
suit failed. Appeal court has remanded it on an open remand.
Oh. Oh, then there is no question of occupation charge at this time. We are not staying in eviction degree. Anyway, you annex your documents. How soon can you file your opposition?
My lord, 2 weeks time. I need to obtain the certified copies from the lower court.
On the pair of the respondents are directed to file their affidavits in opposition to Can 1 of 2026 within a fortnight from date. Reply if any shall be filed. Reply thereto if any shall be filed within a week thereafter. The application shall be listed next in the monthly list of September 2026. Push up next para. A copy of the memorandum of the appeal be served on the learned advocate for the respondents by the appellant in the meantime.
Obliged. দাদা আপনার নতুন চেঞ্জ এসেছেন তো একটু আমাকে
Stay was still disposal of the application.
Yes, my lord, I think so. I'll just check.
My lord, stay was for
just check up
against the remand
till disposal.
Next.
May I please your lordship, I appear for
that affidavit of service has come?
Yes, my lord.
After this matter, we'll take up your Yes, yes.
I appear for the appellant, my lord. Last occasion, my lord, lordship, my lord, passing an interim order also directed for service upon the respondent, my lord.
I am appearing.
They have received, I believe Mr. Chatterjee will be opposing me, and in his usual fairness, he accepts, my lord, the wrongdoings of his client. He says, yes, there has been some wrongdoing on the part of my client.
মাথায় হাত বুলিয়ে অর্ডার করিয়ে নেওয়া
পিঠে, this is পিঠে.
এটা ইংরেজিতে কথা বল, বাংলা কথা বলো না।
In vernacular, my lord, we had heard মাথায় হাত বুলিয়ে অর্ডার করিয়ে নেওয়া. But this is today, my lord, experience is that.
Always, my lord, in his
What
usual
is the
fairness,
challenge against 7-Eleven allowed?
No, my lord, that is pending. But this is, my lord, against, my lord, the order of injunction, my lord. Passed, my lord, in a suit for declaration and injunction. Lordship will recall here, my lord, the case of the plaintiff is that my mother had surrendered the tenancy. We, being her sons, are again trying to get back to that place. So we went to the court, filed a suit for declaration that they are in possession and for injunction, and court initially passed an ex parte injunction. That was challenged in this court with certain observations, my lord. The court below was directed to hear the injunction. In the meantime, the suit property is under the custody of the receiver. I think, my lord, the receiver is here today. Now, my lord, again, my lord, that injunction application was allowed
against which we have come up in appeal, my lord. Now, my lord, lordship has again stayed that order, and the receiver is still in possession of the suit property.
Yes. What was the nature of the order?
My lord, was the interim or the injunction order was that they will continue be in possession. Application is hereby allowed according defendant manner hereby restrained. We have been restrained from interfering, disturbing, and dispossessing the plaintiffs from the suit premises in any manner. Now, my lord, this has been stayed by your lordship.
Let
my
us
lord.
just see our previous order.
ওটা stay হয়ে আছে তো।
দেখি একবার
এই তো প্যারাগ্রাফ 7-8 টা দেখ।
সে কি?
We state the operation subject
But
to the rider
injunction-
that the learned advocate who was appointed as special officer,
Yes.
he was in possession of the property, shall continue to be in possession
Yes,
of the property. He was appointed to take custody of the property, Mr. Chatterjee.
My lord, but that also, my lord, is after this, that the order, my lord, which has been passed by justice said was passed on the ambit below that there can't be any, my lord, implying surrender. There has to be, my lord, a written.
The premise of our order apparently was that if it is in possession of a
very well, that's a
special
my lord,
officer, you cannot get an injunction from disturbing your possession.
my possession.
It's
Now,
not in your possession. It's in
It is
possession
in
of the
my possession.
use.
It is in my
You're
possession.
filing an affidavit.
And the special officer has found that in his report.
Directed to file an opposition, you disclose all these things.
Lord, it's in his report. Lord,
We have already directed
your
to
lordship.
file.
Yes, well, I thought
Within a few days.
Two submissions. First of all, my lord, the mother was the tenant. They are nobodies.
Mr. Chatterjee, we are telling you this. We had directed service of filing of affidavit in opposition. If you do not file, then we have to proceed on the premise of these the averments in the application. That is the difficulty.
Take a chance. I said I
No,
can
you
take a
did not
chance.
know maybe.
But let us file an affidavit. Let us
Do that,
7
Mr.
days.
Chatterjee, unless because
I
otherwise, if it comes to a crunch situation, then we'll have to go by non-favors.
I will just bear with me for 2 minutes. My points I'll tell your lordship so that my learned senior friend also gets to know. Point is, he doesn't have a right on the property at all, whether as a tenant, whether as whatever. The mother was the tenant, she surrendered it and went out.
No, is it true that it is in custody of a special officer?
No,
appointed?
I am in possession. The special officer has given a report that I opened the premises. His report says so.
My lord, may
I ask this question to myself? How does a special officer even come into play?
You annex everything, Mr. Chatterjee, and we'll hear it on the next day. How soon can you file your opposition?
7 days, max. Ready, it's ready. 2 days.
That is what we said. We'll
2
be able
days.
to file it within 2 days, give an advance copy to them. And the learned special officer is requested to be present on the next day also.
I shall.
Please give copies of all pleadings to the special officer.
We
Your
shall do that.
application, your opposition, your reply.
We shall do that.
All the pleadings. We'll direct that in our.
Only, my lord, may I ask this? May I pray before your lordship to ask him who opened the premises and who is in possession?
We'll do that on the.
That's it.
On the prayer of learned senior counsel for the respondents, the time for filing affidavit in opposition is extended for till when, Mr. Chatterjee? Today
2 days.
Till August 6, 2026. An advance copy thereof shall be served on the learned advocate on record for the appellant. Reply, if any, shall be filed within a week thereafter. The application shall next be listed for hearing on August 17, 2026. Next para. Both parties shall serve copies of all the pleadings, including the applications and the affidavits in opposition and reply. The learned special officer who is requested to be present on the returnable date as well when the matter is next called on for hearing.
Well, can it be on August 18th?
Yes, 17th was 18th.
I'm grateful.
Affidavit of service filed to be written.
ভালো ভাই আরে ভাই দিন ছুটি আছে
এবার পাস ওভার
তো 15-16 পরের দিনটা সোমবার
I have served, everybody has received.
File affidavit of service and
there was 30 days delay in filing them.
What is the reason?
Communication gap in between the learned advocate of the court below.
Despite service, none appears for the respondents at the time of call. From the affidavit of service, it transpires that due service has been effected. Accordingly, can 1 of 2025 is taken up for hearing. We find that the delay of about 30 days in preferring the appeal has been sufficiently explained due to communication gap between the learned advocate conducting the case in the trial court and the appellant. Hence, can 1 of 2025 is allowed, comma, thereby condoning the delay in preferring FAT 199 of 2025. The said appeal be deemed to stand registered and admitted, no orders to cost. What is the appeal against?
Appeal, my lord, against the dismissal of the suit, my lord.
There is no scope of any stay.
No, there is no scope. Because
so the application we are disposing of without granting any stay,
yes,
but directing you to put in the postal cost and all.
Yes, yes.
Can 2 of 2025
because we are asking for recovery. Property is in possession of the other opposite party.
But stay of suit does not.
Yes.
You won't get that recovery.
No.
Can 2 of 2025 is an application for stay. However, comma, since by the impugned judgment and decree, comma, the plaintiff stroke appellant's suit was itself dismissed, comma, there is no scope of grant of such stay. Accordingly, can 2 of 2025 is disposed of without granting any stay, but directing the appellant to put in postal costs and due requisites for service of notice of the appeal on the respondents within a fortnight from date. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a fortnight. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for them.
I'm extremely grateful. I'm sorry, my lord, it took long time to get the track report.
No,
Grateful.
Yes.
My appeal, my lord. And they are appearing, and this is my every service.
Respondent.
This was a challenge against refusal to grant any injunction order.
Appeal was admitted.
Appeal was admitted. My lord was pleased to pass in an interim order of injunction. My lord will find that from the last
The
order.
suit was for?
Suit was for declaration, recovery of caste possession, and permanent injunction.
Declaration of title.
Declaration of title. My lord will find that at.
No, why was it ad interim was refused or the main?
Ad interim was refused.
Why?
If my lord kindly comes to the
Let
order
us see
in
that.
tune, my
Yes.
lord.
Yes.
Rather proceeded with the prima facie title rather than prima facie case. That and it was rather observed that it further appears that the allegations of trespass and illegal construction are not supported
Chain of
by
title as pleaded appears complicated.
complicated. That was recorded by my lord in the order itself, my lord. It further appears, the second paragraph, it further appears that the allegations of trespass and illegal construction are not supported by any contemporaneous documentary evidence establishing that the plaintiff's actual physical position immediately prior to the allegations alleged incident. Now, my lord, there's a deed executed in my favor. Prior to the deed, I published a newspaper publication.
These were produced in the...
Yes, my lord will find from the plain, there's a disclosure under Order 7, Rule 14, the documents which I have produced. My lord will find that at page 18 of my CAN application. As well, I am carrying the Firisti as well, my lord, which was produced before the Learned Trial Court. My application for mutation, it's being recorded in the name of my vendor.
Which one is your title deed? The last one, 2010?
Yes, my lord, 2010.
Should be the last one.
Yes, yes.
So there it is recorded that possession is handed over to you. Or tax receipts
Yes,
are also.
it's a deed of sale. Presumption is always there, my lord.
Tax receipts and all are also.
Yes, they are also there, my lord.
But Ramkishore Chaudhary is not you.
No.
Your predecessor.
My predecessor and interest, my lord. I purchased from Ramkishore Chaudhary, whose name was recorded as LR Kotian 2025.
What injunction did you ask for?
My lord, kindly comes to the my application, my lord.
Yes.
It's at page 73. Not to make any further construction, not to make any illegal construction, not
Disturbing
to change the
peaceful person and
yes,
page 73.
Page 73. And my lord, kindly, this is the original prayer which was made before the trial court.
You cannot go beyond that.
No, my lord, I understand.
But we granted injunction beyond
injunction that? on the basis of this prayer, not with regard to my application's prayer.
It's making kind of construction for the illegal. All adjectives used for construction ultimately.
Yes.
And change of nature.
I tried to push my leg on the last occasion. My lord didn't allow me to, my lord.
No, because we cannot go.
Yes, my lord, I understand.
Yes, Mr. Dev, what do you say? Don't
I tell your lordship, the property originally belonged to one HON'BLE Nochkar. HON'BLE Nochkar had three sons, Sujit, Ajit, and Produk. Sujit sold off his shares in 1989.
So at the ad interim stage, court has to go by there.
Only one thing, in 1989, Sujit sold off entirety of his share. And the appellant before my lord is claiming share from Sujit for in respect of sale deed executed in 1993. So whether in 1993 Sujit at all had any share or not.
He said they will record your submission, but we'll say that we cannot go beyond the pleadings before the trial court at the ad interim stage. We'll continue the status quo we granted or
No, my lord, injunction with regard to construction.
continue the injunction to disposal of the injunction application. Will you file your written objection? And
Or so far, my lord, so far the injunction is concerned, my lord, I am carrying out construction on my own land, and even the schedules are totally different.
That has to be assessed by whether it is your own land.
My lord, may I pray, my lord, may I carry out the construction subject to the result of the injunction application?
Not at this stage.
Because I've done substantial construction up to G+1 story, whereas it is recorded here
You
as
bring
per
those on
submission.
record, Mr. Day, before the trial court. You have to bring these on record. We are disposing of the appeal itself.
Then with a time-bound program, time by which the learned trial court will
How
dispose.
soon can you file your objection there?
Within 2 weeks' time.
Wait.
It's not usual practice to file replies before the learned trial court. Let
No,
them
no,
be
we
delivered.
won't permit you. We won't open a new avenue for.
Very well, my lord.
Only we'll couch it as written objection, as is done.
Oh, I just understand.
The present appeal has been preferred against the refusal of ad interim injunction in a suit for declaration of title and permanent injunction filed by the plaintiff stroke appellant. Full stop. The learned trial judge primarily proceeded learned trial judge aage, in view of the appeal and the application being identical insofar as the issues involved are concerned, which are brief in nature, we take up the appeal for hearing along with the application on the papers before us. So next para, the learned trial judge refused to grant ad interim injunction on the ground that the chain of title as pleaded, double inverted, appears complicated, double inverted close, based upon several successive transfers, and requires full-fledged trial and evidence for proper adjudication. Full stop. Secondly, it was observed that allegations of trespass and illegal construction were not supported by any contemporaneous documented evidence establishing plaintiff apostrophe's actual physical possession immediately prior to the alleged incident, and that the appellant admittedly resides outside the state of West Bengal. An entire case is based substantially upon information allegedly received from constituted attorney. Full stop. Next para. Delay in approaching the court was also cited as a ground for such refusal. Full stop. The learned trial judge held further that the grant of injunction at that stage would virtually amount to granting final relief. Full stop. Next para. Learned counsel appearing for the plaintiff stroke appellant submits that along with the plaint, the entire chain of title of the documents in support of the entire chain of title of the plaintiff stroke appellant from his predecessors in interest were disclosed. Full stop. Furthermore, several tax receipts and other documents were also produced in support of the contention that the plaintiff is in possession of the suit premises. Full stop. Next para. As such, at the ad interim stage, it is submitted, the learned trial judge ought to have proceeded on the premise of the averments made in the plaint and the injunction application. Next para, senior counsel appearing for the respondent controverts the arguments of the appellant and submits that substantial construction has already been raised by the respondents on the subject property, on the subject property with a valid sanctioned plan. Furthermore, it is argued that prior to the transfer in favor of the predecessor in interest of the appellant, the property was transferred in favor of the respondent's predecessor. Full stop. Next para. Hence, it is submitted that not only does the plaintiff stroke appellant not have a prima facie case to go for trial, the balance of convenience and inconvenience is also in favor of refusal of injunction. Next para. However, the law is well settled that at the stage of grant of ex parte ad interim injunction, it is only the averments made in the plaint and the injunction application and the documents submitted therewith, which are to be construed by the trial court. Full stop. Since, comma, at that stage, comma, no controversy is available on the part of the defendant stroke respondent, defendant, comma, there arose no occasion for the learned trial judge to look into the contentions of the defendant. Full stop. Next para. On the face of it, comma, it transpires that the learned trial judge proceeded on erroneous principles and materials. Full stop. The mere fact that the chain of title as pleaded appears double inverted complicated double inverted clause does not entitle the trial court to shirk its duty and relegate even the consideration of ad interim injunction to later stage of the suit. Full stop. Secondly, comma, the learned trial judge completely overlooked the substantive documents produced by the appellant, plaintiff stroke appellant, in support of its prima facie case. Full stop. Even otherwise, comma, since injunction was sought regarding change of nature and character of the suit property primarily, comma, the question of possession was not so germane as portrayed in the impugned order. Full stop. The fact that the appellant resides outside the state of West Bengal is utterly irrelevant, comma, since it is open to the trial court, comma, in order to preserve the suit property, comma, if a prima facie case is made out, comma, to grant prohibitory injunction in aid of the final relief sought in the suit. Full stop. Next para. Needless to say, comma, the grounds of objection raised by the respondent before this court are also required to be looked into, comma, being serious in nature. Full stop. However, comma, at this stage, comma, the appellate court cannot transgress beyond the jurisdiction of the trial court, comma, which was confined to the averments made in the plaint and injunction application and the documents filed in support thereof. Full stop. Accordingly, comma, FMAT 185 of 2026 is allowed on contest, comma, thereby setting aside the impugned order bearing order number 2 dated May 22, 2026, passed by the learned civil judge senior division second court at Baripur district South 24 Parganas in title suit number 290 of 2026 and restraining the respondent and her men and agents from changing the nature and character of the suit property in any manner whatsoever till disposal of the temporary injunction application in the trial court. Full stop. The subject to the defendant stroke respondent filing her written objection to the temporary injunction in the trial court within a fortnight from date, comma, the learned trial judge shall make endeavor to dispose of the injunction application itself as expeditiously as possible, comma, preferably within 6 weeks from the date of communication of this order to the learned trial judge. Full stop. Next para, we make it abundantly clear that the merits of the contentions of the parties have only been tentatively dealt with above, and the above observations shall not be considered to be binding at any further stage of the injunction application or the suit, and it will be open to the learned trial judge to independently decide the injunction application and the suit in accordance with law and on their own merits. Full stop. Next para. Consequentially, can 1 of 2026 is also disposed of, no arrest to cause service.
One thing I have to point out, Mr.
Affidavit of service.
Yes, there was no compliance with 39(3)(a)(b) since there was no injunction order clause. I immediately came up before this honorable court.
Now they have copies.
Yes, Malon, they have copies of the plaint and the documents which I relied on the CAN application before this court. I had selective documents. The entire copy, I'll serve within the course of this date. That may be recorded. As per the list of documents filed before the trial court, as mentioned in the plaint.
আচ্ছা, যেখানে needless to say বলে observation গুলো বললাম যে tentative, তার ঠিক আগে learned counsel for the appellant fairly submits at this juncture that in view of no ad interim order having been granted, comma, there was no compliance of order 39 rule 2A of the code of civil procedure, full stop.
3AB.
3A, sorry. 3A of the code of civil procedure. 2A, there is no compliance, then it will be risk. 3A of the code of civil procedure, full stop. Accordingly, comma, the learned advocate on record for the appellant shall hand over the entire copy of the temporary injunction application and plaint filed in the trial court along with the documents filed stroke annexed therewith stroke thereto and or relied thereon on the learned advocate on record for the respondent during the course of the day.
I'm great. I'm great.
Lord, on the last occasion, my Lord, I beg to appear for the plaintiff appellant. On the last occasion, my Lord had directed my Lord to serve and also granted us, my Lord, an injunction, Lord, that was valid till 31st of August. Lord, I'll pray for an extension of that.
31st of August.
My lord, I am only praying for my lord,
31st of
1 day's accommodation, your lordship, if the matter can be heard day after tomorrow, my lord. I'm being
Hey.
led by Mr. Basu, my lord. He's not.
Which Mr. Basu?
Devajyoti Basu, my lord.
What happened to him?
My lord, he's not in Calcutta, your lordship.
No, that's no.
My lord, kindly.
We're disposing of this.
My lord, it's also written in the cause list that the file is not there, my lord. And it's with the department.
সমস্ত রেসপন্ডেন্ট all
File
respondent
lying in department রয়েছে কেন লেখা? It was not there. It is now here. So for that, Mr. Basu is not appearing.
No, my lord, he's in
Achha.
some difficulty, your lordship. Only a day's accommodation, my
Understand that
lord.
he has become very senior, but
My lord, a day's accommodation, your lordship, kindly.
it took it for granted that since the file is lying in the department.
No, my lord, I'm just indicating that I got to know right now, my lord.
That's extempore ground.
No, my lord. My lord, kindly do not take me amiss, your lordships.
All right. So you are enjoying injunction till
31st of August.
Only praying for 1 day.
If you want an extension, then we'll shorten it till the end of this week so that we can grant an extension. We have the
31st of
opportunity.
August, no, it will 31st
On the prayer of the respondent, the matter is adjourned till August 5. Day after tomorrow.
Day after tomorrow.
August 5, 2026.
Come. Wait.
Affidavit to be kept on.
So grateful, my lord.
Next.
নম্বরটা নিয়ে all respondent
এখনো শুরু হয়নি। ও বাবা দাগা ফাগা আছে।
It is your lordship. This is my appeal.
Yes.
So whereby my
Both of you are appearing
Yes.
for the day.
Now, basically, my lord, an appeal hearing. So, lordship fixes a date, my lord, we'll
My lord.
file our
Lord,
opposition.
that's a very short point whether I am entitled to gas connection or not.
You appearing, Mr. Chatterjee appearing a short point, we don't believe you. We just don't believe you. We believe you otherwise as counsel, but on this, no. You have challenged an injunction order.
Yes, an interim order of injunction,
Regarding
which was
trademark or something.
My lord, it was my suit is for declaration that I am entitled to gas connection and M gate. My lord, this was the time when SIR was going on. We came up in appeal, and your lordship directed that the M gate pass should be immediately given. My lord, this is an app through which, my lord, access to the
gas connection.
No, not gas connection. Access to the premises is allowed. So ingress and egress.
That's unique to this apartment.
No, it's most of the new apartments have this kind of
M-gate pass.
M-gate pass. It's called an M-gate pass.
Well, Mr. Bhattacharya.
No, it is only because Mr. Sobhosachi Banerjee stays. He has a flat in Viom. That's why I got to know, because he has that similar app. The other point was whether I am entitled to gas connection. They are for the association. They said
Very rich, but I have never seen anything like this. My friends are all very rich.
You don't buy flats, Mr. Chatterjee, you buy houses.
I have no.
He buys villas. He buys villas.
I have not been able to buy a brick. A brick.
Maybe some new material is nowadays being used.
My lord?
If you don't know about anything about bricks, then must be some other material is nowadays
Nothing,
used.
my lord, is not even a brick, cement, sand.
Some new material has come in the market which
Nothing
they
is
don't
there.
know
But
about.
I have not been able to buy even one, if any material, my lord, used to make buildings.
So, my lord, after that, your lordship gave directions for filing affidavits. Whether I am the only question which is now pending before your lordship, whether I am entitled to a gas connection. Admittedly, I am an occupant. The flat which was in question, which I am in occupation of,
Their ground for resisting.
they are saying it is illegal, but it has been regularized, and they were aware of it.
Why illegal? What is illegal?
This my flat, which has been constructed, it is on a deck, which they say is a part of the common area. But this has been
You are in occupation, you say at least as an essential service.
as an essential service. In fact, my lord, the fight is not between him and me. The fight is between the
other occupants.
No, the developer and them. I am caught in the crossfire. It's about a sum of 35 crores which the developer is to pay to them. I have paid 10 crores of rupees as consideration towards purchase of this flat.
When is the next Saturday when we are having court? Then we'll fix it on that.
Yes, any day, my lord, makes that order, my lord. I'm ready.
I'm there. I'm there.
So when is the next Saturday?
That's
when
what
we
I'm
are
saying.
having
Whenever
court?
it happens, my lord, your lordship keeps it.
No. But please, my lord, there's a 6-month-old child of grandchild of mine.
These are
No. There are two flats.
Chatterjee said that on the last occasion. Now you reflect that you are using your father's gas connection.
Yes.
No. My son's gas connection, but I have another son who has shifted from Bangalore with a 6-month-old baby. What is their difficulty if gas connection is given to me?
Supposed to give it
Gas
to
connection is you are getting already from.
No, it is in respect of the other flat, which belongs to my other son. That's a different unit.
No, we'll fix the hearing then.
I can be staying next to Mr. Chatterjee's house, but is it expected every day I will go to his house for lunch and
You're
dinner?
not my son,
So if
unfortunately.
he's your son, yes, why not?
You're not my son, unfortunately. If you were, I would
not.
have.
Fortunately, probably he's not your son. You won't be able to bear the expense. No, we'll keep it on Thursday then. But some preference has to be given gas connection.
Lord, kindly do not keep it this week. I'll be in. Well, from tomorrow, I'm telling your lordship that this week I'll be in either online or not available.
Some exotic location you must be going to.
Yes, Tata Memorial Hospital.
Oh, I'm sorry.
Very-
I'm sorry.
Very exotic
No. I'm sorry. No. Then I will not stand in the way. Definitely not.
Next week, my lord.
Thursday week we are keeping it. That is the hearing date. We'll keep it as a special fixed matter. In view of the urgency involved, since the appellant contends that an essential service, being gas connection, has been withheld to his premises, as a consequence of the impugned order, we direct the appeal and the application to be fixed for hearing under the heading specially fixed matters on August 13th, 2026. That is Thursday week. Specially fixed.
Mr. Corvus.
Well, should I file? Well, should I file my reply?
Yes. Affidavits in opposition and reply filed today be kept on.
Grateful, madam.
Service order.
The service code.
Oh, Mr. Cord is also there.
Gas connection.
Late entrant. Gas connection? So, what is the connection between Mr. Cord and gas connection? Strange. What sort of submissions you are making? Gas connection, that is self-explanatory, Mr. Cord. Gas connection and you are identical.
Save me by not saying gas chamber.
Great.
Thank you. Yes, next.
I am the 32. I am for the appellant. My lord, this matter was taken day before yesterday. My lordship order.
Yes, Mr. Banerjee.
Yeah, my lordship order has been uploaded. Yeah.
And as an officer of the court, may I just give one?
Yes, absolutely. You have a first right of hearing.
My lord would kindly take my minutes on 28 July 2026. My lord.
Have those been circulated? No.
Yes, it has been circulated. My lord.
Oh, the minutes, yes.
Yes. Now, my lord, I was not waiting for my the consent of any of the parties. What I was seeking, my lord, opinion on their part. And in certain part, my lord, they had given objection.
And that is precisely what you have said, opinion on.
Yes. And despite their objection, my lord, I had allowed certain parts of the payments also, despite their objection.
That is what we,
Yes. But, my lord, prior to that, I had disbursed that payment.
Yes, that is what we directed by the yesterday. So that was not necessary then, if you knew that.
Kindly takes paragraph
Question arrows because it was mentioned on the ground of urgency. That's why we took it.
Yes, my difficult. My lord, kindly takes the minutes, my lord. Kindly takes paragraph 3, my lord.
Yes.
This is the GST component.
Huh.
Yes, my lord. This was allowed. They had raised an objection. I didn't. I had allowed this. Now, my lord would kindly takes paragraph page 4. There were certain payments to be made to the creditors.
Yes.
That stage kindly sees the paragraph starting from admittedly. But since the order was passed on an ad interim basis, I just said well, it was returnable on 3rd, my lord. That was playing in my mind. It was returnable on 3rd. That's why at that stage, my lord, I didn't give approval. So I had all along exercised my independent.
So these bold letters were there from the inception?
Yes.
Yes.
So you are very, that was the ground, it's obvious.
Your lordship has already clarified and passed the order thereafter.
So, but he was doing that already.
My lord, the point was, my lord, regarding the creditor's payment. Unless the creditor's payments as he has not considered,
my lord, the entire business will be paralyzed.
No, will Mr.
Lordship,
Banerjee
Lordship, only 1 minute. My lord, we have shown
Banerjee will give it on you to decide because
Yes,
you will
Lordship.
just prima facie look at the whatever documents are produced by parties, and if you find that it's essential to disburse those, otherwise there may be consequences against this association.
Sari shop, my lord. This is the Sari shop.
Shop partnership, whatever this jural thing, then you may permit those.
Yes, your
But
lordship.
otherwise, if
Lordship,
you
may I
find
make
there's some dispute, then
But
don't.
it is,
Yes.
may I just explain
Lord,
my, I was not at all waiting for their consent. All that was I was seeking was their opinion.
my lord,
and
may I take one
that-
moment?
And that was
Not
done
opinion.
by me prior to the order made by your lordship on Saturday. Prior to
Lordship,
that,
Yes, Mr. Sharma.
My lord, we had shown you the 11 July minute paragraph Roman 3, where the learned special officer says, I will seek opinion or consent. The learned special officer, 11 July was shown to you.
No,
and
your submission, Mr. Sharma, if you remember correctly, and we do remember correctly, was that he was waiting for their consent, which
Yes.
is incorrect. Which
No,
is
no,
incorrect.
that is mentioned in the 11 July. Kindly see the 11 July
28
minute.
July, 28 July, you did not.
No, 28 July is there, but before that, 11 July was
Before
shown
that,
to
why
you.
should you look before that?
My lord,
28 July
11th
is-
also mentions and or, my lord.
11th,
And or consent.
11th, my lord, I had framed as procedure,
SOP,
my lord, a
SOP.
standard operation procedure. There, my lord, if someone gives a application before me, I was seeking an opinion from them.
And at the end of the day, not a
that is what
single
the-
state creditors has
No,
been
no,
passed.
Mr.
The
Sharma,
entire endeavor was to make it-
if the special officer deems it fit, he
You-
can
you have already
refuse to-
clarified. And my lord, kindly consider our claim. That is, my lord, the creditors' payment.
Lordship,
Lord,
order of depot yesterday.
all
we have
creditors payment may
forwarded.
not be made
Yeah.
by him. There may
Correct.
there is unless there is some consequence which may befall the.
we have given all the entire documents. He has not rejected, not accepted.
My lord,
What?
my lord,
Let
may
him
I,
reject or
may
let
I
him
say
accept.
two things, my lord, on this? My lord, if your lordship takes, because my lord, Mr. Special Officer had also come to me today, my lord, saying that you had pointed out that day, but my lord, I understand as an officer of court what is going through his mind, my lord. If your lordship takes the 11 July minutes once, if your lordship has it or not, I'm not aware. My lord, this is a compilation.
Returned it probably.
Just
No, sorry, we have it. We have
but
it.
if your lordship takes two,
No, 28th is the yes, 11th July. We have it.
my lord, in 11 July, Roman 3 at the bottom,
Yes.
on receipt of such permission, I shall seek opinion and or consent.
And
This
or consent means it might have been consent also.
absolutely, my lord. On the next day, kindly sees what happens. There's a meeting then held on 15th July. My lord,
That we
I
don't
have
have.
2 copies.
That we don't have.
Last day, my lord, I did not want to trouble your lordships because, but for the special officer's clarification, my lord, your lordship takes the 3rd page. 15th July, the special officer holds another meeting to confirm the SOP of the first day. The parties appear, attend, confirm. My lord, how is the special officer, my lord, with deepest of respect? Thereafter, certain payments came up with regards to creditors. On the last occasion, Mr. Sharma said, my lord, I was not opposing all these because your lordship was just clarifying the order. But my lord, for the special officer's sake, this is what has to be pointed out to your lordship, my lord. That's my limited endeavor today. Your lordship has now clarified it in our presence. I have no objection to that. My lord, just two things. The login ID password your lordship had recorded immediately. We have not received it yet. Immediately, your lordship had categorically said that immediately would have its own consequences on Saturday. My lord, I do not want to again place the same thing. We have not received it.
Yes, Mr. Sharma, what
My lord, the login ID password is available with my advocate record. We are just in the process of writing the email to the learned special lawyer as well as Mr. My learned friend appearing for the respondent. And insofar as my lordship order has already been clarified, kindly keeps the matter after some time. Let the by the time the matter is over, the email would have been gone, and let us see what
the
happens
application
after.
was disposed of previously.
No, nothing.
The application is pending.
Lordship, kindly keep it pending. Kindly keep it after 4 weeks, and let us see what happens in the meantime.
No, the application. What was the relief sought in the application?
Malad, the order is in order. Malad, we asked for a stay for the ex parte order because this is a commercial matter. Malad, the order has to be virtually been set aside. It is a commercial matter which they filed in the non-commercial section 9. It is a nullity. So we will take that point when the main appeal comes.
So we are keeping the application along with the appeal.
Yes. After 4 weeks,
just one more endeavor, my lord. If your lordship takes the cost title, my lord, I have been told by my learned friends that was pointed out to your lordship.
Yeah, that has been changed. That has been amended.
This is a section 37 appeal, my lord. Perhaps it has to, my lord.
No,
I'm carrying the appellate side list. I do not know, my lord. I've been told there's some internal
was,
circular. I am not supposing admission to take place before your lordship. Maybe.
And the matter admission took place.
My lord, with deepest of respect, my lord, unless there's a circular, section 37, my lord, in my limited understanding in the Arbitration Act, my lord, section 9, direct order appeal under 37. My lord, there is perhaps no scope of admission of a section 37. My lord,
There is a rider that if an appeal is preferred against an award,
yes,
it is it's directly registered. There is no admission hearing. All other appeals against orders are to be placed under order for renewal. That is the difficulty. It came to me in a different context. The office people came to me. But difficulties, I also was under that impression, was what you were saying. But then I saw that the award is specifically mentioned, and by default, all other appeals against orders are appealed. So that's the difficulty.
Very well.
Formally,
We
there has
also
been
raised this point. We also raised this point earlier.
no.
This is just
Didn't we admit it previously? Otherwise, how could it?
Yes, yes.
It has been admitted. Now it goes before the regular bench. Then, thank God.
But I was just trying to assist because
We'll record whatever has been submitted by the special officer today, and we are relegating it to the regular bench. Because this was a clarification of our order, so we had to pass it.
Well, let me see whether as of now I cannot find the admission.
No, my lord, it is not admitted.
Not yet admitted, my lord. Not
interim order has been passed.
We'll
not
deem
yet
it to be
admitted. As of now, order does not record admission.
As of now, immediately it will be recorded.
We are lordship officer, wherever lordship.
Kindly keep it before your lordship to see the arrangement. So the arrangement, if we continue, then your lordship.
We love all of you, but we don't love your matters.
Kindly admit it after 4 weeks.
We don't love to retain matters which you don't have
jurisdiction. This arrangement is going on, your lordship said.
Kindly admit after 4 weeks.
We don't have any arrangement with any of the parties.
Interim arrangement which is going
on. No.
My lord, kindly admit after 4 weeks. Lordship, kindly admit after
before the
4
regular
weeks.
bench. The matter, and at the time of call, the learned special officer points out to the court that in the minutes dated July 28, 2026, it was clearly recorded that some of the payments regarding which the appellant sought approval were allowed by the appellant, by the learned special officer. Not only that, it is pointed out further that it is only the opinion of the respondent for which the learned special officer waited before taking a call on the disbursal sought by the appellant, and not any consent as such. Next para, we find from the minutes that although initially in the meeting dated July 11, 2026, it was recorded that the learned special officer shall seek opinion, double inverted with the opinion and or consent, double inverted close, from the other side, in the subsequent minutes of July 15, 2026 and July 28, 2026, a standard operating procedure was set by the learned special officer in presence of both the parties, and certain disbursals, including GST payments, were also permitted by the special officer, by the learned special officer. As such, particularly in view of the clarification which we have already passed, no further order need be passed at this juncture.
Lord, affidavit in opposition, my lord, if your lordship to can 1, my lord, which is
you have filed.
No, I have not filed. There was no direction yet, my lord. If that can.
The parties, the respondent shall file its affidavit. Respondent shall file affidavit in opposition to can 1 of 2026 within how much?
2 weeks.
Within a fortnight from date. Stop reply, if any, shall be filed within a week thereafter. Let the matter go out of the list with liberty to the parties to mention before the appropriate bench, taking up arbitration appeals for enlistment for the purpose of hearing of the appeal along with the application. This minutes should keep on record.
Lord, if your lordship
will record the copies of the minutes dated July 11, July 15, and what was the other
28.
July 28 handed over in court today, be kept on record. Thank you.
Lord, that compilation also consists of correspondences, my lord. Although
they have handed over compilation to
everything, compilation.
Keep
Yes,
it with you.
yes, my lord, because
It will only the two copies.
Oh, 11th July was handed over by Mr. Sharma on the last occasion. So we have it.
Okay.
Not difficult, we have it.
Compilation আরেকটা copy.
So miserly.
No,
Have a copy of an order you are taking.
The notes were
We have handed it over. Deeply obliged.
Understood. Yes.
Grateful, Lordship.
Thank you, sir.
Grateful.
আর কিন্তু এটা আমাদের কাছে আসবে এটা আরবিট্রেশন আছে তাহলে কি
33, my lord, I am for the
Yes,
appeal.
Mr. Mitra.
My lord, the suit plaintiffs are the appellant before your lordships in a suit for party.
Parties are all alive and we hope they're hale and hearty. 2011 appeal. What about you?
11 appeal, my lord. 12 men are shared they have prayed for in the suit.
15 years have passed by. You have not mentioned this appeal for order of appeal hearing.
Practically, the brief was, my lord, with someone else, and sometimes later it has been pointed out to me that this
Yes.
is required to be filed. And my lord, the client is also not inquiring about the appeal.
Have you established contact with the client?
Yes. Recently he has come, my lord. Thereafter, my lord.
What is the appeal about, Mr.
My
Mitra?
lord, the appeal is with regard to, my lord, we are claiming share in respect of 12 and upon us. In respect of property, plot number 263 and
So you filed a partition
263.
suit?
Partition suit. The court allowed, my lord, so far as the 263 is concerned, our case is that this plot belongs to Sochindranath Pal, who transferred it, my lord, later, my lord, against whom a suit has been instituted in 1932. In 32 suit, it has been declared that Sochindranath Pal has share in respect of 263 to that property, and my lord, he has subsequently sold some others from whom we have purchased the property. The court below proceeded on the fitting, my lord, that in the suit itself, there was no mention of the plot itself. Yes, a separate plot ought to have been mentioned, and separate plot has been ought to have been recorded since 263. After the 32 6, long thereafter, my lord, CS record was prepared. Therefore, had it been a case 263 has been sold, therefore this that has been the by mistake it has been written 263.
Mr. Mitra, you did not make any endeavor to prove that 263 was that by local investigation or something.
263, my lord.
263 was a part of the subject property in that suit.
32 suit.
32 suit. 32 suit. The scheduled property of that. Otherwise, how can the court ascertain the identity? Court was justified.
The courts, my lord, they pointed out that he ought to have sold, my lord, 263 by some Bata plot, because the separate plot ought
When
to
did he
have
sell?
been mentioned.
When did he sell to his vendors?
The our vendor in 43.
So then also it could not have been mentioned.
My lord, there, my lord, the plot 263 has been sold.
Oh, CS had come.
CS has come, my lord, the CS record and RS record. There, my lord, my vendor name was not recorded, but it was subsequently recorded in the LR record of right.
Whose name was Sochindranath Pal's name was recorded in the CS and RS?
No, Sochindranath Pal record name was not recorded. Sochindranath Pal, my lord, in 1943 has sold to some other Pals. Their names were also not recorded in the record of right. But subsequently, 86, they have sold entire property, 263 mentioning that
Mr.
property.
Mitra, in the 1943 deed in favor of your vendors, this plot number was mentioned.
In 1943 deed, that was mentioned.
Was there any narrative in the deed, in the 1943 deed, as regards the previous suit and the decree?
Previous suit and decree.
Those were mentioned in the title deed of your vendor. You produce the title deed of your vendor.
Yes, my lord, that was produced.
So in that, was there any reference to the previous suit or the identity?
Previous suit was given, but the court has, on perusal of, my lord, the deeds itself, the court has formed an opinion that he has sold plot number 263 by 85 to 1825, but he has mentioned it 265, not plot numbers, admitting his share, not in Khotian number. If then he, my lord, the court has formed and such an opinion.
No, in the deed it was written by something. Bata plot was mentioned.
In the deed that was not mentioned. In the deed it has been mentioned 263 has been sold to my vendor.
And you are claiming on 263 itself?
263 itself.
So how does the court come to this finding?
Court comes to the finding, my lord, that kindly on peruse that
Mr. Mitra, we'll not do it hastily. We'll come back after recess. We'll continue with this. We'll just look into the findings of the trial court and then we'll pass whatever. এটা থাক টেবিলে। So you claim title in respect of 263 as well as 262 by 1824. Regarding 262 by 1824, what is the stand of the court?
The stand of the court might be in the deed itself. This has been interpolated and this has been recorded subsequently.
There's no signature beside that.
Signature is there, my lord. These two deeds are with me, my lord. Copy of which.
And regarding 263, you are saying that it was not mentioned in the
it was not
suit.
Mentioned in
the deeds you have.
Yes, my lord. So far as this is the
your vendor's deed and your deed.
so far as vendor's deed is concerned, my lord, that is not with me. This was also exhibited document. Both the deeds are of same, my lord. Two separate deeds by virtue of which, my lord, we have purchased the property. There, my lord, this has been mentioned plot 263 and 260.
Here, no mention of the suit is there.
No, no.
Direct
nothing,
transfer.
Nothing has been.
Let us see how the court proceeded.
The court, my lord.
Could we look at the appeal court judgment?
My lord, appeal court has dealt with regard to plot number 1824. 263 by 1824. And my lord, the trial court has dealt with regard to plot number 263. My lord, trial court so far as page 8-9 is concerned, my lord, and by the
No, trial court directed but granted preliminary degree.
Preliminary degree, so far as the admission is concerned, so far 4.5 an share in respect of which the plaintiff has also admitted that we have acquired it by Kunjo Vihari Pal, therefore they have granted.
Not the entire.
Not the entire.
Let's see the reasoning of the trial court.
My lord, at page 8.
Achha.
Page 9, my lord, kindly turn to page on the basis of exhibit 2.5. Two deeds.
No, in the sale deed of Sachindranath Pal, he had mentioned that he was transferring to 63 by 1825.
My lord, kindly to measuring an area 8 and on perusal through which Sachindranath Pal has sold his share in the suit plot in favor of Ajit Pramani, it appears that he has sold.
Which page you are reading?
Page 8.
Achha. On perusal of exhibit AB, appears the name of Suchina has been recorded in respect of. So his name was also recorded in respect of 263 by 1825.
263 1825.
And he sold that also.
My lord, he has sold also
that. But you are claiming 263.
It appears that he has sold plot number 263 by 1825.
Yes.
And not plot number.
But you claim title in 263. If Sachindranath was the owner of 263 by 1825 and he sold that only, then how can you claim 263 through that?
My lord, kindly turn to a separate Khotian has been in the name of Sachindra, wherein the original suit property of title suit number has been separated by two plots. By
everything 263, yes.
And recording the same, Sachindranath Pal had no share in the original plot number. Claim of the plaintiff being in the predecessor in interest of the Sachindranath Pal does not. They have only right upon plot number 263 by on the basis of exhibit T5. Two deeds are prepared which are exhibit 3 and 6 but in the two deeds in the schedule, instead of mentioning water plot 263 by 1825, by mistake or by maybe by willful, plot number 263 has been mentioned, and another 60 decimal has been sold in favor of the, though actually Sachindranath Pal did not
But
sold
Mr.
the
Mitra, if
plot.
Sachindranath himself had right only in 263 by 1825, in his deed it's not recorded that he was owner of 263, then how could by virtue of that 263 be
So
sold?
far as the court proceeded on the basis of the record of rights.
No, not only that, Exhibit 5 was the deed of Sachindra.
That
Sachindra's
too, my
deed
lord,
and records of right both show that he was the owner of 263 by 1825. Therefore, your title in 263 was rightly disbelieved. And what about the other plot?
Other plot is
262 by 1824? The appeal
lord,
court proceeded on that.
kindly turn to page 9
Of appeal court?
Trial court.
Trial court, acha.
But it is in plot number last, my lord.
Yes, and other plot.
In other plot to, though the
No deed.
plaintiff could not any deed or two, they have purchased, acquired the share as well as Kunyo Bihari Sao. The plaintiff in their contention as well as the evidence establishes that they are in possession of 12 but it is settled principle of law unless they. Now the plaintiff submitted that the plaintiff by virtue of a registered deed which has been marked as exhibit from the legal heirs has already been that said was in the properties by virtue of registered deed of sale from Sachindranath Pal. On perusal, it reveals that the plot number has not been. The legal heirs of Sachindranath got no right to transfer. It appears that the foothold of the said in plot number 2 measuring an area of 20 has been mentioned. On careful exhibit, it appears that the plot has subsequently been, after registration of the deed, by virtue of plaintiffs have not acquired title.
So, these are findings of fact, and in any event, if the predecessor Sachindranath Pal did not have title in, you have shown nothing to show that he had title in 262 by 1824. And this is factual finding that court disbelieves it because it's inserted after. You are not interfering. The present appeal has been preferred, second appeal has been preferred against a judgment of affirmance, whereby the courts have granted, declared shares of the plaintiff in the suit property in the form of a preliminary decree of partition, comma, only partially, comma, less than the claim of the plaintiff. Full stop. Next para, the plaintiff's claimed title in respect of plot number 263 and 262 by 1824. Full stop. From the findings arrived at by the courts below, we find that the courts proceeded on the premise that Sachindranath Pal, comma, who was the admitted predecessor in interest of the plaintiff's vendors, comma, was the owner of plot number 263 by 1825, which is borne out by the title deed of Sachindranath Pal as well as the entries in the records of rights in the name of the said Sachindra. Next para, however, comma, on the strength of the transfer purportedly effected by Sachindra in respect of plot number 263 by 1825, comma, plot number 263 in its entirety was sold to the appellants, plaintiffs took appellants. Full stop. Thus, comma, the courts below came to the finding that the plaintiffs did not acquire title in plot number 263, comma, since the original owner Sachindranath Pal himself did not have title to the same. Full stop. Next para, insofar as plot number 262 by 1824 is concerned, comma, although the title deed of Sachindranath Pal did not contain the said plot, comma, apparently on the sale of transfer by Sachindranath Pal, comma, the said plot was also transferred in favor of the plaintiff stroke appellants by their vendor. Full stop. The trial court found comma, upon a perusal of the concerned title deed, that, comma, that is Exhibit 6, comma, that at the footnote of the schedule, comma, by separate ink, comma, plot number 262 by 1824, measuring an area of 20 decimal had been inserted. Full stop. The finding of the learned trial court was that the said plot number was subsequently inserted after registration of the deed and is a manufactured one to that extent. Full stop. Such finding was affirmed by the first appellate court. Full stop. Next para. Since the aforesaid findings are all findings of fact, comma, there is no scope of interference in second appeal with such concurrent findings of facts arrived at by both the courts. Full stop. Next para. Thus, comma, we do not find any substantial question of law involved. Full stop. Accordingly, SAT 171 of 2011 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. No orders to cause sergeant certificate. There is no connected application.
No connected application, my lord. One defect that should be rectified by myself, my lord, so far as the date of the
প্রথমেই করে দিন যে ওই on the prayer of learned counsel for the appellants, comma, leave is granted to the learned advocate for the appellants to rectify the memorandum of appeal to cure the defect as pointed out by the stamp. Thank you. কি ডিফেক্ট হয়েছে? হ্যাঁ, এটা 34 আছে। Yes, Mr.
Yes. Lord, the second appeal is against the judgment of affirmance.
Eviction.
Eviction.
Otherwise, you won't be briefed.
Lord, suit for eviction of a
Yes.
licensee. Lord, the lordship can see that the learned court below have an earlier occasion a suit for eviction was filed that claiming that I am a tenant at a rental of ₹7.
Shows the merit of your case. No, admitted to be a tenant.
Yes.
What happened to that?
That suit was not ultimately dismissed for non-prosecution because plaintiff was asked to show cause for several non-appearance and he failed to show cause. Ultimately, it was dismissed for non-prosecution. Made an application for adjournment, it was rejected and it was dismissed for non-prosecution. After Lord, long 11 years thereafter, the suit has been filed for eviction of licensee. Lord, that question was raised. The learned courts below have distinguished it that it is not barred by res judicata. Fresh suit is not barred because it is non-prosecution, not dismissed for default. And apart from that, the cause of action is separate. That is a suit for eviction upon termination of tenancy, and it is a suit for eviction of licensee. That apart, court below that predecessor in interest brought the suit. Now the present suit has been brought by the successors in interest against the same parties.
Previous suit was by the predecessor.
Predecessor. This ground, Lord, this has
that is second ground is a bad ground because he is bound by the.
Yes.
But there we cannot also say issue estoppel, Mr. Ghosh, because the issue was not finally. I mean, the suit did not reach final.
But so far, Lord, the tenancy, once admitted tenancy, thereafter suit has been filed. Lord, another thing that at the relevant time, Lord, one mud-built room with annexed veranda in this self-some property. That was the description of the property, same dak. Now, Lord, the entire property with 4 mud-built rooms. This is the distinction.
But did you prove any tenancy by any rent receipt or something?
By everything, Lord. That is that they admitted in the plaint.
In this plaint, they said you are a licensee.
Earlier plaint, Lord, they said
no,
that.
No, this plaint.
Yes, they have licensee.
So, did you produce any rent receipt to dispel that?
Lord, we have produced that this plaint where they admitted that I am a.
Apart from that, you did not produce any independent evidence to show.
Lord, we have been paying, Lord, the rent in the rent controller till now.
That does not prove tenancy.
Lord, kindly see
unilateral payments.
Lord, their admission in the plaint. Lord, one admission in the pleading, your lordship knows, it remains ever until and unless it is explained away. Lord, that judgment of Justice Vijay Mukherjee, Lord, the plaint come and go, but the admission shall remain over unless it is properly explained. The lordship kindly see, Lord, issue number 1, this has been decided. Lord, so far, whether the fresh suit is maintainable or not, that has been decided. And distinction, Lord, these are the distinction. The entire property now described in the schedule, earlier occasion, Lord, portion of the same property as tenant. It was described.
Plaint you have annexed somewhere.
But this
previous plaint.
No, I unfortunately in the statement it has not been annexed, but I can provide.
Do you have a copy of that?
Yes.
So, show us.
अच्छा copy, hello, fresh copy. Yes, Lord, kindly see. Lord, this is the information regarding the dismissal, and this is the print, copy of the print. Lord, kindly see the print.
You took an order 9 rule 9 plea. Your plea was order 9 rule 9, your defense.
And Lord, that the earlier occasion I was a tenant. Lord, kindly see the paragraph, first paragraph of the plaint itself. The earlier suit, paragraph 2. Lord, I have handed over. This suit not has been referred to in the judgment by both the trial court and the appellate. Description of the suit property from the schedule, Lord.
But your argument was on order 9 rule 9. You did not.
Everything that has not been considered. Your Lordship, kindly see, we have pointed out that we are a tenant.
No.
That is also ground.
No, Mr. Ghosh, independently also you could not, on their basis of their admission only in a previous suit, if you could not produce independent document to show that you are a tenant.
Lord, that is sufficient. Your Lordship has kindly rely upon that judgment of this honorable court that admission in the pleading, it shall remain forever. They have admitted me to be a tenant. Then I
Achha, where do we find that you have succeeded these people? They were the titles are also different. They were Taruk Dayal Mondol and plaintiff in title suit number such and such was Taruk Dayal Mondol.
Yes.
And defendants were Nabu Kumar Modok De. Mondol versus Modok De. And here,
Lord, that Taruk Dayal Mondol.
What the parties here in this?
Lord, your Lordship, from the judgment, impugned judgments, you will got it. You will get, your Lordship will get it. Lord, issue number 1 of the trial court, your Lordship, can you see?
Oh yes, you are in your cause title also.
Yes, also.
You are the heirs of.
Yes, of
they are the heirs of Taruk Dayal.
Yes.
And you are the heir of Pachu Gopal.
Pachu Gopal.
Pachu Gopal was a party.
Pachu Gopal was predecessor in interest.
Pachu Gopal was not a party to the previous suit.
No. Yes. No. Pachu Gopal expired at the relevant time.
No, in the previous suit he was not.
Previous suit we were parties along with other brothers.
Oh, you yourself were parties.
Yes. Other. Yes.
And you did not advance the argument that they were barred by estoppel or something like admission.
That is also there.
Where is that? It starts with that you have argued on this order 9 rule 9. You say the defendants have also emphatically denied that they are licensee under the plaintiff. You have denied as they were not inducted by predecessor of plaintiff, namely Taruk Dayal. So you denied being inducted under Taruk Dayal. Then how can you claim that to be tenant? Taruk Dayal admitted in the previous suit about this tenancy. You deny that you are inducted by him. So how can you rely on his admission?
Twofold difference. They also produced a record of right. Their names were recorded as riot. Lord, that matter is still pending before the LRTT regarding Lord the question of record of right. But Lord, clear admission in the plaint.
But this argument was not made in the trial court. We don't find it being advanced. Can you take a new point in this? This is a mixed question. If it's a question of admission in a prior suit, you only argued order 9, rule 9.
No, that has been recorded by both the courts below that your lordship will get it. The previous title number 27 of 2001.
Which page, Mr.
Page 10 of the trial court.
Trial court, yes.
The previous title number 27 of 2000 was for eviction of tenant and after termination of tenancy, whereas the present suit is for eviction of trespasser after revocation of license and first possession. The cause of action of this instant suit arose on and from 1st day of January 2010, and the cause of action of the title suit number circumstances arose after expiry of notice period circumstance. The courts were conscious. I pointed out that when admitted as a tenant, then how this can be done?
This second appeal will be heard on the following substantial question of law: whether both the courts below substantially erred in law in decreeing the suit for eviction on the ground that the appellants are licensees in respect of the suit property, in the teeth of an admission by the predecessor in interest of the plaintiff stroke respondents in an earlier suit, being title suit number 27 of 2000, that the defendants stroke appellants were premises tenants in respect of the suit property, without taking into consideration the principle of estoppel. This ground.
Application for stay of
There shall be stay of all further proceedings in title execution case number 80 of 2015 pending before the learned civil judge, junior division, additional court at Chandannagar, district Hooghly, in connection with title suit number 281 of 2014 till disposal of can 1 of 2024. First of the appellants shall serve copies of the application on the plaintiff stroke respondent numbers 1 and 2, indicating that the application shall be listed before the appropriate learned single judge, having determination subject to being mentioned by the parties. Thank you. We are adding a line, Mr. Ghosh. The question of imposition of occupation charges,
yes,
and if so, the quantum thereof is being kept open for being decided at the final hearing of the stay application.
Item number 35. To the applicant.
Yes.
If there is a delay, it is a judgment of reversal.
Appearing for the first time?
No, Lordship. It had appeared before the learned single judge. I have been subsequently inducted in the matter.
Copy was directed to be served.
Copy has been served, Lordship. This is the affidavit.
By a direction of court of the single judge.
Yes. There was a caveat later before mentioning before your lordships, we intended to serve the learned advocate. He had refused service. Thereafter, notice of mentioning was directly served on the respondent, lordship. This is the application for condonation of delay. There is a 79 days delay in filing the.
But then it should come before the learned single judge then.
This has not yet been admitted. I do not know why it is.
No, even then it normally goes before the single judge. But we take it up because we treat it to be application in connection with the appeal. But if a direction was given by the learned single judge, then Ms. Lahiri, I mean, they would be anticipating that it would come before the single judge.
I have served a notice of mentioning that I'm lordship's record. We have it. This is the notice of mentioning which was served on
give us a copy.
28th. It is also before your in your lordship's record, possibly.
Notice of mentioning এখানে থাকবে. Yes, yes. By email?
No, lordship. By register.
Speed post.
Yes, by post. The postal receipt original is there. Next.
Yes, it is with us also. For the original. This is the original, we'll keep on. What is the delay?
79 days delay, lordship.
Explanation?
Explanation, lordship. It is, I'll be candid, not very nicely worded, but it is that there has been delay in obtaining the certified copies of the respected from the respected courts. Lordship will have paragraph 2. And Certified copy of the judgment and decree dated 10/1/2024 was applied.
It starts with applied on such and such date.
Yes,
Applied within time. Acha, applied within time.
Yes.
Received and the copy of judgment such and such.
On 18/4/2024. That is the appeal court's decree, and thereafter the learned trial court's decree was subsequently applied, which I see was applied.
No, you could have filed with the appeal court's degree.
Lordship,
As
this is
no explanation. Will say.
Lordship, it was through the legal aid services, Lordship.
You file a supplementary affidavit.
I will file a supplementary.
On the prayer of learned counsel for the appellant, comma, leave is granted to the appellant to file a supplementary affidavit to the application for condonation of delay, furnishing further particulars of the explanation for the delay. Full stop. A copy, an advance copy thereof shall be served on the respondent, indicating that the matter shall be listed under the same heading on August 17, 2026, when a 17, 2026, full stop, the affidavit of service of the earlier notice and copy of the application filed to be kept on record.
I'm deeply obliged.
My lord, for the
Yes.
appellant, suit for declaration with consequence or relief of injunction, my lord, and judgment for reversal. Suit was dismissed, appeal was also not allowed.
Declaration of title and injunction.
No, my lord, declaration that marriage of jactitation is involved here. Marriage of jactitation of marriage is involved. That the defendant is not my wife. I want to submit before the learned court and for declaration in this part. Because one miscase has been filed by my sister, my lord. My own full-blooded sister preferred one miscase before me.
The acquisition of marriage can be filed before the district court. Doesn't it have to be filed? It's like a declaratory suit then.
Declaratory suit, my lord.
Then it has to go before the lowest.
Junior division. It was filed before the junior division court.
Oh, junior division.
Junior division.
Oh, this is second appeal, right?
Second appeal. Junior division.
So why was it dismissed by both the courts?
Both courts, my lord, dismissed. Kindly see, my lord, now the order sheet judgment of them, my lord.
Trial court judgment you have not annexed?
Yes, my lord. Both I have annexed, my lord. First, I have annexed the trial.
Yes, yes. No, trial court. Where is the trial court?
Both I have annexed, my lord.
No, certified copy, huh? Right at the order.
Certified copy. We have a certified copy there, my lord.
This is a photocopy. Find out the certified copy of the trial court judgment. Stamp paper did not see it. You please find out. আপনার কাছে সার্টিফিকেট কপি তো আপনার কাছে নেই ট্রায়াল কোর্ট না এটা তো দুটোই ফটোকপি please check up our file.
Yes, my lord, I'm checking my 1 second. It is copy.
You have to check up from our file.
Photocopy.
You check up from our file whether it is there.
Yes, my lord. It is your
Oh,
file.
that is with
Yes, my lord.
photocopy. You have to
Yes,
file the
photocopy
trial
of the
court.
trial court judgment.
File the trial court certificate copy as soon as you must be having it because you filed a photocopy. Or take it back from the first appellate court and file it. That's the certificate copy.
Yes, here is the certificate. She is keeping it. I'll give me leave, my lord, to exchange. Can you fix it tomorrow?
We find tomorrow you can file. You have it.
Yes, my lord, it's lying with us.
Hand it up. Hand it over. We'll take it. But you have to file a second judge's copy also. Oh, second judge's copy is there. Copy is there. Leave it. Copy is there. Copy is there. The certified copy of the certified copies of the judgment and decree of the trial court filed to be kept on record. Full stop.
Fine. As for me, my lord, in this matter, my lord.
Oh, one minute. We have not finished. Full stop. The defect in that regard be deemed to stand cured. Full stop. However, comma, we are surprised to find that there is no reporting as to such defect in the stamp reporter's report. Full stop. The stamp reporter is directed to be more cautious in future as to such omissions. Full stop. এইটা ফাইলটা স্ট্যাম্প রিপোর্টের পাঠিয়ে এটা a copy of this order be sent to the stamp reporter, be brought to the notice of the stamp reporter for the purpose of future compliance. এই ডিরেকশনটা অর্ডারই দিয়ে দিলাম, আপনি এটা দিয়ে দেবেন, বলে দেবেন। Yes, what is the matter?
Yes, my lord.
Why refused by both the courts?
Both courts refused, my lord, that by finding that we have not pleaded properly, or there is not a upon which documents we are mainly relying is our marriage certificate. I am also a marriage person, my lord, and my wife's name is also Lokhi Muchi, and the person who is claiming that I am her husband, I am denying, her name is also Lokhi Muchi. And now I have annexed one marriage registration certificate, and I have exhibited also. And the kindly see, my lord, the appeal court judgment first, my lord. Internal page.
So how did you show that this Lokhimuchi is not there?
Yes, my lord, she is my full-blooded sister, first of all.
Who?
The person,
This present defendant?
Yes, present defendant. Present defendant is my full-blooded sister, my lord. And what to say further, my lord? And my wife's name is also Lokhimuchi.
So how did you prove it?
Yes, my lord. I have I have submit documents, different documents before the learned trial court.
No, you produced a marriage certificate
Yes, my lord,
showing
marriage certificate.
Marriage certificate showing that Lokhimuchi is your wife.
Yes, my lord.
So how do you know that this Lokhimuchi is not that Lokhimuchi?
She was also deposed, my lord. So she was also a witness. My wife was also a witness as PW2 before the trial court, my lord.
And trial court believed your case?
No.
Believed your case?
Believed my case.
No, you are saying?
Both cases, my lord, suit was dismissed.
Oh, you said initially it was judgment of reversal?
No, my lord, judgment for confirmation.
Ah, confirmation. Let us see how the trial court proceeded. Her father's name is Sonnasi Das.
My father-in-law's name is Sonnasi Das, my lord. My father is Govardhan Muchi and my father-in-law is Sonnasi Das.
What is the name of the defendant's father?
Don't know. Govardhan.
Govardhan has to be Govardhan. If he's a full-blooded sister.
Yes, my lord.
What are you saying?
Such a.
She contested the suit?
No. Ex-party. Both
Why did you ask for this peculiar sort of a relief?
Yes, my lord. This is why. Because one miscellaneous proceedings under section 125 of CRPC has filed by my sister against me for claiming maintenance.
Trial court found that he did not bring on record any document to show.
Five witnesses were there, my lord.
That Lokhimuchi is your sister.
Yes, my lord. But from the pleadings I am submitting that whenever we revert that my father name is Govardhan Muchi and my defendant's father name is also Govardhan Muchi.
Acha. She produced any document?
No,
she never contested.
At both court, my lord, she has not appeared.
Your sister's name in the service book is reflected as Shikhamuchi.
No, my lord. Shikhamuchi. Lokhimuchi আছে এখানে আছে।
Shikhamuchi also
one other sister, my lord.
Another sister.
4 sisters, my lord. I have 4 sisters. না চারটে বোনও তো আছে।
But he did not produce any document to show that Lokhimuchi is your sister.
Yes, my lord. That I have also annexed it, my lord.
Which document did you produce? What document?
Annexed আছে।
Let us see what document you produced.
Copy কোথায়?
No, just tell us what document you produced.
I have
epic cards, these epic cards, the voter identity card and Aadhaar cards. So did you produce any Aadhaar card of the other side, defendant, Lokhimuchi? If not Aadhaar card, something else?
No, Chitra Muchi, Rita Muchi. I have submitted, my lord, original birth certificate of my 4 daughters and Aadhaar card of my own right now, who is my wife of Lokhimuchi.
That's your own family?
Yes, my lord. And I have only one document to show that Eastern Coalfields 8 that in my service book, my lord. In my service book, I am an employee of Eastern Coalfields Limited.
Yes.
And my kindly see second page, name Lokhimuchi, sister, and her date of birth was in the year of 1976.
Lakshmi's wife we find two
Now
places.
next wife after it, my lord, 1, 2, 3, 4, 5, 6. Column 6 is also there, my lord. 6 is sister. She is my sister. And that type of advantage is trying to take, my lord. My wife's name is Lokhimuchi and my sister's name is also Lokhimuchi. And another thing, my lord, at the appeal court, kindly see, my lord,
Yes.
page 4 of the appeal court judgment, my lord, that they are relying that I have filed one marriage register certificate, and in the year 2008, my lord, in the year 1988, I was married with my sister, my wife, and in the year 2008, it was registered, my lord. At that time, there was no scope for filing any photograph. Since 2010 onwards, my lord, there is a scope for filing affixing photographs. I have that.
So what was held by the appeal court?
That they held, my lord, the appeal court held that I have not affixed any photograph to prove that Lokhimuchi and is my wife. Her photograph is not annexed, but scope was not there at that time.
Where is the finding? Which page?
Yes, my lord, kindly see.
Internal page.
Internal page 4. My lord. Appeal court. এটা এখানে আছে যে এইখানটাতে আছে
This appeal will be heard on the following substantial questions of law. 1. Whether both the courts below, whether the judgments of both the courts below is tainted by perversity, inasmuch as the courts overlooked the vital evidence furnished by the plaintiff stroke appellant, including the Aadhaar card of his wife as well as his marriage certificate disclosing the identity of his wife, synonymous with his sister, the defendant, and a different father's name of his wife, as well as his service book where the names of both his wife and sister were disclosed, in arriving at the finding that the plaintiff has failed to prove his case that the defendant was his full-blooded sister and not his wife. Next, whether both the courts below substantially erred in law in not applying the doctrine of non-traverse, in view of the plaintiff stroke appellant having discharged his primary onus to prove his case, and in the absence of any rebuttal evidence thereto, in dismissing the suit filed by the appellant for jactitation of marriage. Any injunction application or any scope of any? No, can one, what is that was section 5.
It has been
Allowed.
allowed by the.
So we will direct you to put in paper special messenger costs and all. The appellant shall put in postal costs and requisite for service of notice of the appeal on the respondent within a week from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week.
No.
This legal aid.
No.
Within a week. Full stop. Next para. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, who is of liberty to mention the appeal for enlistment before the learned single judge having determination as and when the appeal is made ready for hearing. Yes.
For the appellant, plaintiff appellant, refusal of injunction against to have come. There's a section 5 application will not delay of 29 days.
Reason?
Reason is not that initially revision was filed by mistake.
Against injunction?
Injunction, refusal of injunction. Revision was filed mistakenly, but after getting legal advice, they have filed this appeal. Because of this, there is delay of.
Yes, Mr. Ghosh, what do you say regarding?
No.
But I appear for quoted 2 and 3.
What do you say regarding this? Well,
There's only one thing my lordship permit me before starting.
Yes.
Value is my lord 1,50,000 before the senior division. See my lord at page 13. My lord, I understand that the appeal should lie before the London district judge, my lord. Page 13, your lordship will find, my lord, of stay application, my lord.
Page 13.
1,50,200.
200.
200, I think.
1,50,200. Page 13 of
Plus 200.
Yes.
More than 1,50,000 probably lies before this court. The plus 200 is there.
Yes, sir.
Upon hearing learned counsel for the parties and perusal of the averments made in the condonation application, comma, we find sufficient explanation regarding the delay in preferring the appeal, inasmuch as, comma, due to erroneous legal advice, initially a revision was preferred instead of an appeal against the impugned order of injunction. Injunction was granted. Of refusal of injunction. Impugned order of refusal of injunction. Full stop. Accordingly, can 1 of 2026 is allowed, thereby condoning the delay in preferring FMET 155 of 2026, no orders to cost. Yes, what is that?
Suit for partition, along with the declaration note which I at the outset said, declaration regarding record of right is not maintainable. That declaration part note I cannot press. But so far as partition is concerned, my lord, coupled with injunction I have prayed. Now, case was that Nitai Chandra Ghosh was predecessor of plaintiff and defendants number 2 and 3. Defendant number 2 and 3 have sold a portion of their share to defendant number 1. One is making construction of a multi-story with a view to.
Defendant number 1 is the respondent number 1 also.
Yes. Respondent number 1. Yes, my lord.
As a preamble bereft of the name.
No, that has been rectified. Corrected.
Then carry on from where you stop.
Now, my lord, injunction, the court after hearing has refused the injunction. Now, in the 3-page order, my lord, the entire case of the plaintiff and the defendant have been set out. Only reason is 3 lines that I have gone through the judgments cited by the defendants being so and so, which squarely apply. Hence, injunction is refused. So, no reason. And the judgments, I am carrying the judgments which have been relied upon, they only say, my lord, that in a master-servant relationship, suit is not maintainable. So, no injunction is.
What master-servant?
This was a suit, my lord, in which the ratio was that a master-servant relationship, it is statutory, the bar under specific relief act, so suit will not lie. On that ground, the court held that suit is not maintainable, injunction cannot be granted.
How is that applicable?
Not applicable. Court says it squarely applies. This is the first judgment.
Squarely, but in a round hole.
This is the first judgment.
Oh, no, keep it with you.
So, this is the ratio of the first one. The second one is, my lord, a judgment of this honorable court where, my lord, parties were in possession of different portions, demarcated portions. One party was making development in his portion. Court has said that since he is occupying, although there is no partition by midst and bounds, injunction should not be granted. That was the ratio here. Possibly the line of judgments of our court that without claiming any equity, a person long in possession of a portion can develop subject to the result of the suit.
What injunction did you seek?
Here, my lord, I say that the defendant number 1 is a transferee, is a stranger who has come in the property. He is not developing the property. So, the defendants took the point that those deeds have not challenged. I say that even without challenging, because he is only acquiring a share.
But this is not a dwelling house, obviously, because he is making construction.
Making construction. Now, my lord.
The second 44 does not come.
No. The other points were not that they say that construction has been made. So, at this stage, no injunction. Now, he's going to alienate. We say that that should also have been prevented. The third point is that there is another partition suit, my lord, regarding some other property of the predecessor. So, they say another suit is pending. This subsequent suit is not maintainable, although this is regarding separate DAG number. It might be a point on merits, my lord, that whether both suits to be heard together or there should be one comprehensive
But then this is, here you have not brought in the hodgepodge the other suit subject matters.
No. That is
so then it is not maintainable on that ground also.
Yes.
So at this stage, it is not maintainable.
There are other parties also, my lord. Different parties.
You have not brought them.
No,
there are
suit, there's other parties. In this suit, my lord, since it has been sold to others, my lord, this, my lord.
So is it your stand that these are the only properties which are common between these parties?
No. My lord,
between these parties only there are other properties also?
Between these parties, my lord, other properties, but in this case, there's additional defendants who have been, my lord, transferred the property. So they become, my lord, new co-sharers of the property.
But then also same principle applies.
These defendants, my lord, do not, my lord.
Acha, one does not have share in the other property.
one does not have share in the other suit. So I cannot, if they take this point, I cannot try to defend on that ground the suit. It will go to the merit of the suit. But on that ground, court has not refused. Court has just recorded their submissions one by one, then said this judgment squarely applies. 4 judgments, I have gone through all, my lord, nothing applies at all to this case. The second is, I have already shown to your lordship. The third is, my lord, a Supreme Court judgment which says that if a co-sharer transfers his share, the new person, he only becomes a co-sharer, he doesn't become owner of a particular portion of a land. So this new inductee, he is, my lord, barred by Transfer of Property Act also from jointly possessing the land. Not a dwelling house, but not, he cannot construct. This is not settled law. That you can transfer the share, but no construction can be made. Now, these are the grounds taken without discussing anything. If a lordship now sees the order once, my lord.
Yes, we've seen the order. Nothing to
The
see.
judgments, my lord, doesn't apply at all.
Starts from I have carefully.
Now, I have to my lord, deal with the objections taken by them, because they have taken the first objection at page 64, my lord. Page 2 is that I have challenged the record of right.
Record of right, even without that, you are
Without
entitled
that,
to
I am
partition.
entitled to pray for partition. Then next paragraph is, they say that record of right has been finally published in the name of the, my lord.
That is still regarding the record of.
Record of
Does
right.
not create title.
Then the next objection is that multi-story building is already standing. So they have already constructed a building.
That is a very important consideration. If they have constructed up to a level.
Now if they will not alienate and now further bring
alienation, will consider.
There should not be further, my lord.
So you sought for injunction, restraining them from making construction. Only.
Yes, because at that point of time they were.
Then alienation will be going beyond the scope of the injunction application. First, the prayer, injunction prayer in the trial.
28 is the application for injunction.
28.
Without changing nature and character.
39.
39. Interfering with peaceful joint possession, changing nature, character, classification, and you should not ask for transfer. How can we widen the scope of the main injunction application in appeal?
No, there should not be co-sharers. Share can be transferred. I cannot say, my lord, there are co-sharers.
That also is. No, multiplicity for multiplicity maybe.
Multiplicity and construction, my lord, they are constructing. So maybe some portion has been constructed. It should remain as it is.
According to them, how far it has been constructed?
They say there are multi-story standing there.
Then, Mr.
The extent has not been described. Written objection.
Multi-story, even if more than one story, then why should we?
If it is standing, my lord. Now, if tomorrow, my lord, they will induct third parties. The
You have not asked for any injunction regarding that in that regard.
Regarding finishing, it is not their case that the building is complete and ready for sale in all respect. That is not their case. So it should remain as it is, my lord.
Yes, Mr. Ghosh, what is yours?
Lord, that suit, earlier suit, Lord, they are claiming to
There was,
Nitai.
yes.
To Nitai. Nitai purchased the share in the property. Lord, it is one dag.
No, you are for one.
I am for one. I am a transferee.
You don't have a share in
Pendency of that suit. In that suit, defendant number 2 is a defendant number 1. Lord, during pendency of that suit, I have been transferred. The new suit saying that it is a new plot, the same claim that we have 1/6 share in the property.
No, the plots are different in that.
They are different. But Nitai, through Nitai.
No, the plots are different. So regarding those plots, you have not purchased those plots.
No.
You have purchased a share.
Yeah. In that suit, Lord, this property.
But if you have purchased a share, you also become a co-sharer in regard to
in that suit. And that apart, Lord, kindly see the schedule of the property. Lord, kindly see the schedule.
No, certain dark numbers have been transferred to you.
Yes, Lord, kindly see the schedule of the property here also.
In that suit, he is not a party.
Lord, kindly see here in the paint also, paint schedule. Lord, kindly see out of 29 acres, 1.29 acres, he sought for partition in respect of 99. And he has said that there is multi-story building in that portion. And both the properties are covered by boundary wall. And construction has been made. Lord, kindly see.
The trial court had to deal with these, Mr. Ghosh.
That defect I have seen.
We will remand it to the trial court for consideration or reasoned judgment upon hearing both of them.
And Lord, kindly see this.
But if you transfer the property in the meantime, you are worried about that.
What?
If you transfer the property,
But they have not paid for. Lord, kindly see, admittedly they have not paid for. And Lord, that apart, This suit is also.
Status quo
but
regarding
for
nature and
not,
character as on
but only.
Not paid. We cannot.
no further.
We cannot broaden the scope of the appeal.
Well, kindly see this scheduled property.
Yes.
This is also part of the entire DAG. Entire DAG is not considered 1.29 acres. He has paid for partition of
Changing nature and
99
character.
decimals.
But in the prayer, changing nature character is there.
No, are you claiming? Are you opposing on the ground of order to rule 2?
But that also, my lord, all the entire property.
Yes, entire property is not.
But yes, it has not been partitioned. That part has also not been partitioned.
Mr. Ghosh's point is that even if some dags have been sold to him in the absence of any demarcation by partition by demarcation, meets and bounds, he becomes a co-sharer of the
co-sharer.
entire plots,
Yes.
entire joint property.
No, it is not a separate dag, my lord. He
Could not, cannot acquire any right in a separate dag.
The other suit is regarding other dags where he has not purchased anything, no share.
Dag in the absence of any specific demarcation by partition. I mean partition by meets and bounds. All the joint properties he becomes owner. But no.
In his deed, only this dag nam
yes.
is the demarcated
So
area.
for that suit is concerned, I'm not. Lord, kindly look like their schedule. This is the part of DAG number 115. 15 consists of not 1.29 acres. He has sought for partition 99 decimals, excluding not 32 decimals.
Yeah, that is not my share.
Yes,
I am not
it
the owner.
is not partitioned, and those have been made not pro forma. You also can.
For the decree of declaration, plaintiff said, no, he sought a declaration that he is co-sharer of undivided 19 decimal.
I have paid for only
What is it?
19
19, so many 19s? The misprint, page 24. Or after decimals,
Share.
19.
the computer went on a spree. So what should it be? Undivided 19 decibels.
19 decimal. That is my claim. My share
Once
after
2/6 share. Two plaintiffs, 2/6 share.
Yes.
They claimed that 57 decimals was purchased by the father and they have inherited.
Co-sharers of undivided, that is their share.
Yes, their share.
In the entire property.
No, the entire property is 1.29. Father purchased only 57. And he claims partition in respect of 99 decimals.
19, not 99.
99 partition from entire property has been shown on 99. It is also part of 1.29. Another part has been excluded. That has not yet been partitioned also.
No, the suit property, a scheduled property is the entire property. A scheduled property, page 25, Mr. Ghosh.
Lord, kindly see.
This is not the entire property.
No, kindly see, read the next page.
Next page is 26.
Page 40.
No, we are.
Plaint.
Plaint is at page 25, 26.
Yes.
You are reading the injunction application.
Next page. That is not next page. You will also get
Next page, yes.
Yes. Plaint.
On the west by rest 30 decimals.
Yes. But after 1981, with well protected, with brick built boundary walls and entrance from gate in the Panchayat Road face in southern front out up to 1.29 acres.
But you say that there has been no demarcation between this 19 and the 1.29. Therefore, all the
partition. That has also it should have been joined.
1.29.
If in respect of 99.
Page 16, paragraph 6, it has been stated Putdak measures 1.29. That is possibly he is on that. But the schedule says 99 decimal.
The schedule says 99 decimals.
No, kindly see paragraph 8.
Out of 1.29, you are admitting that total property is 1.29.
1.29.
That part has been excluded.
Oh, suit dag you are saying measuring more or less 1.29.
My predecessor purchased only 57 decimal out of the 1.29.
Yes, but you have to claim partition in respect of the entire property.
Entire property.
Your predecessor was also co-owner.
Yes. The schedule should have been 1.29.
It's bad for a non-joiner of all the joint properties plus all co-sharers in respect of the entire.
Let me I point to one thing.
Yes.
Earlier suit, an amendment application has been filed. This is the entire 1.27 in previous suit. Lordship, this my kindly.
You pointed out in your written objection in this suit.
This is subsequent. Subsequent.
then we cannot look into it.
Lord, the subsequent means before passing the order, injunction order, my lord, which is impugned before your
Something which is not before the trial
Lord,
court.
they have, my lord, suppressed even there is the application or in the appeal, my lord, about this amendment application. My lord. Even at the time of submission.
Mr. Banerjee, then we are not passing an interim order. We are just remanding it to pass an order. We'll record in a nutshell your arguments, both of you. Learned Counsel, the present, in view, the appeal is admitted to be heard on the grounds taken in the memorandum. Full stop, next para, in view of the short point involved, comma, we take up the appeal along with the application for disposal. Full stop, the Learned Counsel for the plaintiff stroke appellants argues that the impugned order is cryptic insofar as reasons are concerned. Full stop, by way of reason, comma, the learned trial judge only relied on certain judgments cited by the plaintiffs without adverting to the materials on record or the averments of the parties. Full stop, even the said decisions, comma, it is submitted, comma, do not pertain to the issues involved in the suit and do not have any application at all. Full stop, next para, learned senior counsel appearing for the learned counsel for the appellant further submits that although a previous partition suit is pending, comma, the same is in respect of other plot numbers where the respondent number 1, comma, who is a subsequent purchaser from the original co-owners being the respondent numbers
Even number 2.
2 and 3.
2 and 3.
2 and 3,
Yes.
comma, is not an owner. Full stop, thus, comma, it is submitted that the present suit is very much maintainable even without bringing the plots, comma, where the respondent number 1 is not owner, comma, keeping outside the hodgepodge. Full stop, next para, it is further contended that in the event third party interests are created, comma, since admittedly a multi-storied building has been constructed by the respondent number 1 over the property, comma, the interest of the plaintiff's appellants would be prejudiced and they may suffer irreparable injury. Which of next parallel, senior counsel appearing for the respondent number 1 points out that in the absence of any partition by meets and bounds between the different properties situated in the DAG numbers covered by the present suit and the earlier suit, comma, the present suit is bad for non-joinder of all the joint properties between the parties as well as for non-joinder of the other co-sharers as necessary parties. Full stop, next para, learned senior counsel further submits that from the Schedule A property as mentioned, as described in the plaint of the present suit, comma, it will be evident that the total area of the suit property is 99 decimals, comma, whereas in paragraph number 6 of the plaint and in other places, comma, the total plot has been described to be of 1.29 acres. Full stop, thus, comma, it is argued that the suit is bad for partial partition as well. Full stop, next para, that apart, comma, learned senior counsel points out that no injunction has been sought in the trial court regarding transfer of the property and, comma, as such, comma, the same cannot be argued before this court. Full stop, next para, learned counsel appearing for the respondent numbers 2 and 3, comma, apart from the adopting the arguments of the respondent number 1, comma, submits in addition that subsequent to the impugned order, comma, an amendment application has been filed in the earlier suit for partition filed by the plaintiff stroke appellants with regard to other plot numbers seeking to incorporate the DAG numbers, plot numbers, which are the subject matter of the present suit as well. Full stop, thus, comma, the second suit, that is the present suit, is not maintainable. Full stop, next para, upon consideration of the arguments of the parties, comma, we restrain ourselves from entering into the arguments on merits for the simple reason that the impugned order is as cryptic as can be regarding reasons. Full stop, after narrating the respective arguments of the parties and the judgments cited, comma, the learned trial judge, comma, by way of purported reasons, comma, merely recorded that the learned judge had carefully gone through the citations and found those squarely applicable in the instant situation and therefore the prayer for temporary injunction was liable to be rejected. Full stop. Next para. We find such finding to be patently perverse and cryptic, since none of the pleadings of the parties and or the materials before the court were at all adverted to or discussed, thereby the learned trial judge shirking the duty cast upon the court while deciding an application for temporary injunction. Full stop. The impugned order cannot be sustained on such ground alone. Full stop. Next para. Thus, since we intend to remand the matter to the learned trial judge, we abstain from making any observations on the merits of the case which might have the effect of prejudging the issues to be considered afresh by the learned trial judge. Full stop. In view of the above, FMAT 155 of 2026 is allowed on contest, thereby setting aside the impugned order bearing order number 18 dated January 8, 2026, passed by the learned civil judge, senior division, first court at Barasat, district North 24 Parganas, entitled suit number 1102 of 2024, and remanding the temporary injunction application to the learned trial judge, for being re-adjudicated on merits, upon giving a fresh opportunity of hearing to both parties on the materials already on record. Full stop. The learned trial judge, upon such fresh hearing, shall pass a reasoned order deciding the injunction application. Full stop. In view of the time, in view of the considerable time having already elapsed,
and further materials.
it is expected that the learned trial judge shall complete such fresh adjudication as expeditiously as possible, positively within 6 weeks from the date of communication of this order to the learned trial judge.
Only this will not prevent me from not amending the plaintiff if necessary, because I have a right to not make amendments.
Very well. We make it clear that nothing in the above order shall preclude the parties from making any further interlocutory application, for amendment of plaint or otherwise, and from objecting thereto, if filed by the other side. Can 2 of 2026 is consequentially disposed of as well, no order to cause urgency. Appeal this.
Defendant is the appellant before your lordship. I have come up against an order of remand, open remand. My lord, since this issue relates to res judicata, may I just place the brief facts? Prior to this instant litigation, we were 4 brothers. My client had instituted a suit for declaration that the mother is the benamdar. Court, upon thorough scrutiny of evidence, found that there was a relationship of trust, and the exception carved out under the unamended provision of the 1988 Act decreed the suit. No appeal preferred, that attained finality. Now the brothers come up.
Benami in the name of the mother actually belongs to you.
Me.
The present defendant number 1.
Present defendant. Yes, sir. Now the brothers, they institute a suit for partition.
That was never challenged.
No, that was never challenged. The brothers institute a suit for partition. The learned trial court holds
on the demise of your mother.
Yes, on the demise of my mother. And on the learned trial court holds that this suit is barred by res judicata. Against that, they prefer an appeal. The court goes into the appellate court, goes into the correctness of the earlier judgment and remands it. That's my case with your lordship.
What does the court hold by going into the correctness?
Kindly takes
bad according to the appellate court.
Appellate court, my lord, court goes into, first of all, my lord, court goes into the recent amendment that has gone into. My lord, in 2015, this amendment has says that this has a prospective application. This has a retrospective application.
What amendment? To which case?
My lord, section 2(9) has been amended.
Of?
The Benami 90.
Oh,
Now that, my lord, I have an arguable case whether, my lord, to which part it is as a retrospective application, because it's not a penal provision. Now it has been held that the penal provision might have the penal provision, it's a declaratory act. Now whether it will at all have a retrospective effect or not. That's one part of my argument.
Yes.
And the second thing, my lord, the court could not have.
Copy of the text.
Yes, yes.
একটা কপি করে দিন, একটা দিন।
Your Lordship would kindly take the pain of looking at the amended section 2.9. 4.3 is no longer there. My Lord would first take into consideration 4.3. This is no longer there in the amended.
Yes.
4.3 is no longer there. Now section 2.9 has been incorporated. Kindly takes Benami transaction 2.9a, b, and certain exceptions have been carved out. Now the court holds that since in view of this exception 2, my lord, I couldn't have brought the suit against the mother.
That was previously brought.
Yes, that was previously brought. That's why.
Decree. It was even decreed before this.
Yes. Kindly takes the earlier decree once. May I just place the record?
Acha.
And this amendment came into force since 2016.
So the first appellate court took into consideration this amendment, virtually held it to be retrospective.
Yes.
And reopening your previous decree. Since the present appeal has been preferred, now although the present appeal has been preferred against an order of a judgment of remand, comma, since the appellant seeks to assail the same on merits as well, comma, we formulate the following substantial questions of law for hearing the appeal. Colon দিয়ে, Roman 1, whether the learned first appellate court substantially erred in law in applying the amended provision of section 2 within bracket 9 within bracket Roman II, within bracket small ii, of the Prohibition of Benami Property Transactions Act 1988. Whether কি বললাম, whether construing in applying in না অ্যাপ্লাইং না করে কনস্ট্রিং করে, কনস্ট্রিং তারপর যা বলেছি সেন্টেন্সটা কন্টিনিউ হচ্ছে, টু হ্যাভ retrospective effect, comma, thereby virtually invalidating a decree obtained by the appellant under the unamended provisions of the said act, comma, which had already attained finality prior to the introduction of the amendment to the act. Roman 2, substantial question, whether the learned first appellate court transgressed its jurisdiction in sitting in judgment over a decree passed in an independent different suit, comma, which has already attained finality in the absence of any challenge thereto. Roman 3, whether the learned first appellate court substantially erred in law in reversing the dismissal of the suit by the trial court on the ground of res judicata on considerations extraneous to the subject matter of the dispute. Yes. Ever interim order. What?
Since it's an open remand, my lord, I am seeking a stay of the.
There shall be stay of all further proceedings in title suit number 03 of 2021 pending after remand before the learned civil judge bracket senior division first court at Uliberia district Howrah till disposal of can 1 of 2026. The appellant shall serve copies of can 1 of 2026 on the plaintiff stroke respondent numbers 1 and 2. It was a partition suit.
Yes, partition suit.
Acha, on the plaintiff stroke respondent না করে on the respondents indicating that the application shall be listed for hearing on in the monthly list of September 2026 when an affidavit of service to that effect shall be filed by the appellant. Stop. Next para. The appellant shall put in postal costs and requisites for service of notice of the appeal on the respondents within a fortnight from date. The trial court record shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a fortnight. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate on record for the appellant.
My lord, only one thing, my lord. 29A1, not 2. My lord, it was my mistake.
ও আচ্ছা, যেখানে রোমান আই বলেছি ওখানে একটাই 29A1
A1
A small a ব্র্যাকেটে তারপর ব্র্যাকেটে I
না ক্যাপিটাল এ রশিদ ক্যাপিটাল এ
হ্যাঁ হ্যাঁ এইটা তারপরে 9 তারপর A then B2
then B1
after capital A then
after capital A B1 a korta or a member my lord has
not two
not
person
to that
standing in
yes,
financial
yes. But court has quoted my lord this one, that's why I'm saying my lord. Kindly takes the impugned judgment once my lord for
B1 has been quoted.
Yes, B1 has been quoted, but you ought to have quoted B2 at all man. If it
A তারপর small b
yeah.
Yes. ওই বইটা ফেরত যাবে
আমার বই তো
Item number 39.
My lord, I am for the appellant defendant.
Yes.
My lord, there are two applications, my lord. Can one is my application for condonation of delay of 39 days, my lord.
Reason?
Reason, my lord, that the advocate was, my lord, he'd fallen sick. That is what has been pleaded.
My lord, only thing, generally do not oppose. My lord,
Everybody who opposes starts with that.
My lord, generally, my learned advocate has appeared in the matters, and my lord, affidavits have been affirmed. I have those copies
during this relevant period.
Yes. But in connection with the matters between these parties,
which advocate has
same parties,
different advocate.
File an opposition and disclose those.
That was advising.
Period of delay is not important. Quality of explanation.
No, my lord, I am given to understand that no specific advocate has been named, my lord, as to who was sick. My lord, I don't know which advocate is, my lord.
Cannot take advantage of that. You have to put it to someone. Where is your explanation? Advocate on record, you say.
Well,
Unfortunately, the learned advocate on record.
Give me a copy of.
You yourself don't name the person, and then you
give
take advantage of that. You cannot do that. Who was the advocate on record? Disclose that.
Just
keep it with you. I mean,
just a moment. Give me a copy of. Give me a.
Who was the advocate on record?
My lord, just a moment. This is the objection.
Don't disclose now. Let them name the advocate on record.
No, my lord, we will. Show me. Just show me can.
Record that.
Yeah, copy of can one.
And then direct you to file opposition.
ये फाइल दे दो आप.
अरे कागज ना लाओ. Yes, my lord, if your lordship considers, my lord, can one.
Just name the advocate on record whom you have meant here. We'll record that and we'll record that.
Yes.
You have to name someone.
Yes, my lord.
Who was the advocate on record?
Who was appearing? Who was unwell? Listen.
So long practicing at Delhi.
Doesn't matter.
No, not. We are not.
The name of the senior advocate who might be.
Use a supplementary affidavit.
Can't be.
Since this point has been taken.
This kind of plea can't be.
The Lakmani, it's on the quality. It's serious then.
My lord, maybe file a supplementary affidavit.
Yes, do that. Do that, disclosing the name, and we'll give an advance copy. How soon can you file that? You have to disclose the name of the advocate on record.
1 week. My lord, within a week's time.
Give an advance copy. We will direct them to file a composite affidavit in opposition to this and that. Within another week, Mr. Bondabhat. We won't give much time because this will get delayed unnecessarily.
My lord, can 2, my lord, is my application for stay. Lord, yes, unless your lordship.
At the outset, learned counsel for the respondent takes an objection to the condonation application on the ground that although the illness of the learned advocate on record of the petitioners has been cited as the reason for the delay, the learned advocate who was appearing on behalf of the appellant had comma during the relevant period, comma appellants had comma during the relevant period, comma appeared in other matters and filed affidavits in the in litigations between the self-same parties.
Can I
So
name
next para, at this comma, we find that no particular learned advocate has been named as the advocate on record in the condonation application. Full stop. On the prayer of learned counsel
Can I
for
give
the
the name?
appellant, comma, we grant liberty to the appellant.
Can we give the name, my lord? It's the name has been, my lord, obtained from the records. We can, my lord, on instructions, my lord, I'm saying that we can name the concerned gentleman. This may cut short, my lord, because, my lord, we want to, my lord, press our.
You'll record it then, Iraro.
Yes, my lord. This is, my lord,
In the
Mr.
prayer of the
He's a senior advocate. Says Mr. I just handed over, my lord. I don't want to.
Mr. Shamul Baron Chatterjee.
What is the name given there?
Mr. Shamul Baron Chatterjee.
Spelling of Shamul?
Shyamal.
Usual spelling. Kumar Chatterjee.
Baron. Baran.
Chatterjee.
Baron Chatterjee.
Separate. Baron is separate.
Yes, my lord.
Very well. At this comma, learned counsel appearing for the appellant, comma, on instruction submits
Don't take this
that
lightly.
the name of the learned advocate on record mentioned in the condonation application was Mr. Shyamol Baron Chatterjee. Full stop. Next para.
My lord, may I just clarify? My lord, the advocate referred to who was ill is Mr. Shamol Baron Chatterjee. That's the.
There is a little confusion, Your Lordship.
You cannot.
Little.
Your Lordship, one second. I was advocate on record at CT court.
Very well. We'll say the learned advocate record referred to in the condonation application করলাম না দেখো তো এর কিছু বললো at this learned counsel for the appellant submits instruction that the learned advocate on record quote unquote mentioned in the condonation application is Mr. Shamul Baron Chatterjee, comma, on the ground of whose illness the condonation has been sought. So we are making it very specific. Full stop.
We will give this.
In view, next para, in view of the objection taken by the respondent, comma, the respondent is directed to file affidavit in opposition to Can 1 of 2026 within a week from date. Push of reply thereto, comma, if any, shall be filed. How soon can you file reply, Mr. Lakmani? Mr. Lakmani, how soon can you file reply? 3 days.
My lord, may I just say one thing? My lord, kindly do not record, my lord, any name. My lord, I'm a little embarrassed. I'm very sorry about it.
Understood.
My lord, kindly, my lord, allow us to file a supplementary affidavit and, my lord, take it thereafter. It will, my lord, inure to, my lord, the benefit of all my colleagues appearing. I'm very sorry.
We understand. At this second. But then you will change the name, Mr. Lakhan. This is also not proper. Someone you referred to here.
Lord, there seems to be some confusion, my lord, between the between our team, my lord, as to, my lord, who had fallen, my lord, sick. It's better, my
at
lord.
this juncture, comma, learned counsel for the appellants seeks liberty to file a supplementary affidavit to disclose the name of the learned advocate whose illness has been cited in the condonation of delay application as the reason for the delay. Full stop. Liberty is granted to the appellants to file such supplementary affidavit within a week from date with an advance copy to the learned advocate on record for the respondent. Full stop. A composite affidavit in opposition to the condonation application as well as such supplementary affidavit shall be filed by the respondent within a week thereafter. Full stop. Reply thereto, if any, shall be filed within another week from therefrom. Full stop. Next para. List the matter in the monthly list of September 2026 under the same heading.
Monthly. My lord, maybe file our affidavit, my lord, of service, my lord.
Affidavit of service filed to be kept on.
Both Can 1 and Can 2.
Affidavits.
I'm sorry for the inconvenience, my lord.
This happens, Mr. Lak. All of us have been through it.
Item number 40. I appear on your lordship.
Yes.
This is against an order of remand, your lordship. The suit was initially filed by the plaintiff.
Use a microphone.
The suit was filed by the plaintiff.
Injunction has been granted.
No, it's not injunction, remand order, Your Lordship.
Oh, sorry, remand, yes.
Suit was filed seeking a declaration that my predecessor in interest is the ex-tenant of
Yes.
the plaintiff. Suit was dismissed.
Permanent injunction.
And permanent injunction.
Dismissed.
Suit was dismissed.
You sought for a declaration that your predecessor in interest was a.
The plaintiff sought for an interest. I am
You were the defendant.
Defendant, Your Lordship.
The plaintiff sought for a declaration that his predecessor was.
The defendant's predecessor was the ex-tenant. He was the original defendant.
Did not seek any declaration regarding you.
No.
Achha, then his predecessor was alive.
Alive.
Is it?
He was alive. The suit was dismissed. The landlord.
Plaintiff is a landlord.
Plaintiff is a landlord.
Landlord filed a suit for declaration that the defendant was
an ex-tenant.
And sought for eviction also.
And injunction, permanent injunction, by which he meant eviction.
How can you mean that? Let us see the plaint.
And that plaint.
That was decreed.
No, that was dismissed.
Obviously. We also feel like dismissing it. Have you got a copy of the plaint? Should have annexed it somewhere, Ms. Ghosh.
At that point of time, I did not have a copy of the plaint. I have a copy of the plaint now, Your Lordship. This is the plaint, Your Lordship.
You not have drafted it then. You did not draft it also. Really. No. Ex-tenant বিবাদীকে উচ্ছেদ ও বহিষ্কার মতে উক্ত premises suit for eviction on the declaration that ex-tenant.
It was dismissed.
Very.
The landlord preferred an appeal.
Okay, we are keeping yes.
The landlord preferred an appeal. Appeal was sent on remand. During the pendency of the appeal, the original defendant died. His heirs were substituted.
You.
We. Upon remand, one of the son was already contesting on behalf of the father, defendant father, as his power of attorney holder. When the suit was remanded, he continued to take steps, though the father had died and the legal heirs were already brought on record.
He was also brought on record.
He was also brought on record in the appeal. But when it came back in the trial court, no further substitution took place. None of us were made parties thereto.
In the suit, you were not implicated.
No. A decree was passed against a dead person. I filed an appeal. In that appeal, the decree was set aside.
I is appealing for the dead person.
That in the appeal, Your Lordship, the decree was set aside, holding that it is remanded again because only it is a technical defect which can be rectified. And on that order, I am before Your Lordship. My Lord, that is the appeal court's holding. He sets aside the decree, saying it is a nullity because it is passed against a dead person. But remands it, saying it is only a technical fault and it can be rectified. The decree can be rectified upon giving a chance.
Although the appeal has been preferred against the judgment of remand, since the defendants appellants seek to assail the same on the merits as well, we formulate the following substantial question of law for hearing the appeal. Full stop, colon, niche substantial question ta hocche whether the learned first appellate court substantially erred in law in remanding the suit, instead of allowing the appeal outright by holding the decree, passed in the name of a dead person, to be a nullity, the suit having abated in the absence of impediment of the appellants as heirs and legal representatives of their predecessor, the original defendant. One question. Any interim?
Yes, Your Lordship. Can one I have filed, Your Lordship? I filed
temporary injunction.
Injunction not to dispossess and stay of the suit. Stay.
Very well. We'll stay the suit has abated. We have.
I had passed in a to stay of operation of the impugned judgment and decree. That's what I.
That is better. Since the appeal has been admitted on the issue whether the suit from which the same arises abated, comma, instead of granting stay of all further proceedings in the suit, comma, there shall be stay of operation of the impugned judgment and decree till disposal of Can 1 of 2026, full stop. The respondent shall also remain restrained by an order of injunction from disturbing the peaceful possession of the appellants in respect of the suit property, except by due process of law, till disposal of Can 1 of 2026. Full stop. The appellants shall serve a copy of Can 1 of 2026 on the respondent, indicating that the application shall next be listed in the monthly list of September 2026. Ms. Dotto, please take this back and please keep sufficient copies of this at the time of hearing. 3 copies at least, 2 for us and yes.
Gratefully, Your Worship.
I'm for the petitioner, plaintiff suit for specific performance, rejection of an ad interim injunction. 17 lakhs was the consideration money. I paid 11 lakhs and I asked for the mother deed, my lord, kindly provide me. They did not provide and now they are trying to sell, my lord. I filed the suit. The trial court, my lord, observed that I have a good case for trial but failed to grant any ad interim injunction.
Why?
My lord, no reasons, my lord.
The deed is registered?
Yes, no, agreement for sale.
So agreement is not registered.
Not registered.
No, insufficiently stamped also.
Insufficiently stamped.
Anyway, that if that was not
Yes,
considered
my lord,
later.
And the next date is on.
No, court says there is scope of sufficient clarification. What else?
Yes, my lord. What clarification, my lord? I have the plaint, I have annexed the
This
plaint.
requires clarification. This observation requires clarification. Let us see the previous paragraph. The appeal is admitted and shall be heard on the grounds taken in the memorandum of appeal. Full stop. We find from the impugned order that the learned trial judge, despite holding that the plaintiff stroke appellant has a good case for trial in the suit for specific performance filed by the plaintiff stroke appellant, refused to grant ad interim injunction on the sole ground that at this stage the prayer for injunction is liable to be heard in the presence of the other side. Full stop. Next para. Even otherwise, from the materials produced before us, these were a part of the trial court record.
Yes, ma'am.
Which were also before the trial court, we find sufficient prima facie case for injunction having been made out. Full stop. Next para. Accordingly, the respondents and their men and agents shall remain restrained by an order of injunction from selling, transferring, alienating, and or creating any third-party interest in respect of the suit property till disposal of Can 1 of 2026. The appellants shall serve copies of the application on the respondents, indicating that the same shall be listed for hearing in the months of September 2026, when an affidavit of service to that effect shall be filed by the appellants. Full stop. The appellants shall, within a fortnight from date, put in the postal costs and requisites for service of notice of the appeal on the respondents. Full stop. Trial court records we are dispensing with, or
it can be. I have
no, it was ad interim refusal. These are the only documents.
Plain 10.
The trial court records need not be called for. Full stop. This much at this stage.
The only thing, there was a defect. I found that the name of the learned judge has not been.
That is a defect.
Yes, ma'am.
Let's take up whether there is any other defect. Yes, you know the name now. You can furnish today.
I can.
প্রথমেই একটা তাহলে সবকিছুর আগে on the prayer of learned counsel for the appellants, leave is granted to the learned advocate on record for the appellants to insert the name of the presiding officer of the trial court, against whose order the present appeal has been preferred, in the preamble to the memorandum of appeal, during the course of the day. Please make that correction. Yes.
Right.
Thanks.
42, my lord, I am for the appellant, my lord.
Yes.
Plaintiff file a suit for declaration and injunction, and also filed an application under order 39(1) and 2. My lord, learned judge has not considered my 39(1) and 2. My lord, only on the ground that since regular PO has retired, regular PO, presiding officer,
Yes, yes, we understand.
has already retired, therefore regular PO is not available. That's why my injunction application has not been considered. My lord. It is passed by the learned chairman, learned Walk-up tribunal, my lord. Since there is a provision for appointment of a chairman, but my lord said there is a chairman designated at district judge, but he hold the post as chairman in charge. He is a officer of the court, my lord. He is a senior division, my lord. My respectful submission, he has every right to consider my application.
He is a civil judge senior division.
Yes, my lord. It is hold that he has a rank of the civil chairman in charge, being officer of the cadre of the civil judge senior division.
No, it has to be from the rank of a district judge.
District judge. That is
this civil judge senior division does not have jurisdiction.
No, my lord. Only Walk-up tribunal 183.
What is the composition?
My lord,
forgotten. I put the district judge. It is senior division. Senior division which district judge level to know.
Walk-up Act. এটা নতুন অ্যামেন্ডমেন্ট অ্যাক্ট। Four, my lord. 4A.
Walk-up board for it. Walk-up board. The walk-up board. But this would be a quorum non-judice without a district.
No, my lord. There is another two members is there, my lord. That is the order of this court. If my lord, then your lordship.
What sort of injunction did you ask? Satisfy us on merits?
My lord, kindly see merits, my lord. I am the Motwali of the Walk-up state. I am managing the Walk-up state, and we are cultivating the said land. The respondents are disturbing my position, my lord.
Regarding possession, what proof have you given?
For cultivation, I am cultivating the land.
What proof have you given?
My lord, injunction application, page 44, my lord.
Any document you produced?
Yes, the record of rights I have produced, my lord. Annex P2, page 44.
By the impugned order, an injunction application filed, a prayer for ad interim injunction made by the plaintiff stroke appellant before the Walk-up tribunal was not granted, which is deemed to be a refusal, on the ground that the chairman in charge, being an officer of the cadre of civil judge senior division, was of the view that he did not have jurisdiction to pass any effective judicial order in view of the mandate enshrined in section 83 of the Unified Walk-up Management, Empowerment, Efficiency and Development Act, 1995. Which of next parallel counsel for the appellant submits that in view of the concerned judicial officer acting as the chairman in charge and the other two members, comma, that is the majority members of the Waqf tribunal being present, comma, it could not be said that the said tribunal was a quorum non judice within the contemplation of the statute. Full stop. Moreover, comma, on the basis of the materials on record, comma, it is submitted that a sufficient prima facie case for ad interim grant of injunction was made out. Full stop. We find from a plain reading of section 84 within bracket 4 of the 1995 Act that it is arguable as to whether merely because no district judge is present on the relevant date, comma, despite a civil judge senior division having been put in charge of the tribunal, but the other two members being present, comma, the tribunal is rendered a quorum non judice to pass ad interim orders even in urgent cases. Furthermore, comma, from the materials annexed to the injunction application filed before the tribunal and the averments made therein, comma, we find that the prima facie possession of the premises of the appellant as a in the capacity of a mutwali has been established, comma, justifying the grant of ad interim protection to the appellant. Full stop. Accordingly, the appeal is admitted and shall be heard on the above questions and the other grounds taken in the memorandum. Full stop. The respondents and or their men and agents shall remain restrained by an order of injunction from interfering and or disturbing the peaceful cultivation of the suit property by the plaintiff stroke appellant till disposal of Can 1 of 2026. Full stop. The appellant shall serve copies of the memorandum of appeal as well as the application on the respondents, indicating that the application shall be listed for hearing in the monthly list of September 2026 when an affidavit of service to that effect shall be filed by the appellant. Take back your.
Number 43. May I please, Your Lordship, I appear for the appellant.
I appear for the respondent number 10. Yes, yes.
I appeal for the respondent number.
You for the appellant, yes, Mr. Chatterjee, yes.
Yes. Milord, this is against the refusal of an ad interim order. This is a partition suit. We prayed for an ad interim order. The parties against whom it was sought, they filed an application seeking adjournment on that date. That adjournment was granted. Our ad interim was not considered, Milord. Now, the urgency, Milord, I will just indicate. Milord, what we want from your Lordships, Milord, is that, Milord, pending the partition suit, we want an amount which is being ad hoc released as land acquisition compensation in favor of one of the 5 branches of the larger family, that to be secured. Now, there is a partition suit. The plaint, there are 3 schedules, A, B, and C.
Partition and accounts.
Partition and accounts. Partition by mids and bounds.
All right.
Now, Milord, one of the properties forming subject matter, Milord, of Schedule C, a part of that had been acquired by the state. Proceedings continued, and Milord, it went up to the Supreme Court. Supreme Court directed that money should be disbursed to defendant numbers 3 to 6, because the defendant number 3 to 6, who are also respondent number 3 to 6 here, they represented before all the courts all along that they are the exclusive owners of the property. So thereafter, Milord, other branches intervened, and then the Supreme Court had said that the money should be secured with the registrar. I mean, sorry, the deference court, which will be the district court. Now then, Milord, another modification application was preferred. By virtue of that, Supreme Court said that ad hoc 25% be released subject to an undertaking that if it is found upon apportionment that excess money has gone, it has to be Milord, refunded with interest. Now, my lord, there is a partition suit pending, my lord. We filed this application saying, my lord, that the money that has been directed to be released is between the state and the family. So that money, once released by the reference court, that may be secured in the partition suit, my lord, for two reasons. One, my lord, is that admittedly the partition suit is pending. My lord, number two, there is an admission on the part of those defendants, defendant numbers 3 to 6, in their written statement filed in the partition suit itself, that 34 decimals out of 54 decimals in aggregate had already been sold at their instance in an execution sale by this honorable court, where it was held by this honorable court that it is them who represented before the honorable court that the property belongs to them exclusively. Interventions were made by some of the branches, my lord, and then our rights and in the property, they were reserved, and it was said that it would be subject to outcome of the partition suit. So now at present, my lord, the urgency is this: there is an antecedent of these defendants. They have sold the family properties in the past. If the money being, my lord, a liquid money, if that goes to them and that is not secured, what we want, my lord, is to be secured. We do not want the money.
Mr. Chatterjee, where is the prayer portion of your injunction application? Which page?
I shall.
Trial court's injunction application.
Trial court injunction application.
The prayer portion.
Yes.
158.
You are also there.
Sorry, I am for the respondent number 10.
You standing this side. Mr. Ali Bhai is standing this side.
But I would say, it's a partition
Pollution
suit.
is too evident.
80% are together.
Because the 4 branches are in favor of this court.
80%
Who is
one branch
against 20%.
Everyone is a defendant.
Oh, Acha? No. That's a new proposition. Can't be. You don't believe that. Yes, which part of it you are insisting upon? Mr. Chatterjee, page 158.
Yes, my lord. Page 158, my lord.
Yes. Everybody is a plaintiff does not mean everybody is an appellant. Who is aggrieved is an appellant. The other person is a respondent.
My
If
instruction
you are
is,
appellants, then nobody will be there to oppose.
my instruction is, my lord, all other respondents except respondent number 3 to 6 are supporting us.
Apparently so.
Yes, my lord, the first relief, my lord.
Very well, yes. Mandatory injunction directing to deposit before this. Anyway, to secure that amount, either to debit, please put it in an account or whatever.
It may be secured.
So that was refused by the trial court. Let us see how. Oh, you said
not considered.
Not considered. What was the 151? What was the 151 application which was before the court also? Today is fixed for filing counter affidavit and WO in respect of 151. That's the impugned order 46.
151 was an application filed by one of the defendants, my lord.
The others, apart from
others. Lord, so far as my part is concerned, it is recorded subsequently. I am the plaintiff. Plaintiff also files an application under Order 13 Rule 1 and 2 CPC through affidavit copy served. And then
defendants 7A to 7E files written of the that's different. It's a confusion among the two applications.
Yes. And then had considered prayer
as a deemed refusal.
Yes,
deemed refusal. They have already withdrawn that. It's in the reference court now, according to you.
No, since the Supreme Court had directed the money to be released, the reference court had said that there is no other option but to be released. Article 227 was filed against that order. That also was rejected. Was not interfered insofar as the release is concerned.
Very well. We will admit the appeal definitely. Let us hear the other side. If you can dispose of the appeal now. Let us hear the other side.
And then only there are two very small issues like.
Yes.
Very well. Let them say. I will rejoin them. I will rejoin.
Don't disclose your issues unless they point to. Yes, Mr. Rai.
I turn to page 123. It starts on page 120, my lord, and the relevant portion, my lord, and lordship page 123.
What is this?
The Supreme Court, my lord, this order was passed on the basis of our application. There is announcement. They also filed application for apportionment. That is why, my lord,
They?
Yes.
The others?
Others.
Oh, acha, they had filed it.
Yes. Considering that, my lord. Paragraph 6 onwards, my lord, paragraph 6 and 7 I'm reading. Thus filed, Naveen Kumar Anchal is seeking clarification just as the apportionment of the amount as awarded by the arbitrator in such and such has been filed by Narendra Kumar Anchal, one of the original respondents seeking direction for release of 50% of the award amount in respect of dispute regarding apportionment in terms of the previous decision issued by this court. The learned counsel for the parties do not dispute that their interested dispute regarding apportionment in terms of the earlier order passed by this court is subject to the reference court. In view of this matter, we dispose of this miscellaneous application as well as the following with the following directions. The reference court is directed to release 25% of the deposited amount in favor of the original respondents. That is us. Within 1 week. This release shall be subject to furnishing and undertaking on the affidavit that after the adjudication of the apportionment title suit, the excess amount, if any, shall be refunded along with interest as may be determined by the court. Such entry shall be furnished before the reference court. It's called directed to keep the balance amount in fixed deposit in a nationalized bank, which will face the maximum rate of interest. So there is one of the specific application was made. It was held. The reference court should consider the same and 25% is directed to release. Yes, we have already furnished and amount was released in terms of this because they have
this amount, if any, shall be refunded means
if it appears after apportionment manner considering the partition suit, it cannot be
that
gone
whatever was your due, you have received excess over.
If ultimately found it is in excess, which have been disbursed,
so refund to whom?
To the person interested who will get the apportionment. Consider
that will not be a refund. Refund means you give it back to the reference court.
Yes. I have to refund the reference court.
Very well. So that already furnishes protection, you were saying.
Yes, we have furnished this protection and amount has been released. The same application was filed before.
File an undertaking.
Yes, and amount has also been released. Now, consider this.
Second reference. Oh, so that is regarding the other part. Only one affects all of you.
Now, the same prayer was made before the executing court before.
Give a copy to them also.
Yes.
Still, no, it's annexed somewhere here probably.
No, it is not there.
There are several orders here.
No, this is earlier order. It is 14th July 2026.
No, earlier order passed
in this proceedings.
It's not annexed anywhere here in the application.
No, it is after the.
After what?
This application is filed. It is not in annexed.
All right.
The order dated 10 July 26 passed by
the parties here. They were parties.
Same parties. In this case number such and such is under challenge at the instance of respondent number 7 to 9 in the
petitioners.
No, they are the petitioners.
This was against what? Give us a background.
This is a miscellaneous case has been filed for the purpose of 34 prosecution. In the reference court, it is a registered bis case because it is a proceedings initiated by the in terms of the Honorable Supreme Court direction. This section 34 was constituted to be a court of reference, and such was proceedings initiated as the bis case number 97 of 2024. There they filed an application restraining us from withdrawing that amount.
It was an arbitral proceeding.
It was initially arbitrator was appointed for the purpose of enhancement, deciding the quantum. Then it was held that arbitration has been conducted, initiated. So 34 will be considered to be the reference court in terms of this Supreme Court judgment. Always
Supreme Court has appointed the arbitrator only for the special purpose of the award.
And also 34 to be converted
and
to a reference
recorded
court.
In the order.
It is recorded.
So 34 court becomes a reference court.
Yes. As per the direction of the Honorable Apex Court.
There they filed an application.
Now, they filed an application. And considering the other way, whether the reference court, once the property is acquired,
two different provisions entirely.
Once property is acquired.
May I clarify? I will before the Supreme Court. May I clarify?
You are the culprit.
No,
not the culprit.
No, I am not the culprit.
are the tests applicable in section 34 applicable in section in a reference under section 18?
Milord, what happened is this.
We were wondering whether we have forgotten the law section 34 and 18. We are confusing. We are wondering that now we see 96 Act.
Can I indicate, Milord, your lordship will find that in the initial order, the initial order at page 107 of the Supreme Court.
Let us not get more confused.
Yes, they filed an application for restraining us from withdrawing that amount in terms of the Supreme Court Honorable Appeals Court judgment. That was turned down. Challenging that, they came before this Honorable Court.
So they preferred a revisional application
against the order passed in the miscase
in the section 34 proceeding.
Yes.
Under which provision?
Under 227, my lord. My lord, 34, my lord, Calcutta, I am not on that. And it turned to internal page 2, last paragraph. Thereafter, the opposite party number 427, my lord, got it.
Yes. Got the page.
25% of
the idea. Yes. Approach reference code.
Reference code for release of the 25% deposit amount as per the decision passed by the Honorable Supreme Court in the order dated 15 June 2026. Such appears to dispose of by learned district judge with the order impugned. Such and such appearing for the petitioner submits that the petitioner are entitled to share in the compensation amount. He submits that such issue ought to have been decided by the reference court within the time limit specified by the Honorable Supreme Court by the order dated such as he submits that the 3 weeks time is stipulated in the said order, but even after lapse of such period, the dispute as to the apportionment has not been decided till date. Such and such appearing for the opposite party as the impugned order direction was passed to disburse 25% of the deposit amount to the opposite party number 427 herein, but no steps has been taken to release the said amount in favor of the said opposite party till date. After going through the order dated such finds that the Honorable Supreme Court directed the reference court to release 25% deposit amount in favor of the original respondents, including Narendra Kumar Anchalia, within 1 week. It also made clear that such release shall be subject to furnishing an undertaking on affidavit that after adjudication of the apportionment of the title suit, the excess amount, if any, shall be refunded along with the interest as may be determined by this court, and such undertaking shall be furnished before the reference court. The reference court was directed to decide the interstate apportionment title dispute between the parties as early as possible, probably within 3 weeks. Now, my lord, this was the and ultimately it was held, my lord, kindly consider internal page 5, the first paragraph. It is, however, made clear that this court has not interfered with the direction passed by the reference court upon head account and district judge court should to disburse the amount to the original respondent as indicated in the order impugned. Now, my lord, after this application, my lord, this order was passed, they filed an application of partition suit.
No.
No.
Simultaneous relief. In this case, they have filed this application, restraining from disbursement, and they also in a partition suit say they ask for securing that amount.
The application was filed, Milord, on 4th of July, if your lordship can see, Milord. This order was passed on 14th of July.
So partition suit application was first.
Partition suit application was first. We said that the money is released pursuant to the Supreme Court's order. This money can be siphoned off in view of the antecedent of the parties that they have sold off family properties in the past. So in apprehension of that, we filed that in the partition suit.
Now, considering the every aspects of the matter, my lord, there is a direction. And
Mr. Rai, only one thing. We appreciate that you have given an undertaking that you will refund. But there should be something to back up that undertaking. Your undertaking, how will we ensure that if you fail to?
No, it is the Honorable Appeals, so they should kindly consider that aspect. Just directed specifically that subject to satisfaction. In presence of all the parties, they have accepted. They participated in the reference proceedings, considering the same. That clause, they did not back up and say, no, we are not accepting, there's something else.
That was the apex court was approached in the context of your
apportionment. Apportionment, same thing.
Apportionment, no, not same thing. Apportionment is something else. Apportionment of the amount, yes, we can appreciate that. That's within the paradigm of section 18 reference. But in a partition suit, pardon?
Section 30. 18 is for enhancements. 30.
But here, a partition suit, parties are claiming title to that corpus of money.
Yes, well, even if that is why can you consider section 30.
Title suit is somewhat, it's like a title suit. Title suit is somewhat different from apportionment. Yes, we appreciate that. But here, ultimately, if that Supreme Court order does not debar or operate as a res judicata in the partition.
No,
in a partition suit, my lord.
The Supreme Court sitting in appeal over a Section 30 proceeding or a Section 34 proceeding was not quote unquote competent to pass a decree of partition.
No, it is not.
Therefore, this does not, the res judicata principle does not apply.
It is, my lord, section.
That proceeding, none of the courts in that proceeding, the entire line up to the top was competent, so-called, to pass a decree in a partition suit. So therefore, res judicata principle does not apply. In partition suit, they are independently asking for securing that amount.
Yes, ma'am.
What is the security, Mr. Rai, if your client tomorrow siphons off and fails the undertaking, then he'll suffer the wrath of Supreme Court, maybe suffer contempt. But that amount won't be secured.
No, my
Put in something.
Consider here, my lord, the partition suit I am taking.
Put it in an account. Why utilize it? I mean, put it in an account and let us.
Well, it is the litigation which is fighting by us. We are claiming we are the only person who is fighting the litigation. This I am not disputing whatever.
Apportionment is pending.
That is what Malad Kali consider.
Partition suit. Partition suit.
Whether the partition suit in a government property involved, can be termed to a partition suit. Malad Kali consider it that way.
Government property after.
It is after acquisition.
Partition was initiated after acquisition. Partition
yes. Then whether this property can be considered to be a partition suit. Only scope depends under section 30. That is why the apportionment. There is no other option. In a suit for partition, you cannot ask for portable of that property. It is the government who is
getting the money.
That is why apportionment, my lord.
No.
Our
case is today, suppose we have among ourselves only a joint corpus of money.
Yes.
Something liquid.
So this
can I not file a partition suit? Let us just test the principle. Can we not file a partition suit? Suppose there is no immovable property, only the corpus of money.
Yes.
Can't we today file a partition suit for distribution of that only, claiming our share in that property? Partition in the strictest sense, no, maybe. But still, can't we ask for distribution of that money itself?
Yes, that is why section 30, my lord. There is a specific provision.
Section 30 is
for apportionment.
Yes.
Only provision laid down, my lord, Kali consider whether we are still a party, co-sharer or not. My lord is thinking that way that we are the partner common corpus upon which we are asking for division. It is not that. It is the apportionment is only the scope, my lord, for the, that is why the apportionment is there. And after
undertaking, Mr. Rai,
25 and 75% still remains with the. It is not that reference code is still it is holding the.
According to the partition suit, what would be your share? More than or less than 25%?
25%.
20%.
We are claiming to be the exclusive owner, taking to their case to be the hilt. Yes. Then what?
Partition suit gone.
Gone. 25% we are also entitled to at least 25%.
No. May I factually clarify, my lord? For lordship, my lord. Yes. My lord, so far as this DAG number is concerned, it was 54 decimals. 20 decimals was acquired by the state. This money is in lieu of that. 34 decimals admittedly was disposed of by them in a court execution. So our case is that
even disposed of by them in a court execution means they failed a loan and this was sold in a court auction.
They suffered a decree. Yes,
that is what we are saying. Suffered a decree, money decree. Yes.
Yes, they said it is our property. So the executing court said, okay, you are selling it off.
So you have brought that within the hotspot also.
Yes. But may I say this? Yes, of course.
Because the court sale also could not transfer more than their share.
Yes, that is what the order is there, page 162.
So therefore, there is an immovable property which is beyond the purview of this acquisition, as well as this money which relates to
money, which in our submission is a substitution of that part of the property.
Very well. Mr. Chatterjee, what is your answer to this? Insofar as the compensation for acquisition is concerned, the governing law is covered by section 30 or in case of a reference here apportionment, so section 30. So doesn't that operate on a collateral footing as your present prayer, because ultimately it boils down to a money claim regarding the rest of the corpus of money than their share. So if there is an order arising out of a section 30 proceeding, doesn't it create a semblance of a res judicata sort of scenario?
It will not. May I just answer? Milord, so far as this part is concerned, section 30, which is now section 76 of the 2013 Act.
2013 Act is applicable? No.
Yes, the Supreme Court had held 2013 Act is applicable.
Valuation, for the purpose of valuation, acquisition started there.
No. Anyway, very well.
Yes, I'll just clarify this. But so far as apportionment part of that compensation is concerned, the father had 5 sons, so it will be 20% each. There is no doubt about that. But the fact, Millard, is that in the partition suit, the facts also include the sum of the family properties were disposed of by them, so they have to account for it. So today the
No, that
situation
that
is
we,
the
we that
property is
at
gone.
this stage, Mr. Chatterjee, we cannot bring that into this. We cannot confuse the two. This only pertains to this figure only pertains to that acquisition compensation. So we cannot. We have to segregate the two. I mean, if you have a claim regarding that sold out property, that will be canvassed in the suit. You may have a more
But
a larger claim.
it's the same property, Millard. It's the same
Maybe.
property which they sold off. 34 was sold off, 20 was acquired.
No, now we are dealing with. You have not asked for a. I mean, money decree as such in that regard.
No, I have not filed for a money decree. What we have done, Millard, is
We
that
cannot. I mean, interdict their money corpus on the ground that you have asked for title regarding a sold out property. They might have acquired some.
I have not for a title. Millard, there are
We
private.
cannot confuse the two in the sense that we cannot say that since they had sold out some property and that property you also had title in that property, that is a different relief. We cannot confuse that with this corpus of this acquisition compensation. As far as acquisition compensation is concerned, they have only withdrawn within their share as per your plaintiff case also. First, secondly, they have given an undertaking also. 25%.
25% is would not be their share. Number one, it would be 20% otherwise.
Achha.
Now, Millard, our case is if this money that is received by them, our case is if this money is not secured, when there is a decree passed and it comes to Millard apportionment of the entire family property, then there will be nothing left for the rest of the family.
Aren't
We are saying
you already
that
protected? Aren't you already protected by this order of the Supreme Court that they have given an undertaking?
Millard, that undertaking tomorrow, if it is breached, I have no protection. I do not want this money. I am only saying let this money be protected. Whatever is the outcome of the partition suit, that may be expedited.
No, but the difficulty is, Mr. Chatterjee, your clients were also a party to the apportionment proceedings, and your clients were also there in the Supreme Court.
No, but it's two things.
So in your presence, this order was passed, and that relates to the same corpus of money, the compensation acquisition.
Same corpus.
You did not raise a demand to that. You are bound by that order also.
But I am bound by that order. But I am bound by that order.
Aren't we directing them to then put in double security for the same money?
No.
The undertaking as well. You considered to that order.
Yes. But may I say this? But I distinguish this between the two facts. The distinction is this. So far as this order is, I am saying that if the money is released, it is post compliance of the Supreme Court order. When the money comes to the hand, it comes to one of the parties to the suit. That we want to be Millard secured. There is no clash between these two. That's all I am saying.
At the best, then your claim can be for securing 5% out of the amount, even if you say that they have 20% share. Because if they have 20% share according to you, we cannot confuse it and mingle this up with a sale of the other property. Let us be clear on that.
Ultimately, everything goes down to the family corpus.
Maybe, but even if you get a decree, you cannot get a money decree in respect of the property sold out by them. Have you asked for damages also?
Both belong to the corpus. This happened subsequently.
No, corpus is not a victim.
Page 36.
Regarding the 34 decimals.
Yes.
You have not asked for any damages. Nor have you asked for any compensation in that regard.
Not challenged.
May I say this? I'll just explain that. Lordship will kindly come to page 162 for a moment. When we intervened in the execution proceedings, it was before this honorable court in the original side.
Oh, you intervened there also then?
Yes. One of the parties, my client did not, Mr. Ali's client did.
Yes, then?
It said, Millard, pursuant to the said order of the property, kindly come to page 162, Millard, at the bottom.
Yes.
Fact remains that this property was offered for sale by the judgment debtor, claiming that these properties are not encumbered and is an absolute property of the judgment debtor instead of another property which was attached by this court. Pursuant to the said offer, the property was sold and some strangers had coming to claim interest in the said property. By reason of a partition suit already pending, the rights of the parties may be decided in the said suit, and that entire property has not been sold, only a part of it has been sold. The rights of the other co-sharers, if there be any, may be satisfied from the rest of the properties unsold. And then, if your lordship come to next page, 164, fourth line from the top, this order is passed without prejudice to the rights and contentions of the parties and subject to the result of the SLP pending before the apex court and further orders that may be passed by this court as to the rights of the strangers or alleged co-sharers involved in the alleged partition suit. So therefore, my relief with regard to the property sold, that remains preserved for the partition suit.
Acquit. Now I can turn to page 34. What is the plaint? What is the pleadings? Can you turn to page 36? What is the plaint?
যেটা বলছে সেটা কিন্তু ইন্ডিপেন্ডেন্ট হচ্ছে যে সুপ্রিম কোর্টের যেটা সেটা অ্যাটলিস্ট কি হবে কন্টেম্প্ট হবে, যদি আন্ডারটেকিং ফেল করে কন্টেম্প্ট হবে, জেলে যাবে, হতেও। কিন্তু ওইটাতে যদি এই পার্টি ছিল সব ঠিক আছে, ও মানে হচ্ছে ইন্ডিপেন্ডেন্টলি এই অর্ডারটার এক্সিকিউশন কেসে যেখানে ইন্টারভিউ করেছে সেই অর্ডারে, কিন্তু এই অর্ডারটা দিয়ে তো ডিপেন্ড ওখানেও পার্টি ছিল প্লাস সুটে ওর কোনটা অ্যাডজাস্টমেন্ট চাওয়া নেই। Let us come to your plaint relief.
Page 36.
Yes. Plaint, the relief your lordship will find at page 40.
Filed in the year 2022. An initial order passed in 2001. Whether any sort of amendment regarding this sale in the plaint, nothing.
That part, before my learned friend confuses your lordship, I will clarify there was a partition suit in 2000.
No, it's a question of who confuses first.
I will be very truthfully saying, Milord, that in 2001 there was a partition suit pending that was subsequently dismissed for default, and thereafter the 2022 partition suit was instituted. So nothing happened, no partition took place in the meantime, it remains a joint property. So that's my respectful submission on this. Now, if your lordship comes to page 40, my relief in the suit is there. Preliminary decree for A, B, and C. This is the C property.
No prayer of the nature of adjustment with that amount or something.
No, because it did not, because these orders of this honorable court was passed in 2023, Supreme Court's order in 2024, and thereafter this other order 15th June of 2026.
But the acquisition had taken the sale of the property took place before that.
2001.
Sale of the property took place in 2001.
When you filed this suit,
yes,
you were aware of the fact that there was already a sale by them regarding that 34 decimals.
Yes.
But in the suit itself, you have not made any claim for adjustment like that executing court in the other suit observed. You had no prayer to that effect, that this will be adjusted with that or the rest of the corpus or something like that.
Plaint is on record, Milord, I cannot contradict that.
No, we appreciate that, Mr. Chatterjee. You cannot improve your case, definitely. But what we try to say is that today before us, we have two paradigms. One is that section 76 or 30, whatever you say, that reference paradigm, apportionment paradigm, where an order has been passed by the Supreme Court, which relates to the same corpus of money.
Yes.
Compensation, acquisition compensation. Here also in the partition suit, that is also one of the subject matters, definitely. But there we do not find any claim of adjustment of that amount in lieu of the property sold by them. So if that be so, that's why we are saying we have to go by the plaint of the partition suit, right? So there we don't find anything to mix up the two. So we have to proceed on the independent premise that this compensation, acquisition compensation corpus is a different amount. Now regarding that, in your presence, your prayer for apportionment is quite the same as what you are asking for in the partition suit, insofar as that amount is concerned. Apportionment and partition are same insofar as money is concerned. So therefore, if there is already an order of the Supreme Court, you are a party there, in your presence it was passed, wouldn't that be a modification of the Supreme Court's order in an oblique sense?
try to clarify two things.
Yes,
First,
yes.
my lord, there is no adjustment prayer in the plaint, no doubt about that. However, my respectful submission is, since the property is described in Schedule C, which is a part of the claim A, then that may be taken in the larger context.
A is which property? That 34 decimal?
No, 34 decimal is C. The entire property is 54 decimals. Lordship will find page 41. 41 has Schedule A, 40 at the bottom has Schedule B, and then Schedule C.
The area is said to be 64 shoto, 0.64 shoto. That is 64 decimals.
54. It will be 5.
So page 41 at the end.
Typographical error, it is 54.
54, all right.
It's 54.
All at 54. And A is which one? The one sold?
Different properties, Milad. These are different properties.
So what about the portion sold by them? It's not there in this.
Sold by them is not the admitted case is sold by them in C. Out of 54, 20 was acquired by state. Rest of the 34 was sold by them.
Very good.
This is one. Second, Milord, so far as the Supreme Court order is concerned, that was not, Milord, in my respectful submission, a determination of how much they are entitled to. That was an ad hoc release against an undertaking that it would be refunded if found to be in excess. Our respectful submission is, we have evidence to submit before your lordship that in view of whatever they had sold or whatever was sold at their instance, if that is accounted for, then they would be entitled to nothing.
But Mr. Chatterjee, apportionment is on the basis of your entitlement to the sum only. Apportionment, the only test is what title you have, what share of property do you have. That is the only premise of apportionment. So you cannot say that the apportionment order does not touch your title or your entitlement regarding that share in the money. Apportionment is precisely entitlement to your share in a particular share of the money, which is also the subject matter in the partition suit vis-a-vis that portion. So it's a same cause of action which you are reagitating.
But that is exactly why we are before lordship, because ultimately if the father had 5 sons, the apportionment will be 1/5 each or 20% each. That freezed, the screen was freezed, Milord.
Yes. So in the meantime, you have said what we had to.
I will say that, Milord. What I'm saying, Milord, is that so far as the apportionment part is concerned, the father had 5 sons, so it would be 20% each.
We are sick and tired of father having 5 sons.
Yes. Now, Milord, it has to be accounted for in the partition suit where the larger property is considered. That is why, Milord, we have come before your lordship in the partition suit. Because this is where the accounting has to be done.
What else is partition of a monetary amount than apportionment?
Milord, that would be a partition before, but for the reference code, it would be beyond that 20 decimals.
Reference code also decides your title to the apportionment application. What is done by the reference code is deciding your title to the share. I mean, deciding your share in the corpus. So that is precisely what is being done in the partition suit also.
The partition suit ultimately, Milord, is prior. Now, so far as the reference code is concerned, they will only be concerned about these 20 decimals which were acquired by the state. But the property is a larger property otherwise, which is a part of the partition suit. If anything has been wrong, anything wrong has been done by them with regard to the rest of the property, it has to be accounted for there. That is why we are before your lordship in this proceedings.
We find, Mr. Chatterjee, sufficient protection to have been given by you by the Supreme Court. It may not be sufficient in our perception. We agree with you. Your and our perception, maybe the security itself is not a sufficient security. Even if you have that perception, in your presence and in your, an order has been passed which is binding on you, where a similar exercise was conducted up to the Supreme Court and an order has been passed securing the amount in whatever sense the Supreme Court deemed fit. We cannot reopen that.
I would say, Milord, my respectful submission is that I will leave it to your lordship's wisdom, Milord.
Yes.
It's that it was not our application. It was their application.
No, your parties there. Your parties.
Yes. I was present there.
Apportionment was your application. Apportionment?
My lord,
What apportionment?
yes, in 2024, my lord, I filed for an
So
apportionment.
that matter rose out of that apportionment application only. Ultimately went up there.
Separate miscellaneous applications in the SLP.
No, Mr. Chatterjee, sorry.
Lordship, only
Yes, Mr.
without
Ali.
Lordship repeating, Lordship.
Father had 5 sons, we know that.
Because there are two proceedings.
Yes.
One is that miscase where the apportionment proceeding is going on, another is the partition. Lordship, 10 crores odd is the awarded sum. We admit that father has 5 sons, so 20% is admittedly their claim. So 25%, 25%.
You are saying that Mr. Chatterjee said that you claim they have 20% and they say they have 25%.
No. There are entirety. They are saying that entirety is theirs, and they are approached the Honorable Supreme Court to release 25%.
We have heard this.
Lordship.
Yes.
The point is, my lord.
Now we are on
the
the verge
Honorable
of
Supreme
deciding.
Court has said that 25%, and there would be an
Yes, we have seen
undertaking given. Lordship. So I say that since admittedly 20% which they are entitled to, so Honorable Supreme Court security at best protects me for 5%, which is also, Lordship, I have to file contempt proceedings and everything, which is not enough security.
If you win the suit, Mr. Ali,
Lordship?
Not at this stage. If you win the suit and your 25%, their share is declared to be 25%.
But my lord, Honorable Supreme Court also directed that apportionment be also be decided by the. So I don't have to wait for the suit.
Yes.
With respect to 20%, my lord, which they are entitled to, I say that 20% they are supposed to, since they have sold 34 decimals of the joint property.
That he has argued already.
Lordship, that is why, Lordship, they have to put it to a till of the joint family hotspot. That is. So
Acha,
the
you are
Supreme Court order is
respondent
not
numbers?
interfering with.
Your respondent numbers?
3 to 5.
The present challenge has been preferred
3
against.
to 6, my lord.
The present challenge has been preferred against the deemed refusal of ad interim prayer of injunction passed in a suit for partition filed by the appellant. So, next para, learned counsel appearing for the appellant contends that the learned trial judge, comma, while passing the impugned order, comma, did not advert to the pleadings in the injunction application and or the written objection. Written objection was filed by them. Oh, achha.
No, subsequently filed.
Sorry. Did not advert to the application. Please, averments made in the injunction application and or the materials in support thereof, and merely adjourn the matter on a different date to a different date. Push up next para. On merits, comma, learned counsel argues that in the suit for partition, comma, it has been claimed that the defendant numbers 3 to 6 are have around 20% share in the total property. Pushed up, the plaintiff stroke appellant alleges that in a money decree which the defendant numbers 3 to 6 suffered, comma, they gave out that 34 decimals out of the total 54 decimals joint property, which is the subject matter of the partition suit, comma, were next para. In view of such conduct of the respondent numbers 3 to 6, comma, it is argued that when the same respondents, that is the respondent numbers 3 to 6, comma, claimed exclusive right to the compensation amount awarded for the acquisition of the balance 20 decimals of the suit property, comma, that the said respondents would not usurp the entire money, comma, by defeating the shares of the appellant, plaintiff appellant, and the other defendants to respondents therein. Full stop. Next para, it is pointed out that there is a parallel, that in a parallel proceeding, for apportionment of the compensation amount, comma, where the appellant is also a party, comma, orders were passed which ultimately went up to the Honorable Supreme Court, full stop. The Honorable Supreme Court, comma, in connection with an application in respect of the said matter, comma, categorically observed that 25% of the amount deposited with the reference court out of the said compensation amount would be released in favor of the respondent numbers 3 to 6 within 1 week, comma, which would be subject to Narendra Kumar Anchalia, comma, one of the said respondents, comma, furnishing an undertaking on affidavit that after the adjudication of the apportionment stroke title suit, comma, the excess amount, comma, if any, comma, shall be refunded along with that there is every possibility that they will misappropriate the entire 25%. They might misappropriate the entire 25%, comma, which is beyond their share in the suit property in the partition suit, comma, leaving no remedy for the appellant and the other defendants stroke respondents to uh, get back the said amount. Full stop. Next para. As such, comma, it is argued that the paradigms of the apportionment proceeding being different from the partition suit, comma, sufficient security ought to be furnished by the respondent numbers 3 to 6 in respect of the said amount of 25% of the compensation which has been released in their favor, comma, as all the co-sharers have equal rights thereto. Full stop. Next para. Learned counsel further argues that the claim of the appellant and the other defendants than the defendants stroke respondent numbers 3 to 6 cannot be restricted only to the compensation amount for the 20 decimals land, comma, since it also has to be taken into account that 34 decimals, comma, belonging to all the co-sharers, comma, were exclusively utilized by the said respondents for meeting their decretal dues. Full stop. Thus, comma, it is argued that the claim of the other co-sharers than the respondent number 6 would be much more than mere 25% of the compensation amount. Full stop. As such, comma, it is argued that the amount ought to have been secured or directed to have been deposited in an account which would be frozen for the moment, at least insofar as the respondent numbers 3 to 6 are concerned. So next para, learned counsel next para, অ্যাপিলটা অ্যাডমিট করার কথা কি বলেছে কিছু আলাদা করে বলেনি। In view of such arguable questions having been raised, comma, we admit the appeal to be heard on the above questions and the other grounds taken in the memorandum and take up the same for final hearing in view of the issues involved in the appeal and the stay application being identical. For the next para, learned counsel appearing for the respondent numbers 3 to 6 controverts the allegations of the appellants and submits that as per the said respondents, comma, they are exclusively entitled to the compensation amount released in respect of the 20 decimals of land in question. Full stop. Moreover, comma, it is the said respondents who took initiative for obtaining the compensation in the first place. Full stop. Next para, that apart, comma, this court would be that apart, comma, in the event the prayer as sought by the appellant is granted, comma, the suit taking up the court taking up the partition suit and stroke or this court would be tinkering with the order of the Honorable Supreme Court, comma, where all the parties, including the appellant, were uh, impleted. Full stop. Next para. Apart from the appellant and the other respondents being bound by the said order of the Supreme Court, comma, which has sufficiently taken care of the security in respect of the 25% disbursed in favor of the respondent numbers 3 to 6, comma, the parties are also bound by the said order and cannot go beyond the same in the pretext of obtaining an order in the partition suit. Full stop. Next para. After a careful consideration of the arguments of the parties, comma, we cannot overlook certain cardinal aspects of the same. Full stop. Next para. First, comma, although the appellant and the other respondents, comma, who substantially support the appellant apostrophe s contentions, comma, claim that the demand that the entitlement of the other parties to the partition suit than the respondent numbers 3 to 6 is much more than the compensation amount received in respect of the 20 decimal land, comma, in view of the respondent numbers 3 to 6 having alienated 34 decimals out of the joint corpus of the family property, comma, we do not find any such prayer within the four corners of the plaint. Full stop. The claim in the reliefs sought in the suit are simpliciter with regard to partition of the properties. Full stop. Next para. Thus, comma, although a partition decree implicitly includes declaration of the shares of the parties to the subject property, comma, in the absence of any adjustment being sought or any money claim stroke damages stroke compensation being made with regard to the 34 decimals of property which has already been allegedly sold by the respondent numbers 3 to 6 unlawfully, comma, being apportioned or adjusted, comma, there is no scope of mixing up such transfer which can be translated to a money claim. Full stop. Next para. Thus, comma, the paradigm of the acquisition compensation is entirely different, comma, vis-a-vis the partition suit between the parties, comma, from the entitlement, comma, if any of the plaintiff and the other defendants in the 34 decimals sold out under the impression that the same exclusively belong to the respondent numbers 3 to 6. Full stop. Next para. Secondly, comma, we find from the order of the Honorable Supreme Court that all parties to the present partition suit were substantially represented therein. Full stop. The matter went up to the apex court from claims of apportionment made by the plaintiff stroke appellant and the other co-sharers. Full stop. Apportionment in respect of a monetary sum is equivalent to declaration of the shares of the applicants in the same. Full stop. No distinction can be drawn between a partition suit and an apportionment proceeding in respect of compensation, comma, insofar as a money claim is concerned. Full stop. Next para. Thus, comma, the scope of operation of the order passed by the Honorable Supreme Court in connection with the apportionment proceeding cannot be qualitatively distinguished from the claim with regard to the corpus of such money in the partition suit. Full stop. Next para. Thus, comma, the parties are squarely bound by the order of the Supreme Court and the arrangement made therein in respect of the compensation amount, comma, 25% out of which has been released in favor of the respondent numbers 3 to 6, comma, subject to an undertaking being furnished by one of them. Full stop. Next para. Since the said order has attained finality, comma, it binds all parties, comma, including the appellant and the other respondents than the respondent numbers 3 to 6, and it would evidently be modifying the same order if any further rider is added to the same. Full stop. Next para. While observing so, comma, we also take note of the fact that in clause small I within bracket of paragraph 7 of the said order, comma, the Honorable Supreme Court consciously observed that the release shall be subject to Narendra Kumar Anchalia, comma, one of the which respondent? Narendra?
Three.
Bracketed respondent number 3, bracket closed, furnishing an undertaking on affidavit that তারপরটা আইটা লিখতে হবে after the adjudication of the apportionment stroke title suit, comma, italic শেষ, the excess amount, comma, if any, comma, shall be refunded along with interest as may be determined by the court. Full stop. Next para. Although such undertaking was directed to be furnished before the reference court, comma, while observing so, comma, the Honorable Supreme Court took into account both the adjudication pending in the apportionment proceeding and the title suit pending between the parties. Full stop. Thus, comma, the self-same chapter cannot be reopened in an interlocutory application filed in the injunction in the partition suit afresh. Full stop. Thus, comma, we are of the prima facie opinion that the plaintiff stroke appellant was not entitled to any further protection than granted by the Honorable Supreme Court as discussed above, vis-a-vis the compensation amount, vis-a-vis 25% of the compensation amount which was disbursed in favor of the respondent numbers 3 to 6. Full stop. Next para. Hence, comma, no interference with the impugned order is called for. Accordingly, FMAT 245 of 2026 is dismissed on contest, thereby affirming the impugned order bearing order number 46 dated July 4, 2026, passed by the learned civil judge senior division at Siuri, Birbhum in title suit number 128 of 2022, insofar as the deemed refusal of the ad interim prayer for injunction of the plaintiff stroke appellant is concerned. Full stop. Next para. It is further clarified that this court has not entered into the merits of the matter insofar as the final hearing of the injunction application is concerned and or any further stage of the suit is concerned, and the above observations are only tentative in nature, comma, confined to the ad interim stage of the injunction application. Full stop. It will be open to the learned trial judge to decide the injunction application and the suit on their own merits without being unnecessarily influenced by any of the observations made above. Can 2 probably 1 can 1 of 2026 stands disposed of accordingly in the light of the above observations, no orders to cause urgency.
Only two indulgences, my lord. One, my lord, is liberty to amend.
But that order that was 3 to 6.
Only 3 to 5. It should be 3 to 5.
Because my advocate on record secured vokalatnama for 3 to 5 over here.
No, 3 to 5. 3 to 5. 3 to 6 were.
They are in the Supreme Court.
যেখানে বললাম কোথাও বলেছি যে লার্নার অ্যাডভোকেট অ্যাপিয়ারিং ফর দি রেসপন্ড নাম্বার 3 to 6 বলেছি, যেখানে অ্যাডভোকেটকে রেফার করছি সেখানে 3 to 5, বাকি সব যেখানে 3 to 6 বলেছি 3 to 6ই থাকবে, শুধু অ্যাডভোকেটটা যেখানে রেফার করছি 3 to 5 করে দিও, দরকার হলে বোল্ড করে দিও, পরে কাট করো। থ্যাংক ইউ।
Yes, the indulgence is liberty to amend the plaint also.
We won't grant liberty. You go and file that amendment application. It will be decided. Why observe? Make any observation?
Only other thing, Milord, since this is a lesser remedy than we have played in the plaint, and it's not completely out of place insofar as the plaint is concerned, whether your lordship could have granted us some protection.
No.
Very good. I am obliged.
You argued very well, Mr. Chatterjee, but we can't go beyond our perception of the law.
I am so grateful, Milord.
Thanks.
Grateful to you.